Court officer? Court officer? ಮೇಡಮ್ ನಾನು ಕೇಳ್ತಾ ಇದೆಯಾ ವಾಯ್ಸು?
ಕೇಳಿಸ್ತಿದೆ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಆಫೀನಲ್ಲಿ ಹೀಗೆ ಬೇಡ. ನೀವು ಟಿಫನ್ ಮಾಡಿದ್ರಾ? Fresh matter.
Total 20 million.
Hmm?
Total 28 fresh matter. GMFC.
Fresh matter regarding what?
GMFC.
I understood. What is the urgency?
The unbeatable issue.
Yes, tomorrow.
Your Lordship, photo number 20, GMFC matter is for regarding visitation, right? Order has been passed, inclusive of vacation. I'm getting only 2 Sundays per month, including vacation also, and that too for 6 hours only. That and now the petitioner wife, responding wife, is taking the kid away into Kerala for me. That is a urgency in this matter.
What is the order passed by this court?
From the trial court, the order has been passed regarding the visitation, right? That the
When was that?
3/3 for me.
Huh?
3/3/2025, 3rd March.
When did you file the petition?
Petition was like 17th for me, 17th.
Yes.
It may be
When there is
posted.
urgency, not at the back end of the vacation like this, all matters at an urgency.
Problem is, respondent wife is taking the kid away. 8 years daughter. I'm
Yes,
not,
day after tomorrow. Yes.
Seeking interim custody during vacation, GMFC.
When was it filed?
But it was filed 3 days back because the order was passed on 30th of March.
Yes, listed on Thursday. Yes. I'm not able to hear. Use the mic. I'm not able to hear. Use the mic.
Matter pertaining to the injunction order, fresh matter, I have filed it. Tomorrow I required matter of urgency in view of an injunction matter. Injunction is being rejected.
Which year is this matter?
Fresh matter, madam.
Fresh matter of what?
Yeah,
This is MFA.
last Saturday yes, filed.
What is the number? Look at that. What is the
FR number. MFA.
category?
Injunction.
MFA of which year?
As per roster, MFA e-court ge assign barutte. MFA, huh? GMCPC. CPC alla idu. Injunction it.
Injunction, why it is, he is not having the roster.
Ilig barodilva.
Yes, next.
Yavadu? Yav photo?
Insurance company appeal challenging the liability from the claimant.
Which year is that?
2015 old matter, 2012 accident. Till today, I'm not received
Yes,
any
yes.
amount. And
Yes. Yes.
Before the magistrate, but there was no liability on me.
Which year is that?
It is 2020.
No urgency for that. No urgency for that. Yes.
My lord,
No,
2020.
when the court is going this way, you cannot add here. Come this side. Yes. Yes.
Milord, quota number 2.
My lord,
Head.
FC matters, maintenance order is being
Huh?
challenged. Maintenance order will challenge.
When is it challenged?
My lords, in this month on 5th, my lords, there was office objection which we have complied, my lords. The maintenance
Yes.
has not been awarded, my
Give
lords.
accordingly as per the number of the cases. Just look at it and give the dates. Yes.
Milord, quota number 20 matter, a review petition has been filed. And,
Review, how can it be heard before this court?
Milord, there are some errors apparent face on.
No, that would be decided by that judge, not by this court.
The who has sought for stay because execution petition.
That also this court can't interfere. It has to be done by him because he's on leave.
No.
Review can't be heard by this court.
Interim order I am seeking.
Yes.
Your ladyship, your own order, but court hall number 20 matter, we are seeking intervention under order 21, rule 26, because we have applied before the Honorable Supreme Court. The threat is execution on 23rd with the police. That is what the father is.
How can you see that here?
The same,
So you have filed before the Honorable Apex Court, some order you have assigned, you have to move that application.
no, your order, your ladyship's order, we have impugned.
But
it.
there only you need the application. This court cannot entertain that.
No, till reasonable time till then, please.
No.
Because he has sought police intervention to take over the child.
That you should have gone before the court.
No, your
Yes.
ladyship, we have filed.
Application, you move the urgency before the Apex Court.
Your
This court
ladyship,
will not
we have
entertain.
already filed before the trial court.
Take steps to get it.
This is the challenge before the trial court, which is now before you. That's why
Trial
court,
court?
we have already filed before the trial court. The
You are asking the trial court not to take further steps till the SLP is heard.
reasonable time, stay of execution.
That was rejected?
Yes, that is why we are before you.
Take it.
Please.
Yes, next. Call the list.
Tomorrow, your ladyship,
Fresh matter, my lord.
ನಾಳೆ ಕೊಡ್ತೀರಾ?
Fresh matter, my lord. MSA. The matter has been remanded, my lord. The matter is on 25th, my lord. We're challenging the remand. Kindly have it tomorrow, my lord.
No, tomorrow. We'll see according, poll list is matter on second.
Reason is this fraud, my lord.
Hmm?
Holy
Domestic violence case on the petitioner.
So what to do?
Have challenged that, my lord, challenge the order.
Which is, what is that? No. What is that petition? Yes.
Court on 20 matter, my lord. The trial court has already issued an attachment warrant, my lord. So kindly take this.
Which year is that writ petition?
25, my lord.
When was it filed?
My lord, like 2 weeks back we filed this.
Fresh matter?
This for hearing on IA, my lord.
Huh?
Hearing on IA.
No, it's coming up it has to come up for the first time.
Yes, my lord.
Yes, sir, give some date. Yes. Call the list.
Page wise adjournment, list 1. Page number 6, serial number 1819.
Don't call for the adjournments, don't waste it. Call the list.
One submission, my lord.
Page number 1.
In list number 2, serial number 17, my appeal is also pending, my lord. It's to be posted along with.
List number?
List number 2, serial number 17, my lord.
Serial number?
17. Shivande Gowda has filed this appeal. My appeal is also there. It's to be posted along with, my lord.
List along with so and so.
4556 of 20.
After vacation.
What?
Give that slip. to the-
My lord, my lord, list number 2, my lord. List number 2, serial number 61. My appeal is not posted. 4503/22, my lord. Serial number 61, second list.
No, all these matters for the disposal for the Lok Adalat. If your matter is, if there is another appeal not listed, they will tell that we will adjourn. Why time waste for that, all adjournments? Yes,
Page.
no mentionings on list 2 or 3.
List 1.
Yes,
IA order, serial number 1.
Please.
Arjun Rao.
I had assured my lords, the court was indulgent. I'll wrap up within my lords 17 minutes. Very briefly. I was to, my lord, the court had posed a question and I was to argue on IA1 as to how, my lords, for a claim against a time charter or a disponent owner, the vessel cannot be arrested. I proposed to, I had indicated that this issue is covered. My lords, stand by it. Very quickly, my lords, before I trouble the court, may I invite my lords' attention to, before I take my lords to a document, one fact my friend had conceded, and my lords, in any event, irrespective of the concession, the fact that I had taken the court through the entire petition to show that their claim is against respondent number 3 and not against the owner of respondent number 1 vessel.
what is the judgment you're relying?
I was to show a document, my lords, and then take my lords straight to the judgment. But before I trouble the court, my lords, first may I invite my lords' attention to an additional affidavit filed, my lords, by respondent by the applicant, or my lords, the owners of respondent number 1 vessel. Affidavit dated 27th of March 25. It's an additional affidavit.
Page number?
My lords, page number 6 of the additional affidavit.
Oh, that is the amendment petition.
No. Additional affidavit filed in IA1. I think it's IA1 of 2025. An additional affidavit was filed on, it's dated 27th of March 2025. Yes. These things will now, my lords, possibly in my respectful submission, streamline.
1 minute. This is IA number
1.
1 of 2025 dated 16/4/2025.
That's correct. In that, I filed an additional affidavit. And in that additional affidavit, the first annexure, which is at page 6.
Page 6.
This will make clear, this document will make clear what is the status of respondent number 3.
Please read.
Yes, my lord, it is a document called as time charter. At page
number
6, madam.
Page number 6. The affidavit itself.
No, my lord, I am talking about an additional affidavit filed.
You said it is 16/4/2025.
My lord, that's the IA number. I am talking about an additional affidavit filed in IA number 1. If not, my lords, I can tender a copy, hand over a copy again.
1 minute, 1 minute.
It's a part of the record. Okay. 27th March is the date of that document.
27th
March is the date of the affidavit.
1 minute. No, the date is 4/4/2025.
No. An additional affidavit, which is filed, my lords, in IA1.
After 25/2/2025, the other documents, they are from 4/4/2025.
There was a reply. I don't have the date of the reply. Ma'am, may I just tender this? It was tendered. The other side is served. Madam. But they were served in March itself on the same day. If my lord comes to
look at it from this.
Huh?
Yes.
Your lordship may be correct on 4th. It may be that may be the date because it was affirmed, notarized on 27th.
Yes, I think that is the one. Look at it. Oh. Page number?
Page number 6, if I may invite my lord's attention to. Your lordships will find a document called as time charter.
Yes.
Now please see, my lords, in line number 1, this time charter is executed between whom? This charter may be concluded at Hamburg, 6th day of January 2023.
Keep all that orange color flags. Yes, for this. Yes, it says time charter.
Yes, and my lords, line 1, this charter party may be concluded, this charter party made and concluded in Hamburg, 6th January 2023 between. Now please see the name. First is CS Flourish Limited. This is the owner of, my lords, respondent number 1 vessel, admittedly.
No, there is no dispute on that as far as agreement.
I am now on the second aspect. This is owner of the steamer motor ship CS Flourish. See the description so and so, and please see line number 12 and Continental Dry Bulk Limited. Line number 12. Lines are, my lords, on the left side. So this was between the owner and respondent number 3.
Yes.
Now under this, my lords, the respondent number 3, this document will demonstrate, was the time charterer of the vessel, not the owner nor the demise charterer. Please see, my lords, thereafter in line number 14 or line number 13, that the owners agree to let the said charterers agree to hire the vessel from time to time, always about time charter of 6 months and 15 days. So this was for 6 months and 15 days. Respondent number 3 was the time charterer. Please, if I may invite my lord's attention now straight to line number 170, which is at page number 7, page number 8, bottom of page number 8.
Line number?
Line number 170, clause 26. Nothing herein stated is to be construed as a demise of the vessel to the time charterers. So this document will make it clear that respondent number 3 was a time charterer of the vessel and was not the demise charterer. In fact, the clause says he can't be the demise charterer of the vessel. So my lords, in my respectful submission, respondent number 3 being the time charterer of the vessel Admiralty jurisdiction cannot be invoked for to arrest a vessel for a claim of the time charter. On this aspect, my lords, I was to show, my lords.
For the provisions that
Yes,
that you're relying
section
on.
5 was the provision, my lords, for arrest of the vessel. You have the hard copy. If my lord sees section 5 of the Admiralty Act,
Yes.
may I tender otherwise?
Yes. What happened to the book? Yes.
If my lord sees section 5 of the Admiralty Act, arrest of a vessel in rem, the High Court may order arrest of any vessel which is within the jurisdiction for the purposes of providing security against a maritime claim, which is subject of an admiralty proceeding, where the court has a reason to believe. Now, please see, these are the tests. The High Court may arrest for a maritime claim, to secure a maritime claim, if the court has reason to believe, 1A, that the person who owned the vessel at the time when the maritime claim arose is liable for the claim and is the owner of the vessel when the arrest is effected. So for A to apply, the owner must be liable. B, demise charterer of the vessel at the time when the maritime claim arose is liable for the claim and is the demise charterer or the owner of the vessel when the arrest is effected. So he either has to be the owner or the demise charterer. The person against whom a party has a claim to arrest a vessel should either be the owner of the vessel or should be the demise charterer of the vessel, not a time charter, not a voyage charter. C, my lords, is a claim for mortgage. That is not the case in the present case. D is the claim where, my lords, the vessel is for ownership and possession of the vessel. My lords, not the case. E is the claim against the owner, demise charterer, manager, and is secured by a maritime lien. My lords, I don't think, my lord, the case can be pitched to be a maritime lien. Maritime liens are the, my lords, liens mentioned in section 9. Their case does not, my lords, fall in section 9. So therefore, what applies is A or B. Now, my lords, the petition, as your lordships have seen on the last occasion, proceeds entirely on the basis that the liabilities of respondent number 3. My learned friend had conceded that their claim is against respondent number 3, not the owner. So A will not apply. B, and if not, my lords, I will take the quote. I had indicated the paragraphs. I will just indicate the paragraph numbers. Their case all throughout has been that respondent number 3 is liable for, my lords, whatever losses they've suffered. B is only, my lords, the case which can be invoked provided, my lords, respondent number 3, should respondent number 3 be a demise charter. Now we have seen the document that the owners have brought on the record, by virtue of which it is demonstrated that respondent number 3 was a time charterer, and in fact the clause 26 of this charter party says that this is not a demise charter. It makes that clarification. Now I will show, my lords, a judgment in identical basis, where, my lords, the Bombay High Court considers exactly these clauses. And, my lords, holds that an arrest of such a nature is not maintained.
Yes, paragraph.
Yes, my lords, may I invite my lords' attention first, and my lords, sorry, just I am troubling my lords with para 1
yes,
and 2 only to show the issue and that this was decided even at an interlocutory stage. The plaintiffs have moved this court for an ex parte warrant of arrest against defendant number 1 and for some other consequential reliefs. An order came to be passed on 8 January 2003 in terms of the judge's order. Defendant number 3, the owner of first defendant vessel, has now moved this court for vacating the said order on the ground that there is no cause of action. Issue now a few facts may be set out which would enable this court to resolve the controversy. The issue: can a ship be caused to be arrested by a party to a charter party which has been terminated or has come to an end in an action in rem without such a party having a maritime lien and without the disponent owner being the demise charter? In the petition, your lordships have also seen, they keep referring to respondent number 3 as a disponent owner. So we will now see, my lords, whether the judgment will, my lords, actually throw light in an identical charter party like in the present case, where, my lords, the allegation was that he is the disponent owner, what the Bombay High Court actually holds. May I now invite my lords' attention to para 7. or rather, sorry, para 5 for a moment. Just to show, my lords, what was argued. On behalf of defendant numbers 1 and 3, my lords have that?
Yes.
On behalf of defendant numbers 1 and 3, the learned counsel has specifically contended, firstly, that none of the claim amounts to a maritime lien, and secondly, the charter party would clearly show that there is no demise in favor of second defendant. Merely because there is a time charter party would not give ground for the plaintiff to maintain an action for arrest of the vessel. Reliance is placed on the authorities in support of his contention. Exactly what I am arguing today. Please look at 6. Yes.
We'll read the next part.
But just before that, sorry, may I just trouble my lords to see, come to page 5 for a moment.
No,
I'm
on
sorry.
the other hand, on behalf of the plaintiffs.
But just before I come that, sorry, just to show the identical nature of the clauses in the present case and in the judgment in the Bombay High Court, may I trouble the court to come to page 5.
Paragraph number?
My lords, it's in the middle of, it's second paragraph, unnumbered paragraph at page 5, in support of his notice of motion. The page number is on the top, my lords. 5 of the judgment.
Yes.
My lords, in support of this notice of motion on behalf of defendant numbers 1 and 3, Mr. Santosh Manzarekar, the constituted attorney of first defendant, has filed his affidavit. It is set out that so-and-so is the owner of first defendant tug. It is further set out therein that on 17th October, the owner chartered the said tug to second defendant with a time charter party.
Similar clause I have seen.
Yes, clause 34, your lordships must have seen.
Yes.
And then please see just below the quoted portion, my lords, the clause 34 and 9, the charters upon delivery, forget 9, my lords, 34 is the main one.
Yes.
Nothing should be construed as creating a demise, which is exactly our clause 26. Please see, my lords, just below that quoted clause 9, it is set out therein that the plaintiffs have not averred any cause of action against the owner through the averments made in the plaint would disclose disputes between the second defendant and the plaintiff. In our case, my lords, between the petitioner and third respondent. The claim is pleaded only against the second defendant based on the charter party dated so and so. In our case, third respondent. The action of the plaintiff in seeking to recover the amount from first defendant tug.
The counsel, you don't have to go into that. Please.
My lords, please come to para 6. To my mind, what the court was.
You can come to para 5. Continuation of, on the other hand, on behalf of the
plaintiff. On the other hand, on behalf of the plaintiff, the learned counsel contends that there is no statutory provision or definition of maritime lien in the country, considering that the bunkers were delivered and used by the vessel. The action was maintainable. There is no material to show as to the nature of the transaction in charter party agreement between the second defendant and the third defendant. As much as such, the issue as to whether there is a demise cannot be concluded at this stage. The learned counsel appearing on behalf of the plaintiff has also placed reliance on some judgments in support of the proposition and further contended that at the motion stage, when the plaintiff must establish they have reasonably arguable best case in admiralty matter, in these matters, it is pointed out that the court should not recall or vacate its earlier order. They say that this is a triable issue at the motion stage. 6. Now, to my mind, if the judgments of this court, apex court has, as also the courts in other jurisdictions, commentaries on the subject and ratio on those judgments on maritime lien are taken into consideration as to what would amount to maritime lien is no longer res integra. Apex court has concluded, my lords, then the judge, just note, just to save time, I'm not reading this, has read the judgment of the Supreme Court in Epoch Interports versus MV Wonfu. I'll skip that portion and straight invite my lord's attention to para 7, where the question is considered and answered.
Yes.
The question therefore is whether the plaintiff herein were entitled to have the ship arrested by invoking admiralty jurisdiction of this court. The charter party was no longer in force between the plaintiff and second defendant when this court was moved for arrest of the ship. The document, now this is very important, the document produced before this court does not show that there was a demise in favor of the second defendant by the third defendant. There was also no clause creating a demise between the plaintiff and the second defendant. This would be relevant aspect as to consider the issue in issue before this court. Even assuming it is to be a maritime lien, at least insofar as item 1 as pleaded by the plaintiff, could this court on facts as have now emerged, could have ordered arrest of the vessel. Please see, my lords, Wonfu thereafter is quoted. I will skip that because I will cite Wonfu subsequently. Please see para 9. Even in case where a maritime lien, there is a further requirement, plaintiff approaching the court must have a demise in favor of the second defendant. In absence of such a demise, the action would be not maintainable. For the purpose, reliance was again placed on the judgment in Wonfu. It is pointed out for the plaintiff, the charterer, to maintain an action in rem, the disponent owner ought to be a demise charterer. If this is not the position, then an action in rem would not be maintainable. The apex court has observed as follow. Just see, my lord, just before the quoted portion, it is in that context, pleadings and documents on record to determine the nature of charter party needs to be ascertained. The plaintiffs have filed on record charter party agreement. In box 2, defendant number 2 is described as the disponent owner. Here, my lords, their charter party records respondent number 3 as the disponent owner. Clause 34 of the said charter party reads as under demise. Nothing herein contained shall be construed as creating a demise charter of the vessel to the charterers. Just what we read, my lords, clause 26. Para 14 of the affidavit of Santosh Manjrekar, the third defendant has set out the clause in the charter party between the owner and second defendant, which reads as under nothing herein shall be construed as creating a demise of the vessel to the charterers. Insofar as clause in charter party relied by the third defendant entered into with second defendant, plaintiffs have disputed the same. Even though the dispute is at prima facie stage, this is very important, in absence of any strong material to the contrary, there is no reason why this court should not rely on the affidavit of Santosh Manjrekar for the owners. Therefore, at least third defendant has prima facie established existence of clause 34 of the charter party agreement between the third defendant and second defendant, which does not create a demise in favor of the second defendant by the third defendant. The clauses in the charter party between the plaintiff and second defendant has been adverted to earlier. If this be the position, it is prima facie clear that the disponent owner was not a demise charterer. At the highest, there has been a breach of contract between the plaintiff and the second defendant. In such a case, the vessel being the ownership under the ownership and possession of third defendant, liability.
Yes, I've seen.
My lords, just one aspect. This was again at an interlocutory stage. We've seen, my lords, the charter party agreement between the owners and respondent number 3. He could not have been it. The document talks about it being a time charter. The clauses say it is for 6 months and 15 days. And lastly, my lords, the clause itself mentions that it is for, my lords, a fixed. It is that it does not create a demise. Now, my lords, just one more aspect. Since there was, my lords, a lot of stress on, my lords, addressing respondent number 3 as a disponent owner, this judgment of the Supreme Court in epoch inter reports, my lords, needs to be considered. Madam.
Yes.
My lords, may I straight invite my lords' attention to para 36 at page 319 of the judgment.
Paragraph
36. I'm just going to read one paragraph on this proposition, my lords, so that, my lords, we steer clear of, my lords, this argument of disponent owner, unless shown to be a demise charterer, there is, my lords, can be no good. Please see, my lords, para 36. Even, however, assuming the agreement has in fact been entered into by the disponent owner, unless sufficient evidence is laid that the charter was by demise, whereby the possession and the control of the vessel was given to the disponent owner, the question of pursuing the cause of action against the vessel would not arise. Needless to add, charter parties are of 3 kinds. So now, my lords, we will have clarity on what are the 3 types of charter. A, demise charter. B, void charter. C, time charter. Whereas in a demise charter, the vessel is given to the charterer, who thereafter takes complete control of the vessel, including manning the same. In both voyage and time charter, the master and crew are engaged by the owner, who act under the owner's instructions, but under the charterer's directions. Simply put, voyage charter is making available the vessel for use of carriage for a particular voyage, and time charter correspondingly is where the vessel is made available for carriage of cargo for a fixed period of time in contextual facts. Apart from the fixture note, no documentary support is available as to whether the ownership arose through a charter by demise and possession and control of the vessel had already been given to the disponent owner. The facts disclose that the disponent owner was intending charterer of the vessel from the owner, and it is on expectancy of such a contract the fixture note was issued. There was as a matter of fact, no charter party agreement with the charterer, and eventuality in future stated to be on the basis of cause of action. It is on this score we think it is expedient to record that even on an assumption of the appellant's case at the highest, no credence can be attached thereto. The disponent owner was not a demised charterer, but it is also on happening of such an event in the future that such a fixture note has been issued. In our view, there is no sufficient evidence available as regards to an action in rem making the vessel liable in contract said to be entered into as recorded in the fixture note. The nature of breach of contract and the liability of the vessel would not arise. However, we are not expressing any opinion on the maintainability of an action in personam and eventual success. So unless the disponent owner is demised charterer, the petitioner has not produced on record, my lords, at least the contract produced on record by us between us and respondent number 3 shows that he was a time charterer. Now, one aspect, my lords, this issue, both these, just to have, my lords, one aspect. Generally, my lords, when I joined, my lords, the chambers of, my lords, the senior advocate that, my lords, I practiced under, my lords, we were, there are no Indian authors, my lords, on this, on especially on this branch of law. So to give, my lords, an example as to what is a time charter, a void charter, or a demise charter, we always made a reference, my lords, to this book. One of, my lords, a book which is, my lords, the basis of, my lords, studies in Southampton. My lords, please see at page 4 of the of the book that I have, my lords, produced. Please see, my lord, the second unnumbered paragraph. There are essentially two basic forms of carriage charter, depending upon whether the vessel is chartered for a period of time or for one or more voyages. In both instances, the ship owner retains control of equipping and managing the vessel and agrees to provide carrying services. In case of voyage charter, he undertakes to carry a cargo between a specified points, whereas in time charter, he agrees to place the carrying capacity of his vessel at disposal of the charterer for a specified time. A typical example of a voyage charter is provided by a seller of goods under a CIF contract who have agreed to ship the goods to the buyer, and when the charterer as a vessel and then charters a vessel to carry the same to their destination. Time charterers, on the other hand, are often used by carriers who wish to augment their fleet for a particular period of time without expense of buying or running a vessel. So time charter is for the vessel is given on hire for a particular time period. A voyage is only to is for the purposes of completing one or multiple voyages, but not for a fixed time. In a time charter, you carry as many voyages as you want, but you have to return the vessel, or rather, in that sense, settle the account within that time period. In a voyage charter, the number of time is irrelevant. The voyage is as stipulated. Now, what is demise charter? Please see, my lords, page 7. And all this is considered by the Supreme Court. The Supreme Court also, my lords, in Wonfu considers this. Please see 1.4, demise charter party. Finally, brief mention must be made of demise or bareboat charter, which must be distinguished from the types of charter already discussed, in that it operates as a lease of the vessel and not as a contract of carriage. It differs from other charter parties in much the same way as the contract to hire a self-drive car differs from a contract to engage services of a taxi. Whereas in ordinary time charter, the ship owner retains control over the operation of the vessel. Under a demise charter, the charterer displaces the owner and for the period of lease takes possession and complete control of the ship. Under this type of contract, the charterer mans equips the vessel and assumes all responsibility for its navigation and management. For all practical purposes, he acts as the owner for the duration of the charterer and is responsible for all expenses incurred in operation of the vessel, and is also for its insuring her. So, my lords, this is the distinction. In the present case, we've seen it's a time charter for a fixed period of time, that is 6 months and 15 days. Also, my lords, if I may trouble that charter party for a minute, what is also interesting is that in that clause, in fact, apart from that, if my lord sees just for a moment, page 6, line number 36, if I may only trouble the court, that the owners shall provide and pay for provisions, wages, and consular shipping and discharging fees of all crew. So, my lords, here the owner was paying for the crew members. Clearly, my lords,
No, where are you reading that?
sorry, line 36.
And page number?
6, my lords, of the charter party that I had just shown the court.
How the line starts?
That 36, my lords, one dot, that the owner shall provide. My lords have seen the charter are on page 6 of the additional affidavit.
No, I'm looking at the very same.
No, not that, my lord. I was now making a reference to, my lords, page 6 of the charter, just to read this clause, that here in the facts of our case, where in the charter party between me, the owner, and respondent number 3, the wages, the consular charges and provisions for the crew members was paid by the owner. So, my lord, clearly, my lords, this is a case of a time charter where respondent number 3 was the time charter. Now, my lords, one last judgment on this is the judgment of the Gujarat High Court, which had an occasion to consider all that I have cited this far. The Bombay High Court, the Supreme Court, and my lords then come to a conclusion. This was a case of a void charter. It's a judgment called MV Leonis versus Libra Shipping Services.
Yes.
Please see, my lords, para 3. At para 2, the plaint was being, if my lord sees para 2, the plaint was being analyzed. So just see para 3. At para 2, it is stated as under: defendant number 1 is the vessel MV Leonis having Saint Vincent and Grenadines flag built in so and so. Defendant number 2 is Vast East International PT Limited, Singapore, which has entered into a charter party agreement for void charter with the plaintiff and is the disponent owner of defendant number 1, whereas the head owner of defendant number 1 is Prominent Shipping. So Prominent Shipping, my lords, was the owner of the vessel. Defendant number 2 was the charterer of the vessel, and my lords, and it was for the vessel. Now, please, if I may invite my lord's attention, para 4 also, aforesaid shows that even as per the plaintiff, defendant number 2 has entered into a charter party agreement for void charter. Now, straight, if I may invite my lord's attention to para 10. Your lordships will find that at page 2.
Yes.
Or rather, my lords, may I straight rather? Yes, the aforesaid averments in the plaint, if considered in light of other averments in the plaint, it appears that as per the plaintiff, defendant number 1 ship has been entered into a charter party agreement for void charter with defendant number 2. The plaintiff has entered into an agreement with defendant number 2, and through defendant number 2, the plaintiff is claiming the right in the ship, defendant number 1. As per the plaintiff, since loading of cargo for Japan is denied, there is a cause of action for the plaintiff against defendant number 2 and defendant number 1, and also defendant number 1. As stated by the plaintiff in the plaint, defendant number 2 has the bunkers in defendant number 1, and therefore the prayer was made for arrest of the bunkers. But surprising aspect is additionally the prayer is also made for arrest of the ship itself. The aforesaid goes to show, for invoking admiralty jurisdiction of this court, basis of the plaintiff is that defendant number 2 is through defendant number 2 upon defendant number 1. So therefore the liability was of the charterer for which they were arresting defendant number 1 vessel. Now please see what the court considers in para 16, 17, my lords. Further, if the averments in the plaint, as per the averments made in the plaint, the charter agreement was for a voyage, it does not create any demise. Very important. nor Mr. Joshi, learned counsel for the plaintiff during the course of the hearing was in a position to show any material for creating a demise in the ship to enforce the right in rem against the ship as the beneficiary of the charterers. Even if it is accepted for the sake of examination that defendant number 2 was the charterer without demise, there is no agreement or material whatsoever produced by the plaintiff. 17. If there is no privity of contract between plaintiff and defendant number 1, that is the vessel, either directly or as an agent of the charterer, the right at the most can be termed as in personam against defendant number 2, which in our case, my lords, is against defendant number respondent number 3, and not in rem, which can be enforced against defendant number 1. Reference, now please see, reference may be made to the decision of the apex court in Epoch Inter Reports versus NB Wonfu, and more particularly para 35 and 36, and the decision of the Bombay High Court in Sierra International versus MB Umka, the judgment that we read, and more particularly the observations made in para 7, 8 and 9, my lords, these we have read. Therefore, if the claim is only by way of an agreement against defendant number 2, such a right would be in personam, for which reference is made to arbitration as per the above referred order of this court, and there is no right in rem available to the plaintiff against defendant number 1 vessel. So, my lords, therefore, in the facts of this case, and please see, my lords, also para 20.
Yes.
Here, my lords, even at an interlocutory stage, the suit was rejected under Order 7, Rule 11, saying that your cause of action was against, in our facts of the case, if I was to say, my lord, petitioner's entire cause of action is against respondent number 3.
That you don't have to repeat those facts.
Yes. So, my lord, this, in my respectful submission, would demonstrate that, my lords, that for the test under Section 5 is not satisfied. It's a jurisdictional test for the court, my lords, to exercise Admiralty jurisdiction and, my lords, order arrest.
So, because it is not a demise charter, they have no cause of action under Section 5.
That's right, my lord. And, my lords, given the fact that
on this judgment, what is the next point?
Yes, my lords, the next point, my lord, this was, my lords, yes. Then, my lords, just, my lords, to indicate the judgments relied upon by them, just to, my lords, quickly distinguish those judgments. My lord, the judgment of the Karnataka High Court, which was tendered, my lords, on the last occasion. But just to indicate, in fact, your lordships I need not bother the court, but just to indicate.
Which judgment you want to distinguish?
The judgment in Mech Petroleum, my lords, the single judge. Please see, my lord, this was a case where, my lords, bunkers were supplied.
1 minute.
Just to, my lord, let me enumerate the points of distinction, and if need be, I will trouble the court through, my lords, the paragraphs. Just in
Is Mech Petroleum.
I'm just to indicate the points, and then I will trouble the court. This was a case where bunkers, which is fuel, was supplied to the vessel. The master on the bunker delivery note, which is the contract, affixes, master or the chief engineer affixes his stamp, indicating that, acknowledging the.
Was the issue with regard to the time charter?
No, this was not an issue.
Was not considered.
This was not an issue. In fact, the only issue was that the owners come and say,
He was relying on these judgments, whether when there is an arbitration clause, without seeking any other relief in this application, can you seek for arrest of the vessel?
Yes, I don't.
For that purpose, he is relying on this.
On this judgment. Then, my lords, let me indicate, if this is the reason to rely upon this judgment, I am really, my lords, at this stage, my lords, concerned with showing that the test under Section 5 was not met. My lords, I have already argued on the previous occasion that how, my lords, on the contrary, despite their.
With the other contention, whether such a relief is maintainable before this court, when the arbitration is pending before the courts at London or Russia, wherever it is. So, what do you say on that? What is your submission?
So, two answers, my lords. Let me, my lords, having considered this.
So, in the light of these judgments, they say that it is maintainable. Even the judgment of Justice Sriram also.
My lords, let me, as an officer of your lordship's court, answer your lordship's question. If your lordships were to allow, and my lords, I think I understand, allow their prayer for amendment and allow them to incorporate the prayer for a decree. And if, my lords, ultimately a decree is sought, I don't think, my lords, my argument can, in that sense, and let me answer this as an officer of your lordship's court, can take, then that argument may not survive, as on the date when the arrest was granted, it was merely to refer a dispute to arbitration. So therefore, I am covered by the first judgment of Justice Sriram, which I had cited, my lords, in African Eagle, where the court says, if it is only an interlocutory order, it is not maintainable, and then then the suit was dismissed. If your suit is only for an interim order, then it was dismissed. But if there is a decree, then I don't think, my lords, that argument may survive in light of that. So let me answer as an officer of your lordship's court. However, there are two aspects, my lords, with an ongoing arbitration against respondent number 3 that the petitioner has. I am making a slightly different point. To suggest that there has to be it can't be decided, this application can't be decided at an interlocutory stage and must await trial in the arbitration. There I join issues. I don't think that's an accurate position for two reasons. First, I am not a party to that arbitration.
So where you have to address, yes.
Yes. So therefore, my lords, I can't, the issues which I have raised here can't be decided there. The only issue that will be decided in arbitration between the petitioner and respondent number 3 in London, Switzerland, wherever they are taking it, is that whether the charter party has...
Even in case of a demise charter also,
yes,
this kind of a claim will be made against the charter, not against the disponent owner.
My lords, two aspects. Disponent...
In that case also, you
Where?
will not be a party to the arbitration.
No, I'm sorry. May I just beg your lordship's pardon again? May I beg my lord's pardon? Would my lords please repeat that?
I'm saying yes. No, in this case you say arbitration is pending, you are not a party to the arbitration.
Correct.
Whatever takes place, you can't put forth your claim.
Correct.
Because, and you are claiming that it is a time charter.
No, there are two different...
For demise charter also, will you be a party to the arbitration?
In case of a demise charter of the vessel, I will not be a party to the arbitration agreement. There, however, my lords, I must indicate two things. In a demise charter, and therefore, my lords, I was at pains to read those the passages from the book, as well as what, my lords, in a demise charter is a demise charter is made a de facto owner, though not de jure owner.
I understood that.
So therefore, the liability the owner attracts, whereas in a time and a void charter, the owner does not attract any liability for the breach committed by the charterer. This is, my lords, the common theme.
Both the issues, you cannot put forth any of the claim. No, you will not be a party before the arbitrator.
Correct. But however, having agreed to give my vessel on a demise charterer, I have taken the risk of making someone project to the world that he is literally the owner of the vessel. And that is why, my lords, in those cases, the vessel, my lords, is allowed to be arrested. Therefore, my lords have seen even the Admiralty Act makes it very clear that arrest for the liability of only demise charterer can the vessel be arrested. It does not use time or, my lords, void charter. The Supreme Court, when it considers, my lord, discusses the three types of charterers, and then say that assuming that you claim that your claim is against a disponent owner. My disponent owner, my lords, is a terminology, means what happens even in a time charter. Once a vessel is given to a time charterer, he has the leverage, unless there is a restriction in the time charter party, to give the vessel on back-to-back down to someone on a time charter. So, for example, the court, my friend has entered it as the owner of the vessel, entered into a time charter party with me. I am entitled within the duration of that charter party, give the vessel down to Mr. Chinnappa. Just, my lords, to give a hypothetical example. I become the disponent owner because I have the authority. Huh?
He doesn't want.
I was careful, my lords, in saying only as an example. Or let me say Miss Bhatt for the time being. So, my lords, she's more petrified, is it? So, my lord, the point is, I am in that sense disposing the vessel, or rather in that sense handing over the vessel. Therefore, my lord, in colloquial language, that is termed as a disponent owner. But still, my status qua the owner is that of a time charterer. The vessel has been given for a particular time, control retained by the owner, and in the facts of the present case, a clause which says this is not a demise. So therefore, 5(1)(b) in my respectful submission is not, my lord, something that the petition, and very, very importantly, if please see, my lords, may I trouble my lords with their petition for a moment? Please, I will not, my lords, but for the relevant ones, trouble the court on any other aspect.
Yes.
My lords, just to begin.
Then your submission on the other judgments is that
In fact-
this particular, whatever the nature of application that is filed is maintainable.
Yes, in fact, on the aspect of, my lords,
Arbitration clause and
I
without
must,
seeking any.
as an
any other
officer of your,
explanation before the court, only seeking arrest of the,
if it is only seeking the arrest of the vessel, the petition is, or a suit is not maintainable. If it is accompanied by a decree, per se, on that ground, I may not be able to then argue that the petition is for seeking an interlocutory relief. But that does not mean, my lords, on the other aspect, my lords, on maintainability of the suit, or on maintainability of the petition, on the test not being
the
set.
court just wants a clarity on
Yes.
what are your submission. So this is the second one. What is the third point to be argued?
Yes, the third point of the argument, sorry, before I move there, may I just quickly, my lords, I'm sorry, invite my lords' attention to their petition. I just want to, my lord, show a few paragraphs and stop. On this point, I'll stop. My lords, their petition, para 8.
Yes.
Petition, just see para 8. I'm just going to, my lords, point and make my point and move ahead. I'll not read each and every. Para 8 will demonstrate that petitioner and respondent number 3 have entered into a time charter party, which is, my lords, the subject matter under which, my lords, they suffered losses. Please note, my lords, the owners, the applicant is not a party.
Yes.
Just see, my lords, para 9. This is very important.
You have already, that last occasion you have pointed
Yes.
out, and I have already noted all those paragraphs.
All those paragraphs. The point is, my lords, I just will point out one and I'll stop. Please see para 9, just so that, my lords, I don't want to be stuck to a concession or, my lords, which may not stand. But para 9 and, my lords, all those paragraphs will show that, just see, my lords, para 9. Petitioner has a maritime claim against the respondent vessel arising out of use and hire of the vessel, falling under 41H read with 5(2), and for loss stroke damages suffered by the petitioner due to failure of respondent number 3. So, my lords, the entire, and the theme of the petition is, my lords, liability of defendant number 3. Now, just on one aspect, if I may trouble, my lords, with
The
the
last 4 lines in para number 9.
last 4 lines in para number 9. Yes, your lordships will also note the petitioner is entitled to receive the amount as the petitioner has suffered losses from the breach of the time charter by respondent number 3.
In para number 10, first 4 lines.
That's correct. So I'm now, my lords, if I may only trouble my lords with the reply filed by them into my eye, or their objections to my eye. I'm sorry. Still getting used to, my lords, the terminology of each court.
Yes. Which is dated?
Sorry, I will indicate the reply is was tendered in court. I unfortunately, my lords, we have all unaffirmed copies given. So
File?
no, reply filed to I.
I know. I served it to one already.
Dated.
Shall we?
Yes, what it says?
My lords, just to the point that they
Reply to I number?
I number 1.
Dated?
I will not have the date because we have been served with
Dated?
unaffirmed.
I'll just show.
Why don't we write to them and take the affirmed copies from them? Otherwise, we'll not have our record complete.
Last statement of IA to which IA? IA 1. IA 1 of 25.
This is dated 16/4.
Yes, possible.
What is that you want to submit?
I'm sorry. Yes, I was to invite my lord's attention to para 8.
It is settled law.
Yes, it is settled law, and this is my lord's their contention. It is settled law that if the claimant, which I believe the petitioner, asserts a maritime claim against the disponent owner, the ship could be arrested nevertheless to enforce the maritime claim, and therefore the argument of the applicant that there is no privity of contract with the original ship owner and that the petitioner does not have a claim against it cannot be accepted. So their contention simply stating is that they have a maritime claim, of course, not against the owner, but against the disponent owner, and my lords, for which there is nothing produced by them to show, and which obviously because they don't have anything to show, that the disponent, that the person who they assert as a disponent owner is the demise charter. That is why, my lords, those Bombay High Court judgments. I just wanted to complete this line of arguments by showing the pleadings, the petition, their objection. They are consistent that their entitlement to seek arrest is because there is a claim against the disponent owner, and that is why, my lords, I cited this law to point out that, my lords, merely because your claim may be against the disponent owner, but the disponent owner, if it is a time charter, will not be entitled. No, please, sorry, my lords, petition only for one reason. How, my lords, my lords, those points that I had argued on, my lords, false statement and suppression, I need not, my lords, at this stage repeat here.
You must have had that in your written arguments.
Yes, we will be inserting that because, my lords, an attempt was made to hoodwink the court by stating, your lordships have seen their own document saying that CS Flourish Limited, that applicant is the owner of the vessel. But conveniently at places, my lords, they have stated that no, respondent number 3 is the owner of the vessel.
Disponent owner.
No, they say owner. And I had pointed that out, in fact, my lords, to show that clear attempt has been made to hoodwink the court. Because otherwise the test, this is so that, my lord, just in case a person is caught, then to say that, sorry, but I meant a disponent owner. So wherever they've used, they've used the word disponent owner specifically. So in my respectful submission, my lords, this is on the arbitration aspect, my lords, in light of their amendment application, though we've made that point and cited Justice Sriram's earlier judgment, I would respectfully submit that now that they are applying for a decree, may not, my lords, that may not be, they are applying for a decree, but, my lords, that does not mean I concede on the other points, because what they, my lords, intend to do, if my lords sees their draft amendments.
No, that I'll record your objections to that IA also for amendment.
Because, my lords, what they seek to say is, I'm seeking a decree, but you stay your hands. Of course, my lord, that argument is not yet made. As and when the amendment is, your lordship allows the amendment, and thereafter they press for that, my lords, I will meet with that arguments then. You can't seek a decree and then say, I'm seeking a decree only to tell you
then,
that stay on.
What is your argument on IA number 5?
IA number 4.
4 or 5?
IA number 5, my lords, 2 aspects. Please see, my lord, this IA was preferred. Firstly, my lords, on my lords, on the aspect of, my lords, the conduct, and, my lords, given the fact that this, my lords, in my respectful submission would not be a bona fide application, this application has been preferred after, my lords, completion of my arguments and beginning of their arguments.
Not about that amendment. I'm asking you your amendment on that cost and other things.
Yes, security, alternative case. Yes, sorry, I'm extremely grateful. Alternative case, which is for security of cost. If I may invite my lord's attention to, since the court indicated IA5, my lords, I was to proffer those arguments, but IA4, which is for order 25 rule 1, if I may invite my lord's attention to that. Particulars, my lords, just see order, if I may invite my lord's attention to order 25 of CPC, and then I will show, my lords, we've given particulars, and I will show direct Bombay judgment on this, where, my lords, the Bombay High Court has considered that not some, my lords, ridiculously low amount of cost. You are entitled to cost. This is order 25 is to ensure that the cost that a plaintiff is to incur is secured, which includes flying off, my lords, the witnesses from abroad, their accommodation. All these were found to be justifiable expenses that needs to be secured.
So when it comes to this case, as
Yes.
of now,
Yes.
for example, if this court wants to pass an order,
Yes, my lords.
a final order
Yes, my lords.
in this case,
Yes.
then
My lords, my IA4, if the court, my lords, were to be in my favor and vacate, then my IA4 will not survive. If I succeed, my lords, in having my security returned, then the list is only between the petitioner and respondent number 3. And my lords, they may do whatever they wish to do. That IA4 will then not survive because there is no question of me then going to trial and therefore incurring those expenses.
Once the interim order is vacated.
Correct.
What remains to be decided before this?
But
court
technically,
between the petitioner.
technically,
and
my lords, therefore, if my lords have seen here, some courts in Bombay, my lords, have not literally dismissed the suit at this stage, but have merely vacated the order of arrest. I've tendered the judgment of His Lordship Justice Rivello, where they say no case has been made. I vacate the order of arrest, direct refund of security, and then, my lords, not done anything further. At a subsequent stage, my lord, literally the suit should come to an end. Some, like the Gujarat High Court, have dismissed the suit under Order 7, Rule 11, saying that there is virtually nothing against the owner, and you have not shown there is demise charter, so dismiss the suit.
There was a petition for rejection of claim.
Yes, under Order 7. But my lords, let me stipulate this, and the law on this is very clear. If need be, I'll tender those judgments. Order 7, Rule 11, frankly, my lord, does not require a formal application. That law is, my lords, clear. Supreme Court has, my lords, time and again.
No, I'm saying in that particular case, there was an application.
In Gujarat, there was an application. In Bombay, there wasn't. So Bombay, my lord, simpliciter vacates the order of arrest, vacates the interim order granted at an interlocutory stage and leaves it at that. So the vessel was allowed to sail away. In this case, my lord, security will have to be returned. Your lordships have seen similarly in the Gujarat High Court, the earlier one, my lords, that I had cited, where the vessel was arrested, security was posted. The court allows the IA and directs the security to be returned. It does nothing further at this stage. Whatever is the fate, then, my lords, will be left to be decided at an appropriate stage. If a 711 is preferred, a 711 is preferred. If, my lords, ultimately, my lords, the court suo motu dismisses it, dismisses it. But since the one judgment that I had cited, my lords, before your lordship's court in the matter of, my lords, MV Sylvia Glory, security was directed to me, my lords, returned. That, my lords, I have cited those judgments. Now, my lords, insofar as Order 25 is concerned, I must point out, my lords, please, if I may invite my lords' attention to Order 25.
Yes, yes.
Order 25.
But this I must clarify, my lords. I am required to clarify. Please don't get me wrong. This Order 25 application, which is my IA4, is alternative to and without prejudice to my IA1. That's I must. My Order 25 Rule 1. When security for cost may be required from the plaintiff at any stage of the suit, the court may, either on its own motion or on the application of any defendant, order the plaintiff.
What is the amount you have arrived at?
In my security for cost?
Yes.
My lords, the amount that we have given is $234,000 US.
And what is your reply to that? It was, you
filed
a reply to that?
Yes, we have filed a reply. Any cost determination, because if you are treating this as a civil suit, has to be done in terms of the Karnataka Civil Rules of Practice, which provides for a mechanism of determination of cost. If it has to be determined, that is a mechanism. That's the only thing. That's the mechanism which, and I'll place not any number of authorities of Karnataka High Court.
And have you stated how, as per the Karnataka so and so?
No, the amount I'm not fixed. I've not determined that, but there is a mechanism which provides, because this is not for damages. This is for costs incurred, and what rules of practice provide is this is the mechanism of cost. So even if a suit is disposed of with costs, the benefit is only on the basis of the civil rules of practice. That is settled insofar as Karnataka is concerned.
So what your submission? I think we can hear this in a council.
May I just tender the judgment, and my lords, then my friend can
judgment
on this, what all can be, my lords, secured under Order 25.
Yes, you can pass on the judgment.
Yes, my lords, in an Admiralty jurisdiction decided. Please see, my lord, this was in terms of, my lords, judgment of the Bombay High Court in an Admiralty suit.
From Bombay High Court also, all Justice Sriram judgments only on this.
He has been, I must say, with all humility, we were privileged to have him. He was, my lords, one of the most, since his practice stemmed from this, one of the most authoritative judge. The second Bombay High Court judge whose judgments have been reported, my lords, in the prestigious English Lloyd's Law report. So in that sense, my lords, he has been a pioneer.
Yes.
Now, of course, my lords, the benefit has been shifted to the Madras High Court of, my lord, since he is the Chief Justice of that court. But Sorry, I had also cited, sorry, in the, on I1, I had cited, my lords, the judgment of the Hyderabad High Court, which I then indicated was a common
Yes,
High Court.
MS.
MMS Ramchandra Rao's judgment on, my lords, the test and the other factors, that even at an interlocutory stage, the court, my lords, was pleased to vacate the order of arrest. My lord, I will mention all of this in my written arguments. Your lordships may, in that sense, my lords, I'm not repeating all my points because the court was really indulgent in hearing us. Now, my lords, on this aspect, please see, this was an interlocutory application. As your lordships can see in para 1, it was a notice of motion.
Paragraph number
1 to begin with. Notice of motion is taken out on behalf of defendant, praying that an order and direction for the plaintiff to deposit 24 lakhs as security for cost incurred and likely to be incurred by defendant and such other amounts that this honorable court deems fit and proper, dismiss the suit in the event plaintiff fails to furnish the security. Now, my lords, please see, when the court considers this, may I straight, my lord, then it is, my lords, considering judgments and law, may I straight invite my lord's attention to para 21. Having considered order 25 rule 1, the judgment in the matter of Revlon, Revlon is a Delhi High Court judgment, where I have come to the conclusion that proviso in rule 1 is mandatory provision, considering that the plaintiff is a foreign company and having registered office outside India, and they have no immovable property in India and any other assets in India. The fact of this case fulfills the requirement of the proviso of order 25 subrule 1. As such, the plaintiff must furnish security for cost. The cost to be awarded, 22, the cost to be awarded in the nature of incidental damages allowed to indemnify a party against the expenses of a successfully vindicating its rights in court, and consequently the party to blame pays the cost to the party without fault. There are other provisions of CPC other than order 25 where cost would be provided. Section 35 of the code deals with an order of cost, and incidental to all suits shall be in discretion of the court, and only where the costs are not awarded, then the court shall state reasons in writing. I'll pause here for a moment. Now, my lords, with the coming in of the Commercial Courts Act, of course, order 35, it says, of course, the powers are to award actual cost, not merely, my lords, notional cost. In fact, section 35 provides that the fact that the court has no jurisdiction to try a suit shall be no bar to exercise such powers. Then 35A provides for award of compensatory cost in respect of false or vexatious claim or defenses. 35B provides for cost for causing delay where the party fails to take steps which he is required by or under the code to take or obtain an adjournment, or to take steps for producing evidence or any other ground. And then section 95 provides for grant of compensation, obtaining arrest, attachment of injunction on insufficient grounds. Though under 95 there's a cap of 50,000, under 35A cost awardable is 3,000. Under 35 and 35B there is no upper limit of the amount of cost awardable, and the amount of cost to be awarded is at the discretion of the court. Now comes to the next stage of what is the quantum which the plaintiff must furnish security. In para 7 of the affidavit reply, the defendant has given a breakup. Now please see, my lord, what was the nature of claim made? One was legal cost incurred till date in defending 4 lakhs. Legal cost likely to be incurred in counsel fees disbursement was 13 lakhs. Then, my lords, expenses likely to be incurred in defendant's 3 witnesses, including air travel, boarding, lodging, and miscellaneous expenses, 6 lakhs. Defendant's share of commissioner fees for recording of evidence, 1 lakh. So 24 lakhs was, my lords, the claim made. As regards this, the view of the Apex Court judgment in Sanjeev Kumar Jain, my lord, this was under the original side rules of the Bombay High Court. The cap was 25,000 for legal fees. Now, my lord, that aspect has now undergone a change in light of the fact that under the Commercial Courts Act, which now the Supreme Court says prevails over the original side jurisdiction, or prevails over the rules framed by the High Court. Therefore, in my respectful submission, now under 35, the court can, my lords, award actual cost. Now, please see, ultimately in para 25, in these circumstances, plaintiff are directed to furnish security in the sum of 7,25,000 within 3 weeks. Security should be either by a bank guarantee. And, my lords, in para 25, it contemplates the cost that are likely to, that the consequences for not furnishing the security. Yes. So therefore, in my respectful submission, my lord, this was of course in alternative to, my lords, to my argument. And my lords, in my we have given my lords the breakup of the legal cost incurred till date, estimated legal cost expenses, and my lords expenses likely to be incurred in applicant's vessel, my lords, in terms of lodging, commissioner's fees, and my lords other expenses. My lord, in fact, if need be, I'll my lords tender there. In fact, my lords, recently I had the privilege, my lords, to argue in the Madras High Court. The Madras High Court single judge has taken a view that insofar as legal costs are concerned, the court will take give complete effect, my lords, to section 35 and actually secure the entire cost incurred till date. So that was, my lords, we are looking at, which includes, my lords, payment of court fees, etc., which, my lords, was for a sum of almost, my lords, $180,000. So that was, my lords, secured. In my respectful submission, my lords, security for cost, my lords, of course, is something that the court will look at in alternative. But should the court look at that, my lords, security for cost, the court should, my lords, in my respectful submission, I beseech the court to, my lords, have, my lords, to consider this aspect in mind, the actual cost, my lord, that a party is likely to incur, and, my lords, accordingly, my lords, we have given our share of breakup. Of course, my lords, ultimately, my lord, the discretion lies in the court. Those were my submissions. Anything that I have to supplement after his arguments, my lords, with the leave of your lordships? Great.
So what do you say on the
It was a very
judgment?
long 17 minutes.
That's what I'm looking at. He said 15 minutes. So now the
Yes,
only point is, which
I'll
you
only
have to
answer that
address,
question.
only on
Demised
that.
owner,
Whether demised charter,
demised
time
charter, or
and the cause of action under section 5.
and I'll also point out, Lord, I don't think I should really take too much of your lordship's time to say that if it is a simple time charter or it's a simple voyage charter, then, Lord, the question of it being a demised charter doesn't arise. I won't trouble your lordship in trying to make a different submission on that. But the point really in this case, Lord, is slightly different. I, of course, said disponent owner. Initially, the argument, oh, he said disponent owner, he didn't say demised charter.
No, let's not go to the disponent.
No, I'm only saying disponent owner as a concept.
Point is, as per the documents which are placed before this
Yes.
court, there is no dispute about the fact that it is a time charter.
There
In
I
that case, then what is the applicability of section 5 and the maintainability of the application?
Absolutely.
Only on that.
I'm
That's
only
a
going to answer, but
crux of the
I won't
issue.
trouble your lordships on anything else. But we said disponent. I'm only saying this, disponent owner as an expression does not take away from the fact as to whether it is a demised charter or a time charter or a voyage charter. It doesn't make a big difference. The expression used in our petition, it's a disponent owner. Initially, a lot of submission may saying they've said disponent owner, not a demised charter. Now, Lord, whether it is a demised charter or not, how is it that your lordships are being asked to examine? This is by way of an additional affidavit which comes into existence for the first time after the objections are filed. Till then, it was not there. Why it is also a lot of some doubt, because the manner in which the document suddenly comes into existence to make this point, because these documents, as your lordships can see, can be agreements signed at any point in time. It's not like where we have something of verification that is possible. Please see the document for a minute.
No, not that document. Let us only go by with what you say.
Yes,
In your own petition.
Yes, in my petition, I say disponent.
The para number 8.
Yes.
The
Ours is a time charter. There's no dispute about our time charter. The point, Lord, is whether the charterer had a demise in his favor. The issue, my lord, we are not saying ours is not a time. Ours is a time charter. There's no difficulty there. Whether the person who chartered had a demise in his favor.
No, that is for you to say in your petition.
No, that, my lord, in my humble submission.
So unless and until you say that, if this application itself is not maintainable.
My lord, I would respectfully say that that becomes a matter of fact that your lordship will have to examine.
That should be pleaded.
My lord,
It should be pleaded.
it's not there. I can quite clearly say it's not there.
When it's not there.
Yes, but now, my
when
lord,
the other party has raised a claim to that.
Yes.
Then at least what is your response to that? To that application, to that document is filed.
my lord, to that
And anyhow, you cannot know what is the nature of
Arrangement
the
there.
agreement between them and that
correct,
person.
correct, exactly, precisely, my lord. One of the
And
reasons
he
why.
is the person who can place the
but then when
document.
you place that document, the timing at which it is placed becomes, in my humble submission, important. Because what has been done along entire objection statement, there's no mention of that time charter. Please see that additional affidavit for a minute. And I'm saying that this document can be created at any point in time. Can be placed before your lordships. Any document can be there and said, oh, this is the document which is there now. In every case of a charter will result.
No. Along with this petition,
My
what are the documents that are filed?
My lord, along with the petition, I have produced my time charter.
Let's see that.
Yes, ma'am. Please see page 70.
Page
70. This charter part. This charter party made and concluded in Hamburg on January 2023 between Continental Dry Bulk as disponent owner of the good motor ship MVCS Flourish of see description clause 62 and Zobagen Shipping LLC owned by Galleria Investments.
The said owner agrees to let and the said charterers agree to hire a said vessel
Yes.
from the time of delivery
Yes.
for time charter
Of 6 months.
6 months.
More or less in charterer's option. Trading always afloat, always access.
Time charter of 6 months between whom?
Between me and respondent number 3.
Hmm.
So respondent number 3, my lord, is chartering the vessel in my favor. He's handing over the vessel for me. I will then have a time charter for 6 months of that vessel.
Hmm.
Then, my lord, please see the next sentence. That the said owners, my lord, saw that?
Hmm.
Said owners agree to let and the said charterers agree to hire the said vessel from the time of delivery for time charter of 6 months with 15 days more or less in charterer's option. So there, my lord, they call themselves as the owner. The said owners agree to let and the said charters agree to hire the said vessel from the time of delivery for time charter of 6 months with 15 days more or less in charterer's option. Trading always afloat, always accessible, always with institute warranty limit, always safe port by so and so, so and so, subject to master owner's approval. Basis actual condition to have by case within below mentioned trading limits. Charterers to have liberty to sublet the vessel for all or any time covered by this charter. Charterers remain responsible for the fulfillment of charter party. Vessel to be placed at the disposal of charterers at so and so date. Then, Lord, may kindly come to a point.
It is like this.
Serial number
What is the agreement of the third respondent? Is the third respondent?
Yes, he's not appeared.
No, the third respondent with the actual owner, whether it is a time charter.
Then what is the
that
question?
is a no. First of all, to maintain the application, what is your nature of your this thing? That is important.
No, no, no. Insofar as that is concerned.
So when you're seeking arrest of the vessel, we are on. Let's forget about that agreement which he has filed.
Yes.
Between him and the third respondent, the disponent owner. But what is between you and the disponent owner, that only gives the jurisdiction for this court.
Oh no. Lord, what is the nature of the right that the person who has handed over the vessel to me is, what is the question? Either he's the owner. If he's the owner, there's no issue, my lord. Straight away,
Yes.
he's given it to me, I can sue him for not carrying out certain things. If he's demised it to someone else, then that demised owner gives it to me on a time charter.
Yes.
Now that's
So
the
that
second
is
part.
relevant. That is relevant for this application.
Yes, yes. I'm answering that. Therefore, my lord, first is the owner, the demised charterer, and then the time charter.
Time charter.
There's no dispute about the fact that between us, it is a time charter. The question, Lord, is between the owner and the third party, that is respondent number
They are
3.
pausing there. You are the one who has come to the court. Yes. To exercise the jurisdiction under section 5.
Yes.
Now the relevant factor here is what is the nature between you and the demised owner of the said.
Correct.
That is a time charter. We are not concerned with what is there between that, your demised owner and the original owner.
Oh no, that is where it is relevant. If, my lord, that person who has demised it, let's say, my lord, respondent number 1, who is the owner of the vessel, has demised it in favor of respondent number 3.
Now that will come to it will be beneficial to the demised owner when there is a dispute between the demised owner and the original
My
owner.
lord, the nature of the right that he exercises over the ship,
Hmm.
that becomes the relevant fact.
Correct.
And if he exercises an owner as a demised charterer, the fact, my lord, that I have a time charter does not make a difference. The fact that he exercises those rights, in my humble submission, makes the difference.
So let's
What
read-
they are now
no,
doing
let's read
is,
section 5.
yes, Lord.
Let's read section 5.
Yes, yes, Lord. Can I?
Yes, please. Yes.
5B, my lord. May I just read 5, the one first? The
Yes.
High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject of an admiralty proceeding, where the court has reason to believe that the demised charterer of the vessel,
Now we read that. The
yes,
person.
B, the demised charterer of the vessel at the time when the maritime claim arose is liable for the claim. Therefore, if, my lord, respondent number 3 is the demised charterer of the vessel, at the time when the maritime claim arose, liable for the claim, and is the demised charterer or the owner of the vessel when the arrest is effected. The character of the right that is exercised by the person who is giving it to me is the only relevant factor. Therefore, if the character of the right that that
So
person,
now you are disputing the particular document, saying that he is not the demise charterer of.
I'm saying, my lord, he must be the demise charterer.
He is the
He is
demise.
the demise charterer. They have now, for the first time, in an additional affidavit, suddenly produced a document before the court saying, and your lordships can see, as your lordships can see this document, anything can be produced, anyone can sign, anything is possible. And your lordship, and please see the expressions used in various parts of this, they call himself owner. He calls himself the owner. If my lord sees in this, he calls himself the owner of the vessel. Almost identical to say, I'm a demise charterer. Therefore, the character of the person who has given the vessel on hire is not relevant for the purpose of assuming jurisdiction. Now, please see the document. How does it come for the first time, Lord, after the objections are filed? Objections, none of that is said. For the first time, they say, oh, but we also only gave it on a time charter to him. And because he only had a time charter, therefore, there's no question of demise. I did not, that is basically he's saying respondent number 1 did not demise it in favor of respondent number 3. And therefore, what I have only given time charter.
Even while filing a petition before this court,
My lord.
and when you're saying that the court has to pass an order under section 5,
My lord.
that's your pleading shall
Lord,
contain.
Now, my lord,
And
please
you
see
should
the
prima facie, make out a case for arrest.
yes.
That can be exercised only in case, as you say, it's a demise charter.
Yes.
Where is your plea that
That is there in, according to me, the document itself.
No, you never said so.
No, I've not said it, my lord, in my pleading. But if your lordship sees the document which I produced before the court, he represents himself as the owner of the vessel. Please see the manner in which it is said.
Come to page 70.
70, my lord. Please see, witnesseth. After Continental Dry Bulk as disponent owner, he says, witnesseth that the owners agree to let and the charterers agree to hire the said vessel from the time of delivery for time charter of 6 months, more or less, in charterer's option. Trading always afloat, always accessible, always within so and so, with so and so assistance. Then, my lord, will kindly come to item number point 34. That the owner shall provide and may pay for all provisions, wages, consulars, shipping, and discharging fees of the crew, shall pay for the insurance of the vessel. Then 2, charter shall provide. Then, my lord, will come further down at 46.
So this agreement do not contain what is the nature of the ownership of that.
It doesn't have it.
No, need not contain whenever the agreement.
Strictly, one may argue, my lord, that it should have at least a declaration that I am only a time charter. I am further giving you a time charter, which is what has been done by saying, or what they are arguing is, I have a time charter. I am allowing someone else also to have a time charter. And in this document also it says, you have a time charter, you can then give it to someone else.
Disponent owner of the goods.
Lordship is right. It's in the agreement itself. It is stated. Let my friend say otherwise. This agreement says who the owner is and who's the charter.
Let me point it out.
Where do you get that?
My lords, if my lord sees page 93 of this document of his petition, just so that my lords we are clear. He's not showing representing himself as the owner, as my friend indicated. Just see, my lords, in CP chain, the lordship finds it in the middle of the.
That anyway we all know that
head owner CS Flourish to disponent owner Continental Dry Bulk, head owner CS Flourish.
That is there, but that does not say what is the nature of the demise made in his favor. It does not say I have given a time charter to him. He is giving you a second time charter. You can then give a third time charter to someone else. That is how it works.
That's a burden.
No. Burden is no. Now, my lord, there are 2 parts, which is why I am respectfully saying, ultimately at the end of the day, given the nature of the circumstances surrounding this particular case, your lordship will have to see as to the conduct of the parties. But otherwise, it was a straightforward issue. The first thing they would have come and said is, I have only given a time charter. Where is the question of a demise? There is no demise in his favor, in favor of the person against whom you have a claim, and therefore you cannot make a claim. You must raise the ship. That is not the first answer he has given. All of that comes in this additional affidavit. Now, please take the additional affidavit.
First affidavit, what did she say?
No, this issue
what
was
about
not
the written
raised.
statement or objection?
Yes,
Where are the objections? Let's see.
I have one.
Statement of objections, not on behalf of respondent number 1. Please see this.
For IA1, sir.
IA1 objections ಹಾಕಿದ್ದಾರೆ.
Petition ki objection.
Petition objections, yes.
Objections to the main petition.
It is dated 21/10/24.
What is that?
I think your objections to the main petition.
All the documents of the petitioner one side, all application of the respondent
It's a-
in one compilation. I think that would be,
Easier, my lord. Yeah, I understand.
it's very difficult to find out this when this these many. Fingers. No, it is their second volume.
ಇದು ಅತುಲ್ ಮಾಧವನ್ ಅಂತ ಹೇಳಿದ್ರು ಅಡ್ವೊಕೇಟ್ 21/10/2024. In sum, my lord, what he says is there is no claim against me. The claim is only against respondent number 3.
He never says in the entire.
No, I don't think so.
objections.
I've seen it. I don't think he says that
Mr.
specifically.
Counsel, I will not state it in the objections that that it's.
I'm just looking.
It's a demise charter.
I don't want to make it off the cuff. Let me just give me 2 minutes. I'll look.
Because that's an important aspect, yes. Which at the first go has to be stated, if that is so. Or can you just forward your?
Yes, yes. Do you have a?
Yes.
I have a.
Yes.
Give it to me. Open it on your system. Give it to me. Lord, may I kindly see the headings. The headings make the answer quite clear, my lord. 6.1, plaintiff has page, I think 4, my lord. 6.1.
No, para 3, he says, the petitioner has no claim against.
Contracts to otherwise.
To answer the court's question, my lord, this is same as the I. This was filed on the basis that the petitioner has failed to make out a case against me.
I see, I understand. We're just pointing out this issue, nothing else. Not.
All of them were filed at.
All
one
same.
go.
Yes,
IA
yes,
number 1
yes,
and,
yes.
All objections are filed together. They are all similar in terms of
That is why, my
language.
lords, this document, my lords, was what?
Objections filed first. This claim, everything depended, my lord, on the statement that there is no claim against me. That's his entire stand. 6.1, my lord, lordships have.
Yes, yes. There is no privity of contract.
Privity of contract. Then, Lord, B, liability is not of the registered owner, but of respondent number 3. Then at point 6.2, respondent vessel cannot be arrested for an alleged claim against respondent number 3 because they are not a party to the time charter. That's the argument. Then, my lord, 6.4, Russian proceedings.
Well, let me stipulate it's not there. It's not there because they never in their petition asserted that their claim is against a demise charterer. It is only during the course of arguments here that they are now suggesting that respondent number 3 is the demise charterer. Their case all throughout.
No, this is filed when?
This is filed
24.
Okay. And your IA number 1 is also same.
No.
date.
IA number 1 is filed in January.
That also had the same
Yes,
pleadings.
yes, I must, my lords, as I am here as an officer of your lordship's court, I must state it very fairly. But my IA and my statement of objections are identical.
All right. Now
The only reason why we have not stated this specifically, because my lords, the case in the petition is.
No,
You
in
put
IA
forward your
number 1,
case.
1 month.
I'm
IA
so
number 1 you have stated about that it is not a demise charter and hence.
not an IA number 1.
IA number 1 has been taken out on the premise that there is no privity between the applicant, that is the owner, and the petitioner.
Then why you, just like that the document is placed?
No, it is during the course of argument before Mr. Chinnappa came, my lord, it was sought to be suggested that it is a demise, that it may be a demise charter. They do not specifically, that's why the court put that question to him. Have you specifically pleaded that respondent number 3 is the demise charter? They never pleaded that. So therefore, I had no occasion to suggest otherwise that he's not to clarify this position that whether he's a time charter or a demise charter. It is only during the course of argument that was sought to be, my lords, to obviate any further things, a document has been brought ahead. Otherwise, they have not brought any material on record to show respondent number 3 is a demise charter.
Any objections are filed to that?
No.
The affidavit, we've not filed any objection specifically. I'll place an affidavit on
When
record.
was that?
This was
When
filed,
did
my lord,
In
but we've stated so in our submission.
March.
March.
They took time on this ground. Ms. Bhatt will confirm that we want to take instructions. In fact, on this ground, the court adjourned it to take instructions on this document and have not filed an objections thereafter.
No, before going into what the defendant are going to say, it's for the plaintiff. You filed a suit and you wanted an interim order or
Yes.
an injunction, arrest of the ship. You have to prima facie place before the court with all this. Admittedly, you are a time charter. Now it is.
There is no
it-
dispute.
Nowhere it is stated that the disponent owner is a demise charter. As such, under section so and so of the act, this court has jurisdiction to pass an order. That is nobody's case. So without a prima facie case made out by the plaintiff, why should there be an injunction or an arrest?
No, my lord, it is this way. my lord. Now, the point is we have now come down to ultimately an issue as to whether this charter or the person or the demised owner of the vessel was demised or not. For which, my lord, this is not an argument advanced by the other side.
Nobody's case.
No, my lord.
It is nobody's case.
Respectfully, the second.
Things in that regard. Now, if you have taken a particular stand, there is an occasion for them to file a reply adverting
Lord,
to those.
I would think, Lord, it is in a case of this kind, it is necessary for the defendant to place his entire case when he files his objections. And also to say as to what is the nature of the contractual relationship between the respondent number 1 and the respondent number 3. Because that seems to be now the most important question that is arising.
That's an important question, yes.
That's the only question really that they're arguing, nothing else today. Only question is that. But they did not think it necessary to place it at that point in time before the court. There has to be some good reason. The good reason has to be, in my respectful submission, that this document, Lord, did not exist at the contemporaneous point in time. Because even in the Russian court, Lord, this is not the position taken.
No, assuming that he was not there, you were before the court.
But
and
now,
on
my
the
Lord,
day
please see this.
That arrest order was
These
passed.
are, if I may, I understand what has not been stated. We have stated it, my Lord, that there is a charter in their favor. We have said so.
Never saying what is the relationship of that. And you
Lord,
know
it
that
is- it is an-
a third person is the owner of the property, owner of the
That we have
vessel.
said.
Third is the disponent owner.
Yes.
What is the nature of the disponent owner or the agreement between the original owner and him? It is for you to say. Unless and until you say that, this court
I-
cannot pass an order.
Lord, may I just point it out this way, Lord? These are all commercial transactions which are there where parties do not disclose the nature of the right that they have to us at the point in time the transaction is entered into. Suppose, my lord, we have that information and we don't place it before your lordship, my lord, I can understand. But that is an information which is exclusively within their knowledge.
No, the arbitration is going on in UK.
Yes.
And before the arbitrator, all the documents must
Not,
have been
not yet,
placed.
not yet. The claims are, claim is yet
And
to be filed.
already one application is filed there and
No, my lord.
for arrest of the ship.
This
That
document is
was
again not
dismissed.
there.
That was dismissed.
No. Then appellate court said I would have been entitled to the relief, but because the ship had sailed, relief was not granted by the appellate court. Therefore, my lord, this is not, in my humble submission at least, as clear as my learned friend wants to try and make it out today, saying I have now produced a document. That document also is a time charter. Therefore, what you got was also time charter. So,
But it appears that we are putting burden on the defendants,
no,
not
no,
on the plaintiff.
no, lordships, no. I can only say AR, my lord, 1968 Supreme Court 1413. Supreme Court said whoever has the best evidence in their possession must place it before the court. Now, if I have that evidence and I don't place it before your lordship's note, I am to suffer the consequences of not placing it.
And at the same time, plaintiff has to succeed on the strength of his own
On
case.
his own case. Now, my lord, that of course, there are two parts to it, if I may say so. The first part, my lord, is at the interim stage. The second part, my lord, is at the stage of when your lordship consider it finally. Now, if
For the interim stage, we are on a
interim stage. Now, today, my lord, your lordships have two sets of our documents and their documents. It ultimately boils down, in my respectful submission, to conduct, because their entire case, as my learned friend will appreciate, is on the basis that there was no right given to the demise charterer of the kind that is protected under 5.1b. Therefore, there is no right that he could have given you, and therefore that contract is simplicity a time charter. That is, if he says today, the entirety of his case, to get, I ask myself, if I were in his place, what would be the first thing I would do? I would say that the person did not have a right. How could he give you any other right? Therefore, this proceeding was not maintainable. That's the end of the proceeding. But they don't do it in their objection statement. They don't even mention it in the objection statement. They wait until your lordships ask a question. And then it almost like a light in their mind crops up, my lord, saying, oh, now I can raise this new contention. And then suddenly a time charter comes into existence. Which is what I'm respectfully saying. Please see that document as to how it suddenly comes. It was not there at the otherwise, I would think as a lawyer or as anyone else, the first thing I'll place is that document and say, I did not give a demise to anyone. Mine was a time charter. Where is the question of that person making a claim? That is the end of the case. You must put on.
No, as you say, let us take it that this is all matter of trial, whether such an agreement is there or not. Now, even for granting this, the court has already granted the interim order, as you saw, for the arrest of the ship.
Yes.
And just forget about what are their contentions. We have to look at what is your case and whether this court can pass an order under, and at least if you had taken a plea saying that it is a demise charter, whether it is a demise charter or not, it is for them to explain at a later stage. That you have to say. Where did you say?
Well, of course, I have not used the word demise anywhere. I should straight away tell you, Lordship, is not there. But what has been said,
charter in the owner, when he is not the owner, when he is not the owner, when he is a disseminate owner, then why should the court come to your rescue?
No, a demise, a person who has a demise is also a disponent owner. The expression disponent owner does not make any difference.
But it has to be.
Therefore, my lord, the nature.
When the act is very specific about the nature of contract between
what we have said, one paragraph. Lordship may make note of that paragraph. Para 13.
Para?
13 of our petition.
13 of the petition.
Yes. The registered owner of the, I'll read it. Lordship may not have to trouble yourself. Registered owner of the vessel chartered the vessel to respond number 3. That is the specific statement made, because I never claim that the person who chartered the vessel is the owner. I never said that, because I have specified as to who the owner is. Because CS Flourish has made a party. And I've also produced not the document which shows that the owner is one particular entity. CS.
And while granting the interim order,
yes,
if you are not, if you don't take into consideration that Section 5 and all the proviso to Section 5, then now what is a relief in rem or in person?
Now, my lord, what happens is, of course, an interim order is granted by your lordships after considering not the case that was placed before the court. The court felt that there was a necessity to grant the relief, and then a ship was arrested. Then the ship was released on the provision of security. So now, my lord, the ship has been released. Now it is only the question of whether the security must be released or not. Therefore, today the ship is not in the port, nor is the ship under arrest of the court, because someone has given security for the entire value of the claim, and therefore the ship has been allowed to sail. Therefore, today there is no arrest issue.
No, as far as the issue with regard to this demise charter or not, for that, because you are not sought for any other relief in this, except the arrest of the ship. And it is this case that this entire amount of so and so crores, and without there being any liability or responsibility or any legal obligation that has been given as a security. So to decide that aspect, nothing else has to be decided in this. There's the only issue.
You'll have to prove that. No, today, my lord, they'll have to prove that document. The document that has been now placed before you, normally, my lord, if it is registered with some authority, I mean entitled to get it from that authority and show your lordships will know that this authority has registered or it is before some authority. Today, it is simpliciter document signed. At least, in our cases, what happens is in India, there'll be a stamp paper. Stamp paper will have a date. So at least you know when it was signed. Today, that also can't be done. This is simplicity on white paper. Anybody at any point in time can sign any document and place it before your lordships.
What do you say?
By this logic, my lords, their entire case should be dismissed, because anybody, the charter party between them and respondent number 3, anybody can come and create and then come to the court and say, give me relief, ex parte relief order of arrest.
There's an arbitration going on.
Generally, in these cases,
my friend just said that there is no statement of claim filed.
No. In these kind of cases, how do you prove the agreement?
Exactly, my lords, at an interlocutory. This is why, my lords, I cited the Bombay judgment. The Bombay judgment at an interlocutory stage says that look at the plaintiff.
No, the court's query is how do you prove generally
a document of this nature at an interlocutory stage, only on the basis of documents.
It's not an interlocutory stage.
In finally,
provided in a trial.
Like any other document. Like any other document. The point, therefore, my lords, in this case is, my lords, my entire friend's contention is that this, look at the timing, look at this. The fact is that the petitioner comes to your lordship's court showing nothing on the basis of which he claims. Firstly, he does not plead that respondent number 3 is the demise charter. He does not bring a single document to show respondent number 3 is the demise charter. There is one document which the applicant produces to show that he was a time charter, not a demise charter. He says, don't believe that. So believe what? You don't have a document to show respondent number 3 is a demise charter. You don't even plead on oath that he's a demise charter.
You don't deny the fact that this time charter exists. Therefore, where is the question of you making a statement that the time charter doesn't exist? You've not made a statement.
It is his case that he's a demise charterer.
No,
without
the
even
time charter between
and
respondent
without
number.
producing a single document to show that.
How, my lord, I ask myself, it's all very easy to say. Is it something which is available somewhere online or in the public
Therefore,
domain?
the basis of arrest
Therefore,
is
my learned friend
conjecture.
can't make a statement. One second. Therefore, my learned friend can't make a statement that I should have produced some document which I don't have. If I have a document and I don't produce it, I understand. Ultimately, my lordship, your lordship will have to examine whether or not I have made that statement. What was the stand of the respondent when he first filed the objections? And it seems to me from the affidavit, when your lordships ask the question as to what is this concept of a demise charter, because that's how his affidavit proceeds, then he says, oh, but it is not a demise, it is a time charter. That shows, my lord, in my humble submission, a change in his approach in the entire case, only to ultimately find a way out of getting out of this difficulty. And that, my lord, is in my humble submission the answer to the question as to whether trial has to go on this question. Because ultimately today, all I would say is, what is there? There is a security given, and that is in money. It is not like the ship is still under arrest with this honorable court, and therefore he cannot utilize the ship. Ship is gone. The question is whether that money can be utilized, and that is the only issue which there is today. Money, of course, not I can't take today. Money can be taken, and the trial possibly will also be.
No, and how can he give security for?
That can be. If he's a demise, if there's a demise, he can give security.
No, that's again another issue.
Yes, ma'am.
I number 1 is for the vacate. I number
4
is
for, my lord, security for cost.
Security is, he says he's
I
in the alternate.
I number 4 and your IA is?
I am allowed 5 for amendment.
I number 5 reserves for orders.
We file.
Just on second.
We file a written submissions by.
File your list.
I'll file right now.
Yes.
It's ready. We'll file it with some judgments, bro. There are some judgments which I'm just placing on record, which I've cited.
My friend may give us in advance so that I deal in my written submissions, because otherwise I will not have the benefit of those judgments.
What I've cited.
What my friend has cited, certainly.
Now, for that matter, my learned friend gave me several judgments. Now I can't deal with it in my written submission, which is already ready. So
no, I understand. I have no objection with my friend.
There is only one additional, I think.
Matter on second for reserve on second for orders.
Yes.
Yes.
I cannot thank the court, my lords, for giving us this indulgent and hearing us this patiently. We are extremely obliged.
Yes.
Maybe just file it tomorrow.
We'll both file tomorrow and
Both of you can give it to the court office.
Yes,
we'll give it. I'm very grateful. Very grateful.
Yes.
Oh yes. Thank you.
Which number? 1, serial number 2, parted matter, serial number 2. Short.
I'm sorry, just one aspect. My lord, IA number 3 is for amendment. It is only to bring on the record my written
I
statement.
number 1, 3, 4 and 5. Yes.
Serial
Pass
number
over?
2, short.
Yes, pass over. Next.
Serial number 3. Serial number 3.
Give that.
Harish Ayan. Without cover, narrate, not receive.
Give the file. Pass over. Afternoon, no representation, then we'll dismiss.
Yes.
Yes,
Serial
next.
number 4.
Lord, I am for appellant, my lord. The claimant's appeal for enhancement as well as on negligence. My lord, it's an accident between a motorcycle where the claimant appellant was proceeding.
Oh,
and
no,
the
It is only on the negligence part.
no enhancement. Yes.
They are seeking enhancement, but it is not fit case to enhance the compensation. Negligence aspect is concerned, they are prepared.
Let's go to that particular.
My lord, on issue number 1, my lord, facts of the case is, my lord, he was driving his motorcycle and car. My lord,
Please read the paragraph.
my lord, the finding of the tribunal is, my lord, the road width of the road where the car was proceeding is 40 feet, and in the junction where the motorcycle rider was proceeding on 20 feet width road. Only on presumption that the car is coming on the right side, and on the since the road is widened, that is 40 feet, it is considered as a main road. And my lord, the 30% negligence is fastened on the rider of the motorcycle. My lord, the respond number 1 being the owner of the vehicle, even though appeared before the tribunal, will not choose to enter into witness box. No rebuttal evidence is allowed. The charge sheet is filed against the driver of the car. Well, under these circumstances, even in the absence of rebuttal evidence, well, my respectful submission is the presumption of the tribunal to the effect that since the car was proceeding on 40 feet road, and the road is comparatively small where the motorcycle was proceeding. But only on that presumption, but they come to a conclusion only on a presumption that the rider of the motorcycle is negligence to an extent of 30%. That too in the absence of rebuttal evidence. That is wrong, my lord. 5,25,800 amount awarded. Out of that, 30% is deducted.
You say on this?
Pardon?
The reasoning of the court.
Please.
You should have stopped, then you should have gone.
Correct. But what may respect 30% negligence may not, but he is also contributed to some extent. So some extent of contributed negligence to be taken on.
5%. Then what
My
about
lord, as far as quantum is concerned, may I go to quantum, my lord? My lord, date of accident is 2013. So as per chart, 8,000 is required.
how many are the injuries?
My lord, compound biomellular fracture of right ankle with dislocation, my lord. He was treated in private hospital for 2 days.
40,000 is reasonably granted. Medical
My lord, open reduction internal fixation was done. It is still in situ. It required removal. So, my lord, he required.
Mrs. Shripad Shastri, the difficulty with this virtual hearing is you are not able to hear what the court is asking.
No, my lord, I am hearing the court, my lord.
So, how many days he was in hospital?
2 days, my lord.
Court has already granted 15,000. No enhancement is required.
But I have no issue. As far as quantum is
Because
concerned,
court has to look at the chart. As you know, every day how the calculation is made. So you have to come to the chart. We look at it.
Chart as well as the disability aspect. As per Dr. Malad, 17%.
Coming to the loss of income. Which
income, my lord, required another 4,000 rupees on that count.
Which
only 4,000.
Please, madam. 2000.
2000?
2013, 8,000.
Yes, 8,000 is the income required to be considered.
Trial court has considered how much?
7,000. My lord, as far as disability is concerned, 17% the whole body disability. As per the doctor evidence, 15% is considered. It is required to be considered 17%. If it is so, my lord, I am entitled another 1,84,464 on that count. No other heads, my lord.
What is the multiplier?
18, my lord. 18. The future prospect not added, my lord. 17% to whole body
No,
disability.
he is not entitled future prospect.
Well, 40% is required to be added. He is aged only 20 years boy, my lord.
Comes to 5,77,200.
Please.
In that, to
5%.
what is payable is 5,48,340.
Please.
Please come. Agreed with award passed in MVC number 4826 of 2013, dated 25th September 2015. The claimant is before this court seeking enhancement of the compensation as well as questioning the contributory negligence fixed at 30% on the claimant. The claim petition is filed seeking compensation of an amount of rupees, seeking compensation for the injuries sustained by the claimant. It is the case of the claimant that on 12/8/2013, about 9:30 a.m., the claimant was riding his motorcycle at 9th Cross, Wilson Garden, Main Road, Bangalore. At that time, Sancho car, driven by its driver in a high speed, came in a rash and negligent manner and dashed against the motorcycle. Due to that, he fell down and sustained grievous injuries all over the body. He was taken to the hospital. It is this case that he has spent huge amount for the injuries for the treatment. And as per the evidence of the doctor, he had sustained 15% disability to the whole body. The court had taken 7,000 as the income and granted the compensation as per the table given below. That is, extract the table at para 12. And the court had fixed contributory negligence at 30% on the claimant. The court has observed that
Owner has filed the written statement. Owner has filed the written statement containing that he came and dashed against that. There are 9 written statements.
that the court has observed that filing of the charge sheet against the driver of the car does not come in the way of the court to hold that the claimant was also negligent and contributed to the accident. It is stated by the claimants, the respondents, that a separate case is registered against the claimant, but no document is produced by them to substantiate their contentions. There is nothing on record to believe that the police have filed charge sheet against the claimant in respect of the said accident. under those circumstances. And further, as per the motor vehicle rules, the claimant ought to have given way to the car to proceed further, and then he should have proceeded on his way. Damages caused to the vehicle indicate that the claimant has dashed the car on his front left portion. The brake system of both the vehicle was in order, and accordingly, this contributed negligence on at 30% on the claimant. The land council, land council appearing for the claimant submits that the court, without any basis, has fixed the contributory negligence on the claimant at 30%. It is submitted that the police records clearly reveals that because of the accident of the opposite vehicle, the accident has happened. Then when it comes to the compensation, it is submitted that the court had taken the 7,000 and it ought to have taken the income at 8,000. It is further submitted that towards the loss of future income, the court ought to have granted future prospects considering the age of the claimant. It is submitted that even the compensation that is awarded is also on the lower side. Next, for having land counsel appearing for the respondent insurance company submits that the court has rightly passed an order and no interference is called for. Next, for having got the counsels on either side, produce the material on record. Under the head of pain and suffering, medical expenses, nourishment, the court and the medical expenses, court had future medical expenses. The court had rightly granted the compensation. No interference is called for. Coming to the loss of income, considering the fact that this is an accident of 2013, this court is taking the income at 8,000 into 4. It comes to 32,000. Then coming to the loss of future income, the submission of the counsel that future prospects needs to be added. This court is not accepting the said argument. 8,000 into 12 into 18 into 15 is 2,59,200. Coming to the loss of amenities, this court is granting 30,000. In the light of the law laid down in vehicle houses so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 5,77,200. Then coming to the contributory negligence, this court has perused the order passed by the court and the reasoning given by the court. This court is agreeing with the reasoning that is given by the court, but however, the fixing the contributory negligence at 30% is on the higher side. Hence, this court is fixing the contributory negligence at 5% on the claimant in view of the same. The insurance company is liable to pay an amount of rupees 5,48,340. The enhanced amount shall carry 6% interest. Yes, next.
Cell number 5, Veeranna G. Tigri for appellant. Ash Shashikumar.
For a respondent number 1.
This time may be granted.
This petition is filed in the year 2017. Till today, they have not paid the process. My voluntarily filed the wakalat.
All complaints of office objections raised on PF, that is advocate has to furnish to issue notice to R4 for first time. If you are not interested to pursue, we will dismiss it.
2 days time may be.
Finally, 2 days time is granted to pay the process, or else the appeal shall stand dismissed without further reference to the court.
Directed them to furnish the copies, my lord. I voluntarily filed the wakalat, my lord.
Within 2 days, the copy of the appeal memo shall also be furnished to the counsel appearing for respondent 1 to 3.
Please, my lord. After vacation, any date may be fixed, my lord. After vacation, any date may be fixed.
It will come after vacation.
Please.
What is the purpose of posting this matter? Once the notice is served, it will come.
Please.
Yes.
Cell number 6.
Yes.
Shankar Gaudji. R.
I'm representing Shishidhar.
Who is
Filed
appearing?
wakalat. NOC wakalat on 22 January 2015.
When
25.
so submits that, he has filed the NOC wakalat. And what is the insurance company?
Reliance General Insurance Company.
Yes, Mr. Shavanagoda, you appear? Reliance.
Pradeep.
Mr. Pradeep is directed to take notice.
Notice to R1 make and
And the council shall serve the copy of the appeal memo. Memo is filed seeking dispensation of notice to R1. Dispense with the risk of appellant. Yes, next. The memo of retirement filed by so and so taken on record and is permitted to return, and the other counsel has already filed his wakalat. Yes, next.
Sale number
Delete from the
7.
caption for dismissal.
Yes.
Next, 7.
7. Sale number 7.
Yes, give that. Why is it listed for dismissal? Look at it. Where is the order? It's not in dismissal. No. The counsel for the petitioner is permitted to take out notice, permitted to take out hand summons on the counsel appearing for the respondent before the trial court, and shall file a memo to that effect by 9th of June. If the same is not filed, the stay granted by this court stands vacated. Next.
Sale number 8.
In this also, hand summons, memo by 9th of June, or else the stay is there,
Stay is there, my lord.
granted by this court stands vacated. Yes, next.
And Shara has come as
number-
not claimed, my lord.
Huh?
Shara has come as not claimed. I've taken it in the last.
The 8, as per the postal sheriff, no, the earlier order, you remove that order. As per the postal sheriff, notice to the second respondent returned unclaimed, which amounts to deemed service of notice. Give that.
Sale number 8.
Yes. Taking transfer from where to where?
From Pandupura, Mandya to Bangalore, my lord.
Mandya to Bangalore.
Yes, ma'am.
Distances?
100 kilometers, more than
Which year
100.
is the MC?
MC is of the year 2000, 2022, my lord.
When was the stay granted?
Stay granted on, stay granted 21/4/25, I think.
The present petition is filed seeking transfer of MC number. Present petition is filed seeking transfer of MC number 44 of 2022, which is pending on the file of the principal senior civil judge at JMSC Pandavapura at Mandya to the family court, Bangalore. The facts of the case are: the marriage is solemnized between the parties on 1/5/2015. At Ganjamhalli, Srirangapatna Taluk, Mandya district. In view of the differences between the parties, the wife had left the matrimonial home in December 2020. The respondent has filed the petitioner has filed a case against the respondent under section 498A. In that regard, a crime was registered. That is crime number 147 of 2020. And the police have filed the charge sheet, that is CC number 15597 of 2021, on the file of the 37th ACMM at Bangalore. After this, on 23/11/2022, the husband has filed MC number 44 of 2022, seeking divorce. Then the notices were received on her on 22/6/2024. Thereafter, the present transfer petition is filed. When counsel appearing for the petitioner submits that the distance between both the places is about 150 kilometers and it's difficult for the wife to travel, it is submitted that already the criminal case is pending before the courts at Bangalore, and to attend the case, the husband has to come to Bangalore, considering the submission of the learned counsel. Next, though notice as per the postal sheriff, the notice to respondent returned as enclave, and this court held that the notice to the respondent sufficient. Next, for having heard the counsel for the petitioner for his material of record, considering the fact that already a criminal case is pending on the file of the family court at Bangalore, and the distance between both the places is more than 150 kilometers. This court deems it appropriate to allow the petition accordingly. So and so is withdrawn and transferred to so and so. Yes, next.
Cell number 9, Ajay Kumar T.
What is this non-compliance of office objections?
2 days time may be granted.
2 days time, or else the petition shall stand dismissed.
My lords may kindly grant a date, my lords, this week I will comply.
Huh?
The lordship may have it on Wednesday, my lords, I'll comply.
2 days, if the objections are complied with, list the matter, or else the petition shall stand dismissed.
Cell
Yes,
number
next.
10, Ajay J.
Post after service of notice.
I appear for the petitioner in this, my lords. Services awaited to all the respondents. In the
What
meantime,
about hand summons? This court has ordered for hand summons.
I'm in the midst of serving it to them, my lords. I'll file a memo to that effect.
What is this
having
matter
served-
after vacation? Yes,
My
next.
lords, the date may be fixed in June, my lords.
Look
First,
at If in all these matters, any of the matters interim order is there, extent.
I am for the respondent in this matter. I praise 2 weeks time to file the objection. Your
It is
Honor.
submitted that so and so has instructions to file wakalat. This is matter after vacation. Look at it. If interim order is there, extended.
Cell number 12,
Yes, 12.
12, Sridhara Murthy.
In the earlier matter, calculation. Yes, 12. Yes. Await service of notice. You filed the
Yes, sir. Ma'am, it is. We have served and filed.
hand summons. Look at it.
12.
It is submitted that as per the orders passed by this court, they have served the hand summons and filed a memo to that effect. It is stated that they have served the notice to,
Council trial.
what is the name? Who is the advocate?
One.
Your memo should contain, I'm repeatedly telling all the
Prakash.
advocates,
Satya Prakash.
where from the court has to infer that. Write it, pass over, give the memo to him. Next. Yes.
Cell number 13, KK Vasan.
Lord, in this, respond number 1 is a minor.
O Mahesh.
And I have chosen made her father is ruled by the guardian. And I have taken notice to the father. On the last occasion, came up before the Sound Court because the notice sent by RPD is unclaimed. I have taken notice to the guardian himself. So
That is unclaimed.
that is also unclaimed.
Where is that?
Lord, that is there in the cause list.
Then what is to be done now? It tells you such should be considered as a deemed service.
Yes, Mula. In this case also, in next case also, both the minor and the father both are parties.
So minor is represented by the father.
Father.
The notice is served on the father.
I have served on the father. I have sent the
In
notice.
MFN in 13. In 13 and 14, same order. The notice sent to R1, that's the guardian of R2.
Yes, no, the respond number 1, represented by her father.
The notice then sent to R1 in both the cases, returned as unclaimed and amounts to deemed service of notice. IA 1 of 18 is filed, you are the owner of the vehicle.
Yes, I am the owner of the
IA 1 of 18 is filed to condone the delay of 217 days in MFA 2281. And in MFA 2282, it is triple to 222 days for the reasons stated. The delay is condoned. Admit post of final hearing.
Cell number 16.
What is this IA 4 of 18 for
Additional-
appointment of natural guardian?
That is so far minor is concerned. Minor is concerned, I have made an application to appoint her father as the guardian.
In MFA.
In MFA, there also they were actually my guardian. In the,
Why another application is required here? That I'm not able to understand. Cause title contains that so and so
yes,
represented by father. What is this application? And what is the necessity for this application?
well, let the application be pending. Lord.
Number 4 of 18 is filed for appointment of natural guardian. Already father is representing the son. In both the cases, IA number 4 of 18 is dismissed.
Cell number 15.
Yes.
Cell number 15. Arnav, Bagal, vide.
See, for the petitioner shall take steps for issuance of notice to R2 within 2 days, or else the appeal against R2 shall stand dismissed.
Cell number 16. Cell number 16.
I appear for the appellant, my lord. On the last date, your lordship was pleased to pass an interim order, my lord. And also it was ordered to serve the copy through hand summons, my lord. On 6/4 and 9/4/2025, we tried to serve it to the respondent advocate in trial court, my lord. However, it was rejected by the advocate. Thereafter, my lord, we sent this through registered post, my lord. That also I have attached.
That is?
Registered post, my lord. We sent it through. That was delivered, my lord.
That is?
Petition copy.
What has happened to the registered post?
That also delivered, my lord.
What is saying?
That has been delivered, my lord.
That is delivered.
Delivered, yes.
But there is no such order to you to take a registered post. Furnish the within 2 days, the petitioner, the appellant shall pay the process in respect of respondent number 2, respondent to the sole respondent, or else the appeal shall stand dismissed. Yes, please.
Cell number 17.
The order is on 21, my lord, to serve the copy to the council. Lord, I have served on the.
So what is this recalling the order?
Recalling the order, my lord. There is order dated 21/3, my lord. There is a direction to serve to the trial court council, my lord. I have served it, my lord, by oversight, my lord. This has not been submitted to this honorable court. They served this one. That acknowledgement also I have submitted now. That through WhatsApp I have given, and he has acknowledged it. He has undertaken to file wakalat also, but it is not.
No. 21/3/2025.
Yes, please. Yes, please.
Petition is permitted to take out hand summons and
Yes,
shall file a memo to that effect by 8/4,
Yes,
or else
please.
the petition shall stand dismissed.
Dismiss, my lord. My lord, actually, I have taken the process and I have handed it by WhatsApp. I have sent it and he acknowledged it. But subsequently, I could not file the document along with memo by oversight within 8th, my lord. So, therefore, it is deemed dismissal. Therefore, I have filed.
Where is the memo now?
My lord, I have filed the document. I have filed the another one document.
The present, the IN number 1 of 25 is filed to recall the order dated 21/3/2025, whereby this court had permitted the council to take out hand summons on the council appearing for the respondent before the trial court, and to file a memo to that effect by 8/4/2025, or else the petition shall stand dismissed without further reference to the court. It is submitted that they have already taken they have sent it by WhatsApp. When the court says hand summons by WhatsApp,
My lord, hand summons also I have sent it through WhatsApp and he has acknowledged that I have received
hand
it.
summons, where is the hand summons?
My lord, I have produced
And
documents.
also, they have sent the hand summons also, but they have should not file the acknowledgement. Considering the same, the order dated 21/3/2025, with regard to the dismissal of the petition is recalled. Where is that memo?
My lord, it is another
Accordingly, IN number 1 of 25 is ordered. Give that.
another separately I have filed.
What is the name of the advocate?
Dastagir J. Dastagir J.
Of the hand summons to the advocate of appearing for the respondent. The registry is directed to print the name of Dastagiri.
Dastagir J.
Dastagiri.
Dastagir J.
Write on a paper.
Yes,
and give
please.
her-
Yes, please.
Yes. Intermodal is there.
Intermodal, it was a lapsed earlier. No?
Huh?
It was lapsed 2 years earlier.
Let it-
Please.
This list after vacation.
Your lordship,
Six,
with
18.
your lordship's kindly apologies in the previous matter, interim order needs to be extended. Seal number 16.
Wherever intermodal is there, it will be extended. Yes. Next
Cell
18.
number 18.
Appear for the petition.
P. Nataraj.
The wife petition seeking transfer of the MC petition, my lord, filed before the family court at Bangalore to the family court at Mysore. Lord, the petitioner has also filed a complaint against the respondent, my lord, for the offence punishable under section 498A.
Where? From which place?
From Bangalore to Mysore, my lord, 140 kilometers is the distance.
Were any other matters pending there?
Yes, my lord, crime number 210/23 for the offence 498A, 504, 506, 3 and 4 of the DP Act is
Any
also.
other case?
No, only 2 cases.
Children,
No children, madam.
what do you say?
Permit your lordship turn to the objection filed by us and annexures which were produced. Annexure R1 to R8. Permit your lordship turn to our objection. She was working here. Permit R1 your lordship. Statement of objection filed by us. Acharya Institute of Technology has sent a appointment order.
Have you filed your?
I have filed the memo, my lord. Now she has resigned from the said job. Now she is working at Mysore.
What is the document to show?
My lord, memo dated 5/2/2025, my lord. The petitioner submitted earlier, she was appointed as
Acharya
assistant
Institute
professor.
of Technology.
Yes, my lord.
Accepted. You are relieved from all your duties.
Yes, yes.
From 21st November
Yes,
2024.
yes, ma'am.
You are working where now?
Lord, no.
Daksha First Grade College
Yes, yes, my lord, Mysore.
from 2012.
Yes.
Yes, one objection is over. Next.
No, that's what, because these things have been, documents have been concocted documents. Of course, I have not received the copies of those documents. In addition to permit your lordship, only because to arrest the petitioner, she has filed this petition. Only to the, he has to run to my, of course, even otherwise, permitted, these documents are fairly, permitted, look at those documents, R1 to R8 we have produced. Those documents are produced, only after furnishing these documents, he has produced those documents, which he is now relying. Now, permit your lordship, turn to the document, because he is qualified, he has purchased a car.
When these documents are filed,
Lord, on 5/2/25.
then what you are supposed to do, if you are not accepting, you should have filed your objections.
Well, of course. Those
Without filing
documents
the
are not-
objections, we can't consider
No, I
it
have
now.
not received those documents.
Lord, I have furnished the copies, my lord. I have furnished the copies. Signature is there in the memo, my lord. I have furnished the copy. If you don't have the copy, my lord, I will furnish one more copy. There is no problem in it. In fact, we wanted to settle the matter, my lord, amicably.
Your
in
signature
fact-
is there, Mr. Counsel.
Yeah, of course, there was a settlement is going on, my
Lord,
then because.
in
you are
fact,
not-
my lord, we wanted to
Directly.
settle the matter.
Don't, both of you don't mix up all
Please,
these
please,
issues.
ma'am, please,
We are
ma'am.
on the point.
Please, ma'am.
Whether memo is served on you or not.
Yes, it is there, it is there.
And then why are you saying that it is not served on you? You have not responded to that. Please come. The present petition is filed, seeking transfer of
MC number 778, 7738/23.
of 2020, pending on the file of the 4th Additional Principal Judge Family Court at Bangalore to the
Family Court at Mysore.
court at Mysore. The facts of the
Health
case
is also
are that
not, no, he is not, he is suffering from various ailments also. He is not healthy.
What is his age?
Age is,
31 years, my lord.
31 years.
30.
31
What are his health ailments?
Health ailments, because that is the main reason I have filed the objection. In addition to that,
What is his health ailment, I'm asking?
I will ask.
Pass over
Lord, tomorrow, my lord.
tomorrow.
Tomorrow.
Yes, next.
Much.
Serial number 19.
For the petitioners in this case, my lord, sir. 3 claim petitions have been filed before the Bijapur, my lord, sir. 3 claim petitions have been filed in Bangalore. 3 claim petitions filed before Bijapur have been clubbed, my lord.
Served.
Respondent.
Only one respondent, my lord, sir.
Served.
Served. You that.
My lord, sir, the Lordship may kindly come to annexure F, page number 35, my lord, sir. The 3 petitions have been clubbed together, my lord, sir. The main petition has been.
One minute. Let us look at your prayer. Please come to the prayer.
Prayer is there at page number 8, my lords.
To withdraw
The case pending adjudication before the
Vijaypura and transfer that to
the
Bangalore,
Bangalore.
clubbing with, what are these embassies?
My
What
lords,
is the
already-
connection between this and that?
My lords, your lordship may kindly come to page number 35, annexure F, my lords. Already this honorable court allowed the petition filed by the petitioner
in respect of one MVC number, my lords. That is clubbed with along with two MVCs, my lords. But I was supposed to file only one petition because this honorable court directed me to file each MVC case, each petition, one petition has to be filed, my lords.
Oh, before going into all that, tell the court, what is this connection between all this?
Same parties, my lords, arising out of same accident, my lords. 3 claim petitions have been filed before Bijapura, my lords. MVC number 1426, 1427 and 1428, my lords. Three MVC cases have been filed before Bijapura and 3 petitions have been filed before Bangalore MACT, my lords.
Who filed 3 petitions here?
Here 2 claimants, my lords. There 1 claimant, here 1 claimant, my lords. 2 claimants have been, 1 claimant has been filed 3 petitions here. 1 claimant has been filed 3 petitions there out of same accident, my lords. 1 petition filed.
Claimant will file 3 petitions.
My lords, 5 persons have been dead, my lords.
So in respect of 3 persons, 3 claim petitions are in
Bangalore. 3 petitions are in Bijapur, my lords.
Yes.
3 petitions have been clubbed in Bijapura court, my lords. Out of that 1 petition, I have challenged before this honorable court for transfer of the same.
Why should it be transferred?
It is transferred, already transferred, my lords. That's what I am telling, my lords. You lords may kindly come to page number 35. CP I have filed.
One of the claimant.
No, I am not the claimant, my lords. I am the respondent.
Respondent is
the owner, my lords.
owner of the vehicle.
Owner of the vehicle. There was no insurance, my lords. During the COVID.
Please come. So now which case is transferred from here to there? Where is that order?
Your lordship may kindly come to annexure F, page number 35, my lords. Page number 35, my lords. CP number 172.
Seeking transfer of MVC number 1427 of 2021, pending on the file of the senior civil judge and MACT 8 at Vijaypura, 2 the 21st edition SCJ and ACMM at Bangalore, within bracket SCCH-23, and by clubbing with MVC number 3175 of 2020, MVC number 3176 of 2020, and MVC number 1426 of 2021. The petitioner before this court is the owner of the vehicle. In respect to a particular accident, there are about 2 petitions filed at Vijaypura and 2 petitions at Bangalore.
3 petitions at Bijapura, 3 petitions.
Then what happened to the other 2 petitions?
Another petition is there, my lords. Next petition, next.
One order. 3 petitions at Vijaypura and 3 petitions at Bangalore by different claimants.
No, same claimants.
Huh?
They are same claimants, my lords.
One claimant will file 1 claim petition, is it not?
No, 1 claimant has filed 3 petitions, my lords, in Bijapura.
Show the court how can a 1 claimant can file 5 claim petitions or 3 claim petitions. If an accident takes place, 1 claimant will file 1 petition. Is it not?
Please, ma'am.
How will file 3 petitions? There must be 3 claimants.
Petitioner is same, claimants are different.
I'm not referring to the owner of the vehicle, I'm referring to the claimants.
Please, please.
3 claim petitions are filed at Vijaypura and 3 claim petitions are filed at Bangalore. It is submitted that the petitioner is the owner of the vehicle. If these petitions are decided by different tribunals, there is every likelihood of the conflicting of judgments. In that regard, he has already filed a petition before this court seeking transfer of the pending MVC number
1426. MVC number 1426 of 2021, madam.
pending seeking transfer of, there is that order 35.
35, page number 35, madam.
Transfer of MVC number 1426 of 2021 pending on the file of the Vijaypura Court. And this, then the coordinate bench of this court by order dated 4 June 2024 has already allowed the petition next para. Though notice is served on the respondent, no wakalat is filed, considering the fact that all the petitions that are pending before Vijaypura as well as Bangalore are arising out of the same extent. And this court has already transferred one case that is pending at Vijaypura. This court deems it appropriate to allow these two petitions, and accordingly the following order. So and so pending on so and so.
And also, my lords, regarding clubbing, my lords, because all the arising out.
File an application before.
Well, because all the petitions have been clubbed, my lords, in the Vijaypura. For that reason, your lordship may kindly make one this thing observation regarding clubbing of this thing, my lords. Otherwise, again, I have to file application here, my lords. Here, what happened, my lords?
Next
Only-
para.
Serial number 28. 20, serial number 20, Somnath.
Yes.
Appear for petitioner, my lord.
Appear for respondent.
Husband has
Transfer
filed
from where to where?
from Dodbadapura to Mandya, my lord. Husband has
Filed
filed.
by the husband.
Please, my lord. Husband has filed this petition for seeking transfer.
You're saying on the health grounds.
Please, my lord. On the last date of hearing, my lords were pleased to
My lord,
list it on record the opinion from doctor.
one incident I would like to bring to the knowledge of this honorable court. On 3/4/2025, there was a mediation referred in CC case in Mandya, and the petitioner and the respondents have attended the mediation center. Post the mediation center, when the respondent came and her parents came out of the mediation center, the petitioner and his brother have threatened them. And they have threatened that once the case is transferred to Mandya, they would look that they will run around the courts and they will suffer for life. And they were also supposed to assault them. And again, the second mediation session, based on this, the mediation is being cancelled.
Was
And
it recorded anywhere?
it is not recorded, but it is
Either it is recorded or any complaint is given.
no. It is been informed to the public prosecutor, where the public prosecutor is handling the 498A case, and the respondent is also ready to file an affidavit in respect of the same.
No, if something has happened, somebody has threatened you, you should have, because the mediation is done as per the order of the court, you should bring it to the notice of the court. You should file an affidavit before the court. Just like that, the statements will not be taken into consideration.
The respondent is ready to file the affidavit before this honorable court
Not this
regarding
court, she should have done it at an appropriate time when this has happened.
on 3/4/2025.
That is one aspect.
The second,
What about
the other aspect,
transfer that is seeking?
there was one medical report which has been submitted in the last hearing, and we learned that the medical certificate which is being issued by the Aster RV Hospital is fabricated one, because there is no OP summary. Once a patient comes to the Aster RV Hospital, he has to register it, and a patient ID will be created. And based on that, everything, the date, name, doctor name, facility, address.
Have you filed your objections to this?
No, no, my lord, I have prepared the affidavit. I would file this.
Do it without filing the objections. What are the statement of objections filed by advocate correspondent? Is there?
I have filed the respondent, but post that the medical certificate is being produced.
The lead counsel for the respondent seeks time to file additional objections. Yes, Liz's matter of revocation.
Interim order may kindly make.
Serial number,
Order earlier granted is extended till then. Yes, 21.
serial number 21, Chandra Srikanth.
Lord, the petitioner is seeking transfer from Hubli Court at Bangalore to Hubli, my lord. They don't have any objections, my lord. In their objection statement itself, they have stated so, my lord.
The present petition is filed seeking transfer of MC number 5128 of 2024, pending on the file of the Principal Judge, Family Court, Bangalore, to the Family Court at Hubli. Counsel for the respondent, the objections was filed on behalf of the respondent, submitting that they have no objection to transfer the case from Bangalore.
From Bangalore to Hubli, please, my lord.
Bangalore to principal judge.
Considering
Because
the same.
another case is pending.
Please, my lord.
Considering the same, the petition is allowed, withdrawing the same from so and so and transferring the same to the said court.
Cell number
The
22.
list is there in the list, cause list. Yes, next.
Cell number 22.
Apply.
TB
Yes.
Sidramaya.
Petitioner in this case, my lord. Not said, why petition, my lord? We are seeking a transfer from Malur to Bangalore, my lord.
Hmm?
So why petition, my lord? We are seeking transfer from Malur to Bangalore, my lord. The respondent has filed a
Distance,
so
MC is of the year 2023.
23, my lord. So distance between Malur to Bangalore is a 50 kilometer, my lord.
What is the distance?
50 kilometer, my lord.
The present petition is filed, please come. Seeking transfer of MC number 26 of 2023. Filed by the husband under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights from the code of the senior civil judge and JMFC at Malur, Koral district to the family court at Bangalore. Learned counsel appearing for the petitioner submits that the wife is residing at
My lord, it is residing in Sarjapur Hubli, Anekal Taluk, my lord. It's a Bangalore district.
residing at Dhamma Samudra village, Anikal Taluk. And the distance between both the bases is about 45 kilometers. And it's difficult for her to travel. Further, the husband is not paying maintenance to her. Next para. The notice is served on the respondent. There is no wakalat filed on their behalf. Considering the fact that the distance between both the places is about 45 kilometers. This court deems it appropriate to allow. Accordingly, so and so is withdrawn. Yes, next.
Cell number 23. Chandana Tariga for petitioner Sirish Prasad Payas.
Affidavit is filed.
Yes, madam. I have filed the affidavit. The very next day, I served the copy on.
Only one submission, my lord. In the affidavit, they say, my lord, she is working here in a bank and son is staying with her and he is not going to any school. The fact, my lord, if she is staying in apartment, the child is staying with her. During the daytime, she is going for work. Where the child is residing, we don't know.
Huh?
Where the child is residing during the daytime, we don't know. The information what I received, my lord, child is residing with a grandparents.
We are not here to decide about the well-being of the child.
According to the,
For coming and exercising the visitation right
yes, ma'am.
at Bangalore, that presupposes that she is staying in Bangalore. She is seeking transfer. If you say that what is happening to the son when she is not at home, all that will be taken by a custody court, not by this court.
The information what I received, my lord, child is residing in Bangalore with a grandparent.
You are never, then why are you coming to Bangalore and exercising the visitation?
That's what, my lord, when I
We cannot
exercising my
consider that.
visitation
We
rights, my
cannot
lord, I'm
consider
given to
under the-
understand.
Under the light of these, please come.
When exercising my visitation rights, my lord, I'm given to understand that the child is also coming from Bangalore to Bangalore.
That you tell the court, why I have to come to Bangalore to exercise the visitation when the child is staying at Bangalore?
And also, my lord, she is working here and it's apparently obvious that child cannot stay alone here in the apartment. Child is staying in
You
Bangalore.
don't know what are that is not the affidavit that is asked to be filed. Affidavit is filed as per the order of the court.
Yes, ma'am.
Court asked whether you are staying at Bangalore, whether the child is with you, whether you are working here or not. She said she's staying here, child is with her. That's sufficient. Please come. The present petition is filed to transfer GNWC number 16 of 2024, pending on the file of the Principal Judge, Family Court, Mangalore, Dakshin Kannada, to the Family Court at Bangalore. It is submitted that the wife is working in Bangalore and the stale is staying at Bangalore, and as it is difficult for her to travel from Bangalore to Mangalore, the present application is filed. Husband has raised his objection stating that the wife is not working in Bangalore, and in fact this child is staying at Mangalore, and as such the petition cannot be transferred. Land counsel appearing for the petitioner submits that in a division bench of this court had passed an order granting visitation to the father. Even as per the said order, the father is exercising the visitation at Bangalore, which shows that the child is residing at Bangalore along with the mother. Then on the last occasion when the matter came up, this court had asked the wife to file an affidavit, the mother to file an affidavit before this court. Giving particulars of from when she is residing in Bangalore, in which place she is residing, in which company she is working, and whether she is working from home at Bangalore or from the office in Bangalore, whether the boy is with her in Bangalore or is residing with her parents at Bangalore. And accordingly, if an affidavit is filed in this regard stating that she is working in Bangalore and staying in Bangalore along with the son, then counsel appearing for the respondent submits the husband submits that if the mother is working and the boy is not going to the school, and who is taking care of the boy is not known, and it strengthens the fact that his case that he is residing in Mangalore along with the maternal grandparents. Next paragraph. Heard the counsels on either side, but the material on record. Admitted facts in this case are, in view of the order passed in MFA, the father is exercising the registration at Bangalore, and according to him, she is not working in Bangalore. For that, an affidavit is filed before the court. If any statement that is filed before the court, if it is not correct, then the petitioner and the respondent could have filed the document before the court. No such document is filed. Hence, and coming to the next submission, that if the wife is going for the work, who is taking care of the boy and all, that is not the scope of inquiry in this petition, and this court is not inclined to go into that aspect, considering the fact that the boy is staying with the mother in Bangalore, and the distance between Bangalore and Bangalore is 450.
360, my lord.
360 kilometers. This court deems it appropriate to allow the petition. Say accordingly. So is withdrawn and transferred. Next.
Till number 25, the petitioner case.
24.
24.
Yes.
I appear for petitioner. In this case, my lord, we are seeking transfer from Senior Civil Judge Court, Madur to Bangalore, my lord. That this is the wife petition, my lord. She has to take care of the minor daughter, aged about 2 years, 7 months. The distance from Madur to Bangalore, 90 kilometers, my lord.
MCs of which year?
2024, my lord.
The
In the initial
petition is
stage.
filed seeking transfer from Madur to Bangalore. Madur to Bangalore.
Yes, Senior
Madur
Civil
to
Judge
Bangalore.
Court.
The distance is?
90 kilometers, my lord.
90 kilometers, and the wife has to take care of the
Minor daughter, aged about 2 years, 7 months.
daughter.
Daughter, aged about 2 years, 7 months.
2 years, 7 months old daughter. Considering the same, they shall be stay of all further proceedings. In so and so, the petitioner shall take out hand summons on the counsel.
Already, I have taken the hand summons and notice also served to the.
Oh, it is already.
Already above.
The so and so, it is submitted that though notice is served on the respondents, yes, no wakalat is filed. Next paragraph. And counsel for the petition submits that the wife has to take care of the 2 years and 7 months old daughter in the distance between the place is so and so, and it's difficult for the wife to travel, considering the fact that the distance between so and so is so and so, and the wife has to take care of the daughter who is aged 2 years 7 months. Hence, this court deems it appropriate to allow the petition. Next.
Till number 25.
Yes.
I represent the petitioner. The petitioner residing in Bangalore, she filed the case criminal miscellaneous before the 5th additional family court 854/2024. The respondent filed the case before the hospital for a divorce. MC distance is 326 kilometers.
Children?
They are the children, 2 children. They are residing in Bangalore. They are studying
Age?
4th standard and 12 to 8 years.
The present petition is filed seeking transfer of MC number 5 of 2024 pending on a file of the additional senior civil judge JMS State Hospital to 5th additional principal judge and family court at Bangalore. Land council submits that already wife had initiated criminal miscellaneous at the
854 5th additional.
Before the before the family court at Bangalore. And she has to take care of the children who are studying in Bangalore, aged about 12 and 8. Considering the same, they shall be stay of all further proceedings. The petitioner shall take out hand summons on the counsel appearing before the trial court and file the memo to that effect by 14th of July. If it is filed on 14th, list this matter on 15th, or else the stay granted by this court stands vacated.
Case number 26,
Next.
Ramo SR.
No representation post after vacation. Yes.
Cell number 27, Nirmala K.
It is a transfer petition.
We have no objection
Wife
to allow
might.
the transfer petition.
The present petition is
My lord.
filed seeking transfer of.
One submission, my lord. Let there be a order of time period for speedy disposal, my lord.
No MC of 24, there will not be any order for
My lord, he is a government lecturer, my lord. He cannot take a leave on every date.
what is that?
He is a government lecturer, the
The
respondent.
present petition is filed seeking transfer of MC number 334 of 2024. Pending on the file of the principal senior judge Bangalore.
Tumkur, my lord.
Bangalore to Turuvekere, Tumkur Taluk.
Bangalore principal senior civil judge, Bangalore rural.
Rural court.
To the senior civil judge and JMFC, Tumkur. The land council appearing for the respondent submits that they have no objection to transfer, but a direction may be issued to the trial court to dispose of the matter in a expeditious manner. Next para. The submission of the land council to for direction to dispose of the matter expeditiously cannot be considered.
My lordship, there
as
are
this is
two
a-
minor children are there, my lordship. It's only 8 years and 4 years.
So
So
what
it
to
cannot
do?
be, she needs to be with the husband. So if it is impossible.
That his request cannot be considered as this is an MC of 2024. Next para. Considering the fact the husband has no objection to transfer the matter and the wife has to take care of the children. The petition is, this court deems it appropriate to allow the petition. Next.
Much.
Obliged.
28,
Petitioner is the wife, my lord. 2 days
Yes,
back, my lord, I
Mr.
filed the wakalat, my lord, for the my lord respondent. Now, I praised him
They
to
appeared
from.
on the last occasion and asked for a time.
Yes, my lord, at that moment, I didn't file the wakalat, my lord. I just 2 days back, my lord, I received the my lord documents from the my lord.
So why the court has to list this matter again and again just like that? You should have asked for time that day. List this matter on 21/4/2025 and by that time objection shall be filed. This is matter after vacation, interim order earlier granted is extended until further orders. Next.
cell number 29. 29.
Yes, 29.
This is wife petition, my lord.
Patabi
The
C.
respondent filed a case at KGF, 100 kilometers away from this. The wife is working here and having 2 children of 7 years and
Bangalore.
Bangalore,
Distance is
100 kilometers,
100.
100 kilometers,
The petition is filed seeking transfer of the MC number
55 of 20.
MC number 55 of 2024, pending on the file of the principal senior judge and JMFC at KGF to the family court at Bangalore. It is submitted that the wife is staying at Bangalore and the children are also staying at Bangalore. The distance between both the places is 400 kilometers.
7 and 5 years. Age of
Distance.
The 100 kilometers.
100 kilometers. 100 kilometers, and it's difficult for the wife to travel accordingly, considering the submission of the stay of all further proceedings. And the petitioner shall take out hand summons and file a memo to that effect to the council appearing to respond to the trial court and file a memo to that effect by 21st. If it is filed, there's this matter on 22nd or else the stay granted by this court stands vacated. Next.
For
July. Yes.
Cell number 30.
Yes.
For the petitioner in this case, my lords, this is a petition which has been filed by the wife, and we are seeking for transfer from Chintamani to Bangalore, and the distance is around 100 kilometers. And there are 2 other cases which have been pending in Bangalore, which has been filed by the wife, and this is a subsequent petition which has been filed by the husband after 7 months.
Transfer of OS number 218. What is this OS?
OS is restitution of conjugal rights. Husband is a Muslim and the girl is a
which is filed for restitution of conjugal rights by the husband at the JMSC Chintamani to Bangalore. It is submitted that there are some other cases which are pending at the courts at Bangalore, and wife is residing at Bangalore. Considering the same, there shall be stay of all further proceedings. In this case, hand summons 28,
Yes.
memo by 29th, or else stay granted by this court's transfer. Next.
Much obliged.
For the petitioner, please. Petitioner is residing at
The
Tarikere.
caveator, your lordship. For the caveator.
They filed a caveat.
You filed a caveat.
Yes, your lordship. Your lordship, some
Arvind, the copy.
direction may be issued, your lordship, because some direction the petition may be allowed, your lordship. Since like for 1 year or 1.5 years speedy disposal, because we have filed.
You know, these petitions which are of the year 2024, just
Yes.
because wife had come to the court, why will the court issue directions to the wife court to expeditiously dispose
If I
of?
make one submission, your lordship, we have filed restitution of conjugal
Whatever it
rights, your
is, there
lordship.
can't be any direction.
There was a 2 years, 3 years it went on, it came to be dismissed, which we have challenged in MFA, your lordship.
There can't be any direction, and unnecessarily, instead of wasting staying the proceedings.
Yes, sir.
Anyhow, today, tomorrow, or next month, it's going to be allowed.
Yes, your lordship. We have also given them permanent alimony, your lordship. That is also, she is not agreeing on
That
that.
is true,
Yes,
but the court cannot give a direction for expeditious disposal.
Yes, your lordship.
There is the court, the oldest matter has to be heard first.
Yes. At
The-
least 2 years, your lordship, if I may request.
Now, in which court is it? Tarikere means which district?
Yeah.
Huh?
Chikmagalur district. Ma'am.
Chikmagalur, now the 20 matters are going on. Yours is which year?
25, your lordship.
25. Even if taking the 2 years it is pending, still your matter is 23. Now the 19, 20 matters are going on in Bangalore district.
Yes, your lordship.
Shall we, you want to file formal objection, or?
Yes, your lordship. We'll file our objections.
Then we'll grant stay and then adjourn it. Or if you don't, if you are ready, I'll dispose of.
I will let it be disposed of, your lordship.
The present petition is filed
Copy has been served. Copy.
seeking transfer of MC number 27 of 2025, which is pending on the file of the Principal Judge Family Court at Shimoga to the Court of the Senior Civil Judge at KMFC at Tarikere, Chikmagalur. It is submitted by the Land Council appearing for the petitioner that the distance between both the places is about
43.
42 kilometers,
No, madam. 75 kilometers.
75 kilometers. It is stated that already wife had filed a petition under section 125 CRPC, that is criminal miscellaneous number 424 of 2023, before the Senior Civil Judge and Additional JMFC at Tarikere, Chikmagalur district. It is submitted that only to harass the petitioner, the present petition is filed at Chikmagalur and is difficult for the wife to travel. Land Council appearing for the caveat submits that the husband has filed the petition for restitution of conjugal rights, and when the same was dismissed, she has filed a petition. She has filed an appeal against the MFA is filed, and the same is pending consideration.
Your lordship, MFA is also dismissed with the liberty to
MFA is
file.
dismissed with the liberty to file a petition for divorce.
Yes, sir.
And after that, the divorce is filed. Land Council submits that as the MC for restitution of conjugal rights is filed in the year 23.
Yes, 23.
23. Hence, this matter may be, hence there may be a direction to the trial court to dispose of the matter as expeditiously as possible. Next paragraph. First, coming to the aspect of transfer, considering the distance between the places and the fact that already another criminal miscellaneous is pending on the file of the before the courts at Tarikere, Chikmagalur district, this court deems it appropriate to allow this petition. Next, coming to the direction for expeditious disposal, considering the fact that this is an MC of the year 2025, this court is not inclined to pass any such order accordingly. So and so allowed. Next.
32.
Madam.
Ganesh Mishra.
Wife petition, my lord, seeking transfer from Bangalore to Kundapur, my lord. Seeking transfer to Kundapur.
Distance is
Distance 500 kilometers, my lord.
Huh?
500 kilometers.
children.
One child, my lord, 2 years.
She submitted the present petition is filed seeking transfer of MC number MC number 7157 of 2024 filed by the
Respondent husband.
respondent on the file by the respondent husband on the file of the family court at Bangalore to
Senior Civil Judge Kundapur.
the senior civil judge Kundapura, Udupi district. It is submitted that the distance between both the places is about 500 kilometers and it's difficult for the wife to travel, stay of all further proceedings. In this, by 29th, memo shall be filed about the hand summons. If it is filed, 30th to be listed, or else the stay granted by this court stands vacated.
Then
Yes.
33. Naveen N.
This is the wife's transfer petition
From where to where?
from Tumkur to Bangalore, Your Honor.
Tumkur to Bangalore distance.
Distance is 70 kilometers.
MC of which year?
MC is of 2025. Both MCs
Seeking
are
transfer from, next matter, seeking transfer from Tumkur to
Bangalore.
Bangalore.
Bangalore family. court.
Distances,
70 kilometers.
so and so, and in like in the same case, earlier case, handsome. Next 34.
34. Prakash MH.
Lordship for the petitioner, this is a wife's petition, Your Lordship, transfer from Mandya court to Bangalore,
Mandya to Bangalore, and when is, which year is the MC?
2025, Your Lordship. There's
In this
DB Act
Mandya to-
being
Mandya to
filed here,
Bangalore,
so he's
distance
coming and
is,
appearing here, Your Lordship.
Distance is
100.
140 kilometers. 100 kilometers. And another matter is pending before the courts at Mandya, and the husband, Bangalore or Mandya, the
DB Act is pending in Bangalore.
Bangalore, and the husband is attending the said case. Same, in this case, the hand summons by 30th of July, 31st is the, if it is filed, 31st, or else stay granted, stands vacated. Next.
Oblige, Your Lordship.
5. Delhi Kukku. 2006.
Last time, Your Lordship had directed me to serve the copies. Even I had paid the process also for the respond number 2.
You have served it to Renuka?
No, I did not get her, but I called up, she did not pick my call.
So what is to be done now?
Already I had paid the process, I don't know whether it has reached to them.
No, why to waste time? If she is, some of the colleagues were there, come in the afternoon, they'll be, all of them will be here. All insurance matters are going on.
Next week, ma'am.
Please come, unnecessarily, why do we? Yes, what about this final hearing?
Final hearing up to 2018 matters were there.
Probate 23 of 23.
L. Srikanth Rao. We'll have it after lunch.
And for the.
We'll have.
Please. One submission, my lord. Serial number, list number 2, serial number 35, my lord. 1 week's time I will granted.
That is, that's a.
Additional document has to be
The
produced.
Lok Adalat, if there is, they are ready to settle it, we'll see.
List number 2, my lord.
List number 2 is all that, those matters only come in the afternoon. ರೆಡಿ ಇದೆ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ಇದೆಲ್ಲ ಹೌದು ಇದೆಲ್ಲ
ಮೇಡಮ್ ಇಷ್ಟ ನಂಬರ್ 3 ಫಸ್ಟ್ ತಗೋತಾರಾ
ಆಫ್ಟರ್ಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಮೇಡಮ್ ನೋಡಿ
ಮೇಡಮ್ ಗೊತ್ತಿಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಇದೆ ನಮ್ಮಲ್ಲಿ ಸ್ಟೇಜ್ ಅದೆಲ್ಲ ಅದನ್ನೊಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇಸ್ಕೊಳ್ಳಿ ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲೂ ಅಷ್ಟೇ ಸಿಪಿ ಅಲೋ ಆಗಿರೋದ್ರಲ್ಲಿ ಅವತ್ತು ಯಾವ್ದಾನ ಒಂದು ಫಾರ್ಮ್ಯಾಟ್ ಇಸ್ಕೊಳ್ಳಿ ಹೇಳಿದ್ದಾರೆ
ಡೇಟ್ ಇದೆ ಅಲ್ವಾ ಅದರಲ್ಲಿ ಇವಾಗ ಸೈನ್ ಹಾಕಿರೋದ್ರಲ್ಲಿ
ಡೇಟ್ ಇದೆ ನಾಳೆ
ಇವಾಗ ಅದ್ರಲ್ಲಿ ಡೇಟ್ ಇದೆಯಾ
ಈ ರಾಶಿ ಎಷ್ಟು ರಾಶಿ
ನಾನು 2 ಕಾಲೇಜ್ ಬಂದ್ಬಿಟ್ಟು
ಮೇಡಮ್ ಸರಿ ಮೇಡಮ್ 32 ಏನೋ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಬನ್ನಿ ಗೊತ್ತಾಗುತ್ತೆ
37 ಸರಿ 37 ಸೀರಿಯಸ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ
ಅದು ಇದೆ ಸರ್
ತಗೊಂತಾರ ಮಧ್ಯಾಹ್ನ
ಇದೆ ಗೊತ್ತಿಲ್ಲ ನೀವು ಕಾಯ್ಬೇಕು ನಾವೇನು ಹೇಳಕ್ಕಾಗಲ್ಲಪ್ಪ ನೆಕ್ಸ್ಟ್ ಸರ್ ಲಿಸ್ಟ್ ಬಂದ್ಮೇಲೆ ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್ ಕೇಳ್ಬಿಟ್ಟು ಮೇಡಮ್ ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬಿಟ್ಟು ತಗೋತೀನಿ. ಸರ್ ಮೊಬೈಲ್ ಎಲ್ಲ ಆಫ್ ಮಾಡಿ ಇಲ್ಲ ಸೈಲೆಂಟ್ ಮೋಡ್ಗೆ ಹಾಕೊಳ್ಳಿ. ಡಿಸ್ಪ್ಲೇ ಕಾಲ್ ಔಟ್ ಆದ್ರೆ ಈ ಫೈಲ್ಸ್ ಇದೆ ಹೋಗ್ಬಿಡ್ಲಿ ಅದೆಲ್ಲ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ. ಅದೇನು ಅಷ್ಟು ಒಟ್ಟಿಗೆ ಆರ್ಡರ್ ಶೀಟ್ ಮನೆಗೆ ತಗೊಂಡು ಹೋಗಿದ್ದ ಮೇಡಮ್? ಹಾ ಮನೆಗೆ ತಗೊಂಡು ಪೋಕರ್ ಇಲ್ಲಮ್ಮ ಬಿಂದು ಪೋಕರ್ ಇಲ್ಲ.
ಇದು ಪಾಸ್ ಓವರ್ ಪಿ ತೋರ್ಸಕ್ಕೆ ಯು
ಅಪ್ಡೇಟ್ ಯು ಪಾಸ್ ಓವರ್ ಪಿ. ಅದೇನೆ ಅದನ್ನೆಲ್ಲ ಅವರು ಫೈಲ್ ನಂಬರ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ. ಅದೆಲ್ಲ ಸೆಪರೇಟ್ ಆಗಿ ಇಟ್ಕೊಂಡು ನಾಳೆ ಲಿಸ್ಟ್ ಹಾಕ್ಬೇಕು. ಲೋಕಲ್ ಆದ ಗೌರ್ಮೆಂಟ್ ಸಿಗುತ್ತೆ. ರಘು ಅವರು ಮೋಸ್ಟ್ಲಿ ಬಂದಿದ್ರು ನೀವು ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಟ್ಟು ಆ ಫೈಲ್ಸ್ ಎಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು. ನಿಮಗ್ ಬರುತ್ತೆ ನಿಮ್ಮ ಲೇಟಾಗಿ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಲೋಕಲ್ ಕಳಿಸ್ಬೇಕು ನೀವು. ನಾಳೆ ಡೇಟ್ ಇದೆ ಲೋಕಲ್ ನಾಳೆ ಲೋಕಲ್ ಮುಂದೆ ಫೈಲ್ ಮಾಡೋಕ್ಕೆ ಅದು ಇಷ್ಟ ಆಗ್ಬೇಕು. ನಾಳೆ ಡೇಟ್ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಮೀಟಿಂಗ್ ಎಲ್ಲ
Also the passwords in the first list.
First list pass over matter, serial number 2.
My lords, I appear in this matter for the mother. My lords, if my lords were to see the last date order, this was where my lords had ordered the Nimhan sessions with the child, if my lords recollect.
Yes, yes.
So on the last date order, 12/3, 25 order from para 3 onwards. As per the above recommendation, child shall undergo 6 to 8 sessions, that is on Mondays and Thursdays as fixed by NIMHANS. NIMHANS shall also take into consideration exams. While the child is undergoing sessions, NIMHANS shall also assess the influence of both father and mother of the child, and both of them shall also be counselled simultaneously, and a report shall be placed before this court after the sessions are completed. Father can be present in every session. Now, my lords, in fact, I just wanted to submit an affidavit. Fourth session happened today. Before this, we've just give a copy to that side. All that has happened, sessions have been going quite all right. There's nothing untoward except the fact that the father is contacting the doctors separately, which in fact should not happen, because the doctors should contact both parents simultaneously. Be that as it may, we wanted to just bring this on record. But still the sessions, only the fourth session happened today. So let the matter be listed. In fact, even the report is not submitted.
Why the memo is moved in this case?
We didn't move it, my lord.
We had moved the matter, your lordship. Reason being
Your Lordships,
What if I remember, it was submitted that NIMHANS, they're
Correct.
not going ahead with the sessions.
Your Lordship, what has, no. Your Lordship's order was
What the council submitted.
council submitted. What was happening is that NIMHANS doesn't seem to now have the time. Right now, the ones who are even put are, I believe, trainees and interns. Nobody who is a regular psychiatrist or psychologist there. These are trainees and interns. And I believe they have been told that they also keep changing. So the same person is not sitting. In fact, details can be sought for as to who's sitting for these. The same person is not sitting. So it's virtually every time it is restarted when a new intern is sitting for this issue. And your Lordship has clearly stated that the father and the mother would be there. Now, there is absolutely not one session in all of these sessions where father has been allowed to participate, father is kept out of everything, the child is going through it. Your Lordship had stated that the father anyway can meet the child during these sessions, but that has also not happened. Now, what is happening is, started with something substantial, asked for more. Your Lordship, in all the orders, have found sufficient material as to how the mother is trying to alienate the father. Despite all of that, now, not only are the sessions not actually happening the way your Lordship would want it to, father's not once been called for any one of the sessions, and he's not met with the child, and the alienation is getting more and more. All we would request is this could continue, wherein your Lordship could ask as to who is the one who is sitting with the child for all of these sessions, then your Lordship will know whether
Is
it
it
is.
correct that the father is not part of the
No,
session?
no, my lords, we are in fact going through with the sessions as per the NIMHANS request. My lords may kindly see my affidavit. I have in fact given in my affidavit last 3 sessions apart from today's session. Today's session was today morning at 10 o'clock. Father was there today at NIMHANS. That is the information that the
Father's there every time.
No. The kindly see from para 3
It's not
onwards.
about father being there at NIMHANS.
Yes.
Their father is part of the.
My lords, half the sessions are only with the child. My lords may read my.
The order of the court is
Yes.
that he should be there.
Correct.
Both
Both of them can be there.
My lords, we are not dictating the nature of the sessions. The mother is not dictating. Let the report come.
The director NIMHANS shall place before this court what about the counseling that is being that's going on as per the order passed by this court and passed by this court. This court
In
has
fact-
directed. This court has directed. 1 minute.
Sorry.
This court has directed that whenever the sessions are going on, father and mother, both of them can be part of those sessions, and with that, the father will get an opportunity to interact with the child, or he can be present and he can have he can see the child. No, it is submitted with the senior counsel appearing for the father that in any of the sessions, father was not part of it. And further, they were not conducting the sessions properly. And every time, so far, 4 sessions are completed. And for each session, the new interns were taking the sessions. And it is not the same intern every time. And the sessions are not going as ordered by the court. Hence, in this regard, the director NIMHANS shall place a report before this court. What has transpired from the day the order is passed by this court and the court till today. Registrar Judicial is directed to communicate this order to the so-and-so forthwith. Yes.
May I just kindly see my affidavit at para 5? The mother's affidavit, para 5, bottom of the page. I state that I received an email dated 19/3 from NIMHANS addressing both parents to come to the Child and Adolescent Psychiatry Outpatient Department at 11. At the OPD, my child, myself, and respondent were seen by Dr. Bino. After initial introduction with the child, a joint session was conducted with the parents. Child was asked to wait outside. Dr. Bino informed us sessions will be conducted every Thursday. So on 19/3, joint session with father and me were there. then kindly see para 6. I state on 26/3 I received email, etc. Kindly come to the middle of the para 6. After a while, Dr. Bino called both parents and after the initial greeting, asked the other parent what he can do as a parent for the child. That is the father. This Dr. Bino interacted with the father. Conversation was primarily between parent and the doctor in
So
my
we'll
presence.
call for a report.
No,
and
we have
basing
no
on that-
difficulty. We have absolutely no. I'm only.
No, we'll list this matter on Thursday.
Please.
Basing on that, whether all through, whether the father was able to, even have a minimum interaction with the girl or not, whether he met her or
Very
not.
well, I have no
we'll be
difficulty.
knowing. No, please listen to the court. After that, basing on that, we'll pass orders. If he's not getting enough time to, at least a minimal time to spend with the daughter.
No,
at any
I
point
have
of
no difficulty on 2 submissions. Thursday, I have a personal difficulty.
When
If
you
it
want
can be on
Friday?
Friday, yes.
List
Thursday,
this
I'm not in
matter
station.
On Friday, by Friday, the report shall be, by Thursday, the report shall be placed before the court. List the matter on Friday.
Till such
The
time, your
only-
lordship, since
Only other submission I wanted to make is, report can come. We have absolutely no difficulty. Let Nimhans give the report. I only wanted to make the submission that since the council said father is not even involved in the sessions, as per my affidavit, in 2 of the sessions, father and mother were both called by the doctor themselves.
So what is the submission they are making is, when they wanted visitation, court said, whenever the counseling is happening, both of you are present along with the child.
Yes.
That is not happening. In that case, if it is not happening that way, then they want to have the visitation.
That is
For
all.
that, they
In
are-
fact,
is
in
all.
fact, we are taking she's taking the daughter, even today, she has taken the daughter, even the father is there. So in fact, whether, if the daughter is inside for some time, rest of the time, the father is anyway there with the child. She has taken the daughter for every session and every session, both parents are there.
We'll see from
Very
there.
well, very well. Friday, my lord.
List it on Friday.
obliged.
Yes, next.
Till number 3. Harisha R.
This is a petition of 2023. As there was no representation on behalf of the petitioner 2023, on 17/4/2025, as there was no representation on behalf of the petitioner, this court has directed the matter to be listed for dismissal on 21/4/2025. Today, in the forenoon as well as in the afternoon, there is no representation. It appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Next.
Till number 12.
There is some more matters or this is the only one? What is
Served
that?
on council before trial court.
What is the name?
CR Satyaprakash.
It is submitted that as per the orders passed for this court, the council has served the hand summons on the council appearing before the trial court and filed a memo to that effect. The registry is directed to print the name of the council appearing for the respondent before the trial court. CR Satyaprakash. Yes, list this matter after vacation. Intermorder is there. Look at it. Granted earlier is extended until further orders. Yes, next.
Till number 35.
Before his name could be divided, I just checked it in the our.
Where is Renuka?
My lord, in fact, my lord, I sought permission. I sought instructions from my client, my lord. They wanted the appeal memorandum, my lord. So could it be called on Thursday, my lord? I collected from.
Serve it to Mr. Shivana Gowda. She will give the.
Yes, I'll collect it from him, my lord.
The counsel for the appellant submits that he has served he has served the appeal memo on the counsel appearing for the respondent. Admit post for final hearing. Yes, next. Delete the name of Mr. D. Vijay Kumar. Yes, next.
It may be posted on Friday, my lord.
Yes, my lord. Friday, by Friday, I'll get ready, my lord.
Yes, next.
Till number, for final hearing, till number 36. SV Prakash for appellant.
I am for appellant.
K. Anman Prayappa.
Where is the counsel for the respondent? It's a claimant's appeal.
Owner's appeal.
On what ground you are before the court?
That this is the, after lapse of 7 years, the claimants filed a claimant petition.
And that was entertained by the court.
Yes, ma'am.
No representation on behalf of the respondent This is matter after vacation.
Till number 37, L. Srikant Rao for appellant. Rush.
Yes, what are these matters?
Implication of driver in the, implication of driver.
Implication of the driver.
In other words, in fact, it's a jolly ride turning out to be a disastrous event wherein the son of the insured was driving the vehicle who did not possess a driving license. And he hit a road median and the entire car was damaged. The son of the petitioner sustained grievous injuries. Other three also sustained injuries. And one day after, one Mallikarjun was stated to be driving the vehicle. It has been, the MLC record reflects that he was driving the vehicle as at the time of the accident.
So, like, how many claimants are there?
Four claimants. Six claimants, sorry. Six claimants. 4 inmates and 2 other persons who were standing.
There appears to be more appeals. How many? 1, 2,
6
5,
appeals.
6 appeals.
6 cross objections.
That's all cross objections.
Yes.
So first we will see the issue of liability or the negligence. Take that. Please come to the particular finding.
Okay. May be permitted to read para number 16.
Para number?
16 of the lower court judgment.
Now, as far as these matters are concerned, we will not take up right from 40. Who appears in 40?
Till number 37.
Will not take up this. We'll take up after vacation.
40.
Next week, is it possible next week?
May not be possible after
Okay.
vacation 40.
After vacation. Apply.
Yes.
Miller, para 16 is the relevant. Page 8. Page 17.
1 minute. Yes, please read.
16. In order to substantiate their contention, the petitioners in all the petitions are examined themselves as PW1 to PW6, respectively, by submitting their affidavits in lieu of their chief examination. In the evidence also, they have reiterated the contents of the petition. Yes, ma'am.
PW1 to PW6 for the claimants.
Claimants.
They are all the injured claimants.
All the injured claimants. 4 inmates and other 2 persons who are standing.
They are traveling in which car? In which vehicle?
Indica car, driven by the son of first petitioner Manu.
Then how the accident had taken place?
He went and hit a median, as a result of which entire vehicle was damaged.
Oh, median. Yes.
Even MV report, if your lordship were to look to the MV report, that would make.
Yes, please read.
PW1 to 6 have stated that due to the rash and negligent act of the driver of the said car by name Mallikarjun, accident was caused. In support of their contentions, PW1 has produced Exhibit P1, copy of the affair, PW2 complaint, PW3 spot motion, IMB report, PW6 is charged. 6 is charged. By careful perusal of the records, it is clearly shows that after the accident, the case was registered against the driver of the car bearing number so and so, and accordingly, the concerned investigation officer has, after conducting detailed inquiries, submitted a charge sheet against the driver for the offences punishable under section 337, 279, and 338 of IPC. So, as per the said document, prima facie, it reveals that the cause of accident is for one rash and negligent act of the driver of the car. In the evidence, though, the respondent number 2 has cross-examined the witness exhibit, the PW1 to 6, but nothing has been elicited to rebut the evidence of PW1 to 6. Though during the cross-examination of the said witness, the respondent to 2 insurance company has made efforts to substantiate alleged fact that Mallikarjun was not driving the car, but the petitioner MBC 1031 of 13 by name Manu was driving the car, but not proved the said alleged facts. PW1 to 6 have clearly deposed that Mallikarjun himself was driving the car at the time of the accident. The petitioners MBC 1031 to 820 were traveling in the said car, and the petitioner number 8 in MBCs so and so and so were standing by the side of the road at the time of the accident.
The said witnesses are the best witnesses to ascertain the actual factum of driver of the vehicle at the time of the accident. All these witnesses have stated that Mallikarjun himself was driving the vehicle at the time of the accident. In corroboration to the said evidence, IO has filed charge sheet against the said Mallikarjun and he has pleaded guilty. Therefore, said material fact reveals that Mallikarjun himself was driving the vehicle at the time of the accident. Moreover, the complaint was given by the villager by name Sadanandappa, who was not inmate of the vehicle or injured in the accident. The said complaint was an eyewitness to the said accident and mentioned the name of the driver of the vehicle as Mallikarjun at the time of the accident. In the complaint,
So Kumuda Krishnamurti.
Kumuda Krishnamurti is the officer of the company. RW1 is the doctor.
No, basing on what material you are saying that so and so is not the driver, but somebody else.
If your lordship were to look to the IMV report, a direct hit to the median and extensive injuries have been caused to the driver. But in this case, Mallikarjun himself has admitted the petitioners and others to the hospital, where the RW1 speaks about it. And Manu has sustained grievous injuries. The other three have sustained simple injuries. Manu says that he was sitting in the backside of the vehicle.
No, Mallikarjun, he has not sustained injuries.
He has not sustained injuries. The impact must be if your lordship were to look to the IMV report, the impact is so much, the entire car was damaged. And all the inmates have sustained injuries except the driver. In fact, it must be the driver must sustain injuries because it's a direct hit.
My lord, charge sheet was filed against the Mallikarjun and he pleaded guilty also, my lord.
No, those
Complainant.
are not the questions. Here, the simple issue is there is if you look at the car and the IMB report as submitted by him, if the entire car is damaged, all the inmates have sustained injuries. Why not the driver? Driver will not sustain any injuries.
That's why it's observed in the judgment itself, my lord. Even sometimes driver will be escaped and some no injury will be sustained by the driver of the offending vehicle, my lord. If he is the offending vehicle,
No,
Mallikarjun.
When the entire car is damaged, where is the question of not sustaining injuries?
And it is also, my lord, live. It is the obligation of the insurance company to evidence complainant. Complaint is made by one Mr. Sadananda who was standing nearby, or he was bathing his bullocks nearby there. Then the complainant was also not examined, and the charge sheet filed against the driver of the offending vehicle is also not.
No, it is very strange. I can understand he has not sustained grievous injuries.
Please.
In the nature of an accident of this nature, the driver will not be injured at all.
Please.
He will just like that. He'll take all of them to the hospital, and all of them, including one of the inmate, will be seriously injured. How can it be?
That's why it is observed in the first next paragraph.
Because it is like we are on the burden is on the preponderance of probability.
Please.
We have to look at it. We have to look at it. Preponderance of probability will point out.
It is my lord, it is the obligation of the insurance company to prove beyond.
All these circumstances, your own evidence shows that.
My lord, that's why in the cross-examination of the PW 1 to 6, nothing has been elicited to rebut the.
Please give the IMV report.
Yes.
That is exhibit.
Exhibit R1. Exhibit R7.
Next paragraph, I may be permitted to read next.
That is the reasoning given by the court I have seen.
Yes, please.
We'll see the IMV report.
IMV report too. No, it's petitions themselves have produced it. I'm sorry.
That is exhibit.
One minute. Exhibit medical bills. Spot Mahazar P3. P4 is the IMV report. P3 and P4.
P4.
P3 and P4, sir.
P3 and P4.
P3 is
Spot Mahazar IMV report.
Front windshield glass broken.
Yes.
Front and rear bumper damaged. No, windshield glass is broken and no injuries to the driver.
Sometimes it will happen, sometimes,
happen.
it's not required that it should be, he should sustain the injuries, my lord.
No, windshield is broken and sometimes only driver will be injured. Where will that, once it is broken, what will happen to the glasses? They will not go into the air.
No, it avoids driver and.
Front to both side fender damaged, bonnet damaged, right side headlight damaged, radiator grille damaged, body shell damaged, steering system assembly damaged, dashboard and instrument panel damaged, right side front door and rear door completely damaged, rear dicky door dented, right side tail lamp broken, right side front and rear shock absorbers damaged, front both seat and rear seat damaged, left side rear view mirror damaged and out of picture. Next, where is that spot, Mahajar?
Spot Mahajar exhibit alle P3 ನೋಡಿ. Exhibit P3 is the spot Mahajar.
P3.
Yes.
What it says, P3?
It's just I will translate it and then. It is in Kannada, I think.
No, this Mallikarjun is the claimant in which MFA?
No, he's not a claimant at all.
No, not Mallikarjun.
SS Manu is the first MFA, 7051.
SS Manu.
Manu. He's the son of the insured. He sustained severe damage, injuries. The others have sustained simple, some injuries. And I have examined the doctor who clearly stated that Mallikarjun admitted Manu and others in the hospital. And Mallikarjun, the alleged driver, admitted these people to the hospital. And at the time of the accident, Manu was driving the vehicle, exhibit R7.
Exhibit?
R7.
Again, R1, R7.
History. Complaint RTA, closed head, your lordship got it. Last one. Outpatient record, admission record, authorization for operation, and next history. 4th page.
RTA car accident at 2 p.m. near so-and-so. Patient unconscious.
Attendant gives an alleged history of RTA on 9/9/13 at around 2 p.m. wherein the car he was driving toppled over.
Exhibit R8.
Exhibit R8.
Admission card.
Exhibit R8 is the policy copy. Exhibit R8 is the policy. Policy was enforced. Policy copy. Exhibit R8.
What is this admission record? That is what you.
It's one continuation of the exhibit. P7 consists of outpatient record, admission record, authorization for operation, and history. 4 pages. It contains 4 pages.
You're reading outpatient card or admission record?
History, Your Lordship. History, last page, 4th page.
History, yes.
RTA, closed head injury. Patient attendant gives an alleged history of RTA.
Where the car he was driving toppled over after divider near?
Hit a divider near Mallal Kere.
Yes. Now, assuming that this Manu is driving the car.
Yes.
Then what about the liability with in respect to the other claimants?
Other claimants as
so if he is not having the driving license?
No, he did not. He did
then
not
it's
possess.
A pay and recover will apply.
He did not possess a driving license at
then
all.
What about the other inmates and the
the pay and recovery must follow.
As far as Manu is concerned,
Manu is concerned,
he is entitled for,
he will not be entitled because he did not possess the license at all. In fact, his expenditure is
the age of that person,
20 years. Manu is aged about 20
20
years.
years.
20 years.
And whether it is brought on record that there is no driving
No.
license?
Nothing has been, my lord. It is their obligation to produce certain documents, and summons could have been issued to the RTO.
For case whether he is having driving license or not.
My lord, he was not driving the way offending vehicle at all.
We'll do one thing, we'll adjourn this matter. If you have a driving license,
Please.
the person is having a driving license, produce it.
I will ascertain, my lord. My lord, actually, my case is that he was not driving. He was inmates
That I
of the vehicle.
understood. That
The question of production of the driving license does not arise there. Why? Because
in that case, we have to assume that I'm giving you an opportunity. Now, basing on the material, court is convinced
Please.
that Manu is driving the car.
No,
Then
it's
next what follows? No, that is your submission.
Please.
So now what falls is whether he's having a driving license or not.
Nowhere stated that he was driving the vehicle. Only it is their case. Well, otherwise they could have when that Mallikarjuna was not having the driving the vehicle. They could have issued summons also. They could have got issued. They could have filed an application. And also, complainant was also not examined. Summons has not been taken to this complainant. Complainant is given by one Sadananda who was standing behind at the time of the accident.
Basing on the medical record, exhibit R7 and the IMV report, the court is convinced that that is not sufficient.
A charge sheet is also filed, my lord, against Mallikarjuna Reddy, my lord. That has, and we pleaded guilty, and that reached final. That has not been challenged by the insurance company either.
Can the insurance company question the charge sheet? Or what is their business to question the charge sheet? Are they parties? Are they the complainant or the accused? It is not possible.
It is a beneficial legislation, my lord. They have not. Next para, I may be permitted to read the next para.
Please read.
Please. Beginning of the para number, page number 9, my lord.
Yes.
The PW 1 to 6 have clearly deposed that Mallikarjuna himself was driving the car at the time of the accident. The petitioners in MEC number 1031 of 2013, 8 so and so, were traveling in the said car, and the petitioner in MEC number 818821, Ramesh and Venkatesh, were standing by the side of the road at the time of the accident. And now these people could have been examined, my lord. That has not been examined. The said witnesses are the best witnesses to ascertain the actual factum of driver of the vehicle at the time of the accident, my lord. Then all the witnesses have stated that Mallikarjuna himself was driving the vehicle at the time of the accident. In corroboration of the said evidence, the IO has filed charge sheet against the said Mallikarjuna, and he had pleaded the guilty, my lord, before the criminal court. Therefore, said material fact reveals that the Mallikarjuna himself was driving the vehicle at the time of the accident. Moreover, complaint was given by villager by name Sadanandappa, who was not inmate of the vehicle or injured in the accident. The said complaint was the eyewitness of said accident and mentioned the name of the driver of the vehicle as Malik.
You are relying on the medical evidence with regard to the injuries and other for the compensation.
Sometimes what happened?
And the medical records contain something contrary to your stand. What did you do in that regard? You have come to the court seeking compensation. It's your duty to prove your case.
It is a preponderance.
And the documents are against you. And whether we will not go into that aspect.
The evidence of all two.
Not go into the accept, and it is because of his negligence this accident has happened.
There is no evidence, my lord.
The evidence of all two.
163A.
166.
And then?
The evidence of all two has here.
Then on what basis the court said the accident has happened? Whose negligence?
Mallikarjuna's negligence. Not Manu's. I have led evidence and
this is what is the view of the court. We'll take up this matter tomorrow. This matter tomorrow.
Yes. Kindly next Monday.
Yes.
Otherwise, after vacation, we will take an
No,
up.
no, no, no. Already we have spent substantial time.
Next Monday, my lord.
28.
I will ascertain.
Next Monday is what date?
28.
Yes, let it be on 28th.
Till number
Yes.
38.
Yes, the matter has been settled. 1,80,000 we have settled the matter. My name may be shown, my lord.
For respondent insurance company, Mr. Shivanagowda takes notice. It is submitted that he has instructions to appear and he submits, and it is submitted that the insurance company has agreed to pay an amount of rupees
1,80,000 in addition to what has.
1,80,000 above the amount.
In addition to what
In
has
addition
been granted.
to- It's already mentioned on the last.
It is last occasion we have mentioned, but
Why
I
it has
don't know.
come? I'll list this matter for filing the joint memo on tomorrow before the Lok Adalat. Yes, next.
Till number 39.
What about this?
I'm for the appellant. I'm for the appellant now. 36, 20, my lord.
Admit post for final hearing. Call for the case here. Yes, next.
List number 3, no?
Call list number 3.
List number 3.
Yes.
Till number 1.
Appearing for applying, my lord, in this case.
What is this council submission with regard
The
to?
judgment is legible and readable, my lord, that is the
Give
objection.
that. Even for that also council submission, sir. In every order, first line is not legible. That's why they've said office objections are sustained.
Two is
The legible copy shall be filed.
yes.
Till number 2.
Appearing for applying, my lord. In this case, my lord, petition number 3 is, my lord,
Yes.
petition number 3, V. Nagesh is died after the accident, my lord. I will note the,
Note it as it is, the cost title should be there.
no, my lord, I will, after the cash title, my lord, I will mention a note, my lord. Is died, my lord, hence the petition number 1 and 2 and 3 are the appellant are the.
You have to, first of all, as it is, cost title should be mentioned, then the note.
No, no, we are doing like this here, my lord. Petition number 3 is already died, my lord. Hence, we are not made a party in this appeal, my lord.
No, cost title should be as it is reflected. Beneath that person's so and so died. Whatever you want to say, the note you can, it could be there.
I will show.
No, cost title, because they won't be knowing all this, the section. The cost title should show and say that so and so person.
Bottom of the cash title, man. Cash title bottom only. Second page of the appeal memo, my lord. We are death certificate also produced after the wakalat, my lord. That is for council submission. They put the file before the summer court for acceptance, my lord. Petition number, appeal number 1 and 2 are the son, and 3 is the mother of the deceased, my lord.
No, that's what so and so died. We'll mention it in the cost title. Why not? We'll say so and so person died. So by the LRs, that's how the otherwise where will be the clarity? The office objections or the office objections are sustained. The appellant shall make the necessary the comply with the office objection. Yes, next.
Till number 3. George Antonicus, petitioner. Nasimurthy.
I may be permitted to file a memo for withdrawal of the, and also copy.
File for withdrawal of the writ petition.
Yes, ma'am. And undertake to hand over the, wait, I'll make a submission.
Huh?
I'll make a submission.
Why you want to withdraw?
Because I filed a writ petition in the name of a caretaker of the child. I am only interested. Child, the welfare of the child is a paramount consideration before all. Now the.
1 minute. The petitioner humbly submits and craves to accord permission to withdraw the writ petition unconditionally and hand over the premises in compliance of the order passed with the in execution case number considered in the interest of justices and equity. This writ petition is arising out of?
Madam, it is a frivolous petition. Kindly see the note, the order dated
I make a submission.
9/4/2025.
Why you are, when withdrawing, fairly make a submission.
See, so and so, his submitted petition is not stated, who has not been appointed as stated, whereas respondent number 3 is actually chartered appointed by the court. Contents this special request to be dismissed with exemplary, however, in order to provide an opportunity. Respondent on hand over the hand over custody. Respondent number 2 call this matter. Granted earlier shall continue till the next date of.
Madam, may I make submission? Madam?
Give that, what is the impugned order?
This caretaker, so-called caretaker, not the short form, not the stay of execution petition, not the, what happened, not the matrimonial dispute, not the, was not the entered into memorandum of settlement before the, not the party, respondent number 1 and 2, not before the family court. Not that has been entered into a memorandum of settlement that could be seen from not the page number 50 number 50.
No, first of all, show to the court what is the order impugned in the writ petition.
Not they have challenged execution petition filed by the wife, not the executing the order of the, not the memorandum of settlement, that the family court.
How can that be? First of all, our writ is maintainable. How the writ is
why I'm not
maintainable?
last.
Show the, now let us see the prayer. What is the prayer?
Not page number 18. Not.
Page number
18.
119.
Prayer.
Call for relevant records pending on the file of the
And fourth
Fourth
addition.
Additional Family Bangalore in execution case. Issue a writ in the matter of, in the nature of writ of certiorari by quashing the entire execution proceedings.
The matter is pending between the wife and husband. This person not no way concerned to this petition.
First of all, how the writ is maintainable?
Yes, that's all, my lord. My noble lordship, kindly see the order dated 9/4/2025, passed by court number 20. There it says, there is a dispute between respondent 1 and respondent 2.
Will not go into all those things.
No.
A writ petition as a relief as sought before this court is not maintainable.
My lord, that's why I withdraw.
Petition is dismissed.
It has to be
That's all the
with heavy cost notes for this reason. Not dispute is between them, not the husband and wife.
Who is he?
Not he is no way concerned to the.
I am a child. I am representing child.
Number 1, set up this lady stating that not the, as if she is a caretaker of not the minor.
No, let's see.
Kindly see the cast title of the petitioner, my lord. My humble request is,
Why he has no mother, father?
Mother and mother, that's my submission. Either you make a submission, I will make a submission.
Where is the mother and father, and who appointed you as a caretaker?
Yes, my lord. Respondent 1 is a mother. Respondent 1 is a father. Respondent 2 is a mother. Now, my lord, there is a dispute between the husband and wife. This is entered in annulment of the marriage and other things. We are not concerned. Now, the wife files an execution petition before the land fourth additional principal judge family court. Since memorandum settlement entered, court has not passed any orders on the memorandum of settlement.
We'll not go into all that. What is your relation with the child?
My child is my son. The respondent, I am petitioner is son of respondents. Now my humble submission is
your name is Indumati.
Yes.
And the petitioner is Ajit Rajkumar.
Yes.
What is the relation between Ajit Rajkumar
and Indumati? Indumati is a neighbor of a caretaker because husband and wife are quarreling. The child is studying in the school. At least for the protection of the child, I come to this court.
Which law?
Yes, I will withdraw that petition. I will withdraw.
Not withdraw.
Yes.
How can you file it?
And moreover, one of the court appointed mother as one of the caretaker and guardian.
Any interim orders are passed in this?
In interim orders.
That is why not I had filed a vacating also, my lord.
Yes.
And last date of hearing that not of the judge not taking into consideration with heavy cost notes, he will dismiss his expressed before the honorable court.
The relevant para in 4949 of my writ petition, I only challenged the order. Issue of delivery warrant.
For locus to challenge.
And I know locus, and that's why I gracefully make a
First of
submission.
all, you have come to the court. Will impose costs. How much?
No, my,
1 lakh, 2 lakhs?
no, my submission, my
What
lord.
is your business to interfere
What-
with the neighbor's child
Yes, my
and their
submission.
affairs
My
and
sub-
come to the court?
Yes, my submission is, the child is a minor, he is studying. Respondent 1 and 2 being the parents, not taking any care. Where the child?
You are taking care of, are you the guardian of the entire world? How are you concerned?
I'm not
And you
concerned.
come to the court, ask her, take an interim order.
Interim
And
order.
now, at this point of time, have you mentioned all these facts in this?
I only tell I am the caretaker to the welfare of
appointed
the
you as
child.
a caretaker?
I want the welfare of the child. Now this court, yes.
We will impose costs. What are the amount of the costs? What you want
My
to say, you can
submission, my
say,
lord.
or else I'll impose 1 lakh.
My submission, I leave to the court, my submission is,
Please
only the
come.
child.
No, these kind of frivolous petition, court is not for these kind of litigants. The present writ petition is filed, seeking the following prayer, extract the whole prayer. The cause title shows that Aryan Ajit Rajkumar, age 13 years, represented by his caretaker, and the respondents are the father and the mother. The relief that is sought is to quash the execution proceedings pending on the file of the 4th Additional Principal Judge Family Court under order dated 24/2/2025. When this matter came up, a coordinate bench of this court on 4/4/2025 had passed an order that the executing court shall not precipitate the matter in execution case number 157 of 2024, and no further proceeding shall be conducted till the next date of hearing in the interest of the minor child. After the notice, the respondent, you are for the mother.
Yes.
The respondent mother has come before the court, filed a vacate petition. It is stated that already an order is passed appointing her as a guardian of the minor ward.
Also not of the quit and vacate the not of the vacant possession of the not of the schedule house, which is belongs to the not of the respondent number 2 hearing. And moreover, not of the petitioner respondent number 1 contacted the second marriage through her not of 2 daughters are there. That is also I have produced. No, concealing all these facts, not
It is submitted that the petitioner, without any locus and locus, has filed this petition and obtained the interim order, and the petition needs to be dismissed with exemplary cause. In response to that, land counsel submits that he has already filed a memo to withdraw the petition, and he may be permitted to withdraw. Next para. Having heard the counsels, there is a material on record. It is surprising that how the court and how the registry itself has numbered this writ petition filed by a person naming himself as a caretaker, and the writ petition that is filed against the mother and the father. Further, there is no impugned order before the court. And when he says that the execution proceedings have to be stalled, the relief that is sought is to quash the entire execution proceedings. Even if a person has a locus, how those proceedings can be assigned before this court by a writ petition, and how this writ petition itself is numbered, this court is not able to understand. That apart, the petitioner, being a neighbor,
claimed. Claimed, my lord, she is now. We don't
claims to be a neighbor of the respondents, and the boy who is the neighbor's boy, the son of the respondent number 1 and 2, and comes before this court with these kind of petitions and obtains an interim order, it is nothing but a pure abuse of process of law. And this court is of the view that the cause this has to be dismissed with cause. Accordingly, the writ petition is dismissed with cost of rupees 25,000 to be payable to the legal services authority. Yes. Next.
Cell number 4, Rangnath Reddy R.
Lord, I am for the petitioner, my lord. I appear for the respondent, my lord. We have filed wakalat today, my lord.
Yes, it is submitted for the.
My lord, we
Interim order
are
is
ready
there.
for a hearing, my lord. Any short date, my lord.
Interim order is there.
No, my lord.
My lord,
What is this?
My lord, visitation rights ge family court munde hogidvi, my lord. He is having a daughter of 2.5 years. The family court has given only 4 hours of visitation rights, my lord. 2 hours ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ.
my lord, we have filed a
Page
counter
number.
writ petition bearing FR number 130378.
Entitled for visitation right of the minor child on every first Saturday and third Saturday of the month from 11 a.m. to 1 p.m. in the child's visitation room, BMC, Bangalore. Where is where the parents are residing in Bangalore?
Yes, my lord. Yes, my lord. Both parents are residing in Bangalore, my lord. And the
What is the age of the child?
2.5 years, my lord. 2.5 ವರ್ಷ, my lord.
Hmm.
My lord, ಬರೀ 4 hour ಕೊಟ್ಟಿದ್ದಾರೆ, my lord. Only 2 hours on first Saturday and the second Sunday, my lord. So we are challenging that, my lord.
What the mother is doing?
My lord, we have also challenged the visitation order. It may be tagged along with this and may be listed day after tomorrow, my lord.
Please, when we can't do it, your matter will come after vacation.
My lord.
My lord, the reason is that on the previous dates of visitation, my lord, the incidents that have occurred, the father has shown extremely aggressive behavior towards the mother, which has completely disturbed the child, my lord. She is aged just 2.5 years, and she is extremely disturbed by the visitation, my lord. That's the reason we have also challenged this very order.
Lord, kindly have it for final hearing, my lord. Any date, my lord, in the next week. My lord, our grandparents.
Hearing.
My lord,
You will
our
admit it will come after vacation.
my lord, our grandparents ನೋಡೋದಕ್ಕೆ ಮಗುನ್ ಬಿಡ್ತಾ ಇಲ್ಲ, my lord. Our grandparents ಮನೆಯಲ್ಲಿ ಇದ್ದಾರೆ. ಆ ಆರ್ಡರ್ ಅಲ್ಲಿ ನಿಮ್ grandparents ಹೆಸರಿಲ್ಲ ಅಂತ ಹೇಳಿ grandparents allow ಮಾಡ್ತಾ ಇಲ್ಲ, my lord.
No,
ನೋಡೋದಕ್ಕೆ.
my lord, the child is 2.5 years old, and the court has ordered visitation in the grandparents' house of the petitioner, my lord. That was not even sought for before the family court.
Well, that is for one.
She's 2.5 years
monthly
old, my
once,
lord.
my lord. That is not even started, my lord. 3 months ಒಂದ್ಸರಿ ಹಾಕಿದ್ದಾರೆ ಅದು. So that is not even started, my lord.
This matter on Saturday along with so and so. On the day, all the parties shall be present before the court.
Obliged, my lord.
Obliged, my lord.
Yes, next.
Saturday 26th. Sale number 4.
So and so submits that she has instructions to file wakalat. Yes.
Sale number 5.
Few
City Malay.
office objections are there, ma'am. We have it on Friday, ma'am. In the meantime, we'll comply in office objections.
Why is it coming? Why the memo is moved then?
Mood is, there is emergency is the matter, my lord. There is court has said, taken some course here because it's a petition challenging the maintenance.
This is an impugned order.
Impugned order is passed on 10th March.
If the office of petition shall comply with the office objection, if the office objections are complied with, this is matter on Friday.
Please.
Yes, next.
Sale number 6. Abhishek के order नहीं है.
Lord, I appear for the petition, appellant, my lord.
Krishna Kishore.
My lord, I pray for a short accommodation, my lord.
For what?
My lord, I had to file an application for stay, my lord. However, by oversight, the same has been missed. Maybe
Appear for the owner of the vehicle.
owner of the vehicle, my lord. By oversight, it's been missed, my
Is
lord.
this matter when?
My lord, Friday, my lord.
Not Monday.
Monday,
28.
please. Much
Yes, next.
Sale number 7.
Claimants appeal, lords.
Nagaraj
Item number
And
1 of
Milords.
25 is,
Milords, no.
the notice has to be ordered.
Notice.
Which is
And
insurance
milords, I have
company.
sought for stay. Stay, milords, in apportionment, milords, 50% is granted to wife and 50% to the mother. And the wife is no one, milords, to look after, and the mother, milords, has 2 more children, but they are respondents 3 and 4 here, 4 and 5 here. And she is admitted, milords, that she is residing with them.
You know, it's a case of injury or death.
Death, milords, death of the
Who died?
husband of this appellant.
Husband of the appellant died.
And respondent number 3 is the mother. Respondent number 4 and 5 are the other children of respondent.
Respondent number 1 is?
Respondent number 1 the owner of the vehicle. Respondent number 2 insurance company.
Yes.
Respondent number 3 milords is the mother.
Mother of the deceased.
Mother of the deceased. Respondents 4 and 5 milords are sister and brother of the deceased.
Hmm.
Apportionment lots is made 50% to the respondent number 3 and 50% to the appellant.
Why when the, for all of them it is granted?
No. Only for respondent number 3 and respondent number appellant, not respondent 3 and 4 and
4 and 5 it is not
no.
granted. So according to you, how it should be?
Lots at least 70 to 80% to the wife. Lots she has admitted lots that the children are working in government employment and she is residing with the other son, and she has no one to look after. The wife is no one to look after. And court honorable
You're
trial.
only on that ground.
Lots.
You're only on that ground.
And enhancement also. For enhancement, lots, the salary certificates have not been properly.
Counsel for the petitioner submits that. Then counsel for the appellant submits that the third respondent is the mother of the deceased and the appellant is the wife of the deceased. Court had granted compensation. And it is apportioned at 50% on both. It is submitted that the mother is staying along with the other sons, and the other sons are also employed. Considering the same, we'll say 30% she can withdraw.
Yes.
Considering
But
the
out
same.
of 50%, not 75% is ordered to be withdrawn. If 30% out in total amount, 30% may permit. Yes.
In the total amount, in the compensation amount, till until further orders, the respondent mother is entitled to withdraw only. Is only entitled for till under the further orders. She is only entitled for 30% of the compensation amount, and the withdrawal shall be as per ordered by the court.
Please, great. Notice has to be. Notice.
Yes, notice the, which is the insurance company. There is a list.
Tata AG.
There is a list. What happened? Everything is mixed. This one.
Tata AIG General Insurance Company.
Who appears?
Pradeep.
Pradeep appears.
Pradeep.
So and so takes notice on behalf of Tata AIG. Then counsel for the appellant shall serve the copy of the appeal memo. And next
Respondent
is
number 1 may kindly be dispensed with. Respondent number 1, owner.
file a memo.
Yes, I
for
do.
that.
I do.
The memo is filed. Give it.
Yes, now I'll
that
give.
Notice to respondent number 1, the owner of the vehicle may be dispensed with as the liability is fixed on the insurance company. Accordingly, the one is taken on record and the notice is dispensed with. Then you have to take registry is directed to issue notice to 3
to
4,
5 and 5. Please.
Yes, next.
Serial number 8.
And I am for appellant, but I filed a memo for dispensation of judgment, whereas of the certified copy. That certified copy is produced in another connected appeal.
Number 1 of 2025 is filed seeking dispensation of the production of the certified copy of the judgment for the reason stated. The same is dispensed with it for the present. Yes. Notice.
Serial number 4. Serial number 4 is United and serial number 6 is Oriental.
Which matter he is referring to? Yes, 9.
Serial number 9. D. Vijay Kumar.
Appeal by the insurance company challenging the negligence and liability quantum of compensation. The accident between two vehicles, our vehicle was parked on the extreme right side of the road.
Notice.
To take notice.
I number 1 of 2025. The same dispensation of the production certificate copy of the judgment. Notice.
Sought for stay, my lord. I have sought for stay. I am ready to deposit 50% of the award amount before I court. The police are filed.
Before this court seeking the IA number 3 of 2025 is filed stay. Is filed seeking for stay. You are on the liability.
Yes, my lord.
The insurance company, it is stated that the insurance company is questioning the liability fixed from them, and it is submitted that they are ready to deposit 50% of the amount
Before I court.
There shall be stay of all for the proceedings pursuant to the award passed and so and so, on the condition that the appellant shall deposit 50% of the amount within 4 weeks.
6 weeks, my lord.
Yes.
6 weeks, 6 weeks.
6 weeks, yes. Notice to the respondents.
Much.
Serial number 11.
What happened?
Tell me, notice.
Dispensation.
Notice?
Yes, madam. Notice.
Which is insurance company?
Insurance company.
R2 is HDFC, madam.
Huh?
HDFC.
HDFC, Elbow General Insurance.
HDMC.
Then notice.
Mr. Vijay Kumar is directed to take notice on behalf of the respondent.
Notice to
insurance
R1,
company.
madam. Pain recovery.
Huh?
Notice maybe R1. Notice to R1, I will take notice, madam.
Notice to?
R1, I will take process, madam, because
Notice to R1. Yes, next.
Cell number 11.
The Maya 1 is ordered. Notice to the, which is the company located? 11.
United, madam.
United.
R2 United India.
Janardhan.
Mr. L. Srikanth is directed to take notice on behalf of the respondent insurance company. Same appellant should serve the copy of the appeal memo on the council. And what about the other respondents?
R1 notice, I will take notice. R1, I will take notice, madam.
It's liabilities on whom? The liability is not the issue. Why to take notice?
I will
on
check,
that?
my lord. I will check.
Notice to respondent. Yes, next.
Cell number 12.
What about this? Which insurance company?
In this case, also, National Insurance Company.
National Insurance Company. Mr. A. N. Krishnaswamy is directed to take notice. Then counsel for the petition shall the appellant shall serve the copy of the appeal memo. What about the others?
I will dispensation memo.
Huh?
I will file dispensation.
A memo is filed seeking dispensation of notice to whom?
R1, my lord.
R1, as if the liability is fixed on the insurance company. Accordingly, so and so is taken on record and notice to so and so. Next 13.
Cell number 13.
Maya number 2 is allowed.
United India Insurance Company.
United
India Insurance Company. R1 may be dispensed. Memo filed.
Mr. P.B. Razi is directed to take notice and the learned counsel for the appellant shall sell the copy of the appeal memo on the council.
Dispensation memo filed.
Memo is filed same to respondent number 1 dispensed with. Next.
Cell number 14.
This is a matter that has had a chance to be heard before your leadership. There was February 2024, your leadership may recall. This is a custody matter. Father's petition for enhancement of custody, visitation and access was challenged. Your leadership had heard it on a couple of dates. Parties had also met your leadership along with the child in chambers. Since that time, there have been some developments that I wish to bring to your leadership's. Since that time, there have been some developments I have to bring to your leadership attention. There was an order passed by your leadership recording the reluctance of the mother respondent to obey the orders of the court. There was an order passed by your leadership to basically allow the father to meet the child at a neutral location, which was not obeyed by the respondent mother. There was an order by your leadership for the child to meet with a specialist at the mediation center along with the parents. The father traveled from Gurgaon for that meeting. The mother did not come, did not comply. All of these non-compliances are on record. Then the matter took pause for a few months in the Supreme Court because parties were mooting a settlement. That settlement did not go through. Transfer petition that was filed where the settlement talks were going on got allowed, and the matter came back before your leadership, before this honorable court. Justice Yerur, who's hearing the matter, has passed a series of orders. The most important one of those is on 21st March, where my interim prayer for 50% access during visitation in an unsupervised manner has been allowed through a very detailed, reasoned, long order. That order mandated that on the 7th of March, the respondent mother come to the office of the Registrar Judicial before this honorable court and hand over custody of the child in presence of the registrar, so that 50% of the summer break, which has commenced in the month of April, can be spent in the company of the father and the paternal grandparents. That order was again thwarted, not complied with. We had to move this honorable court on the 7th evening to say that the child and the mother have not come before the court. The matter got taken up on the 8th. On the 8th, the mother and child are have disappeared incommunicado with their respondent counsel. A senior is brought and stated that we have moved an application to appeal in the Supreme Court against the order for 50% visitation and access for the vacation. On the 8th, the court takes cognizance of the fact that the respondent is a repeat contemner. She's not appearing before the court. She's not appearing before the registrar. The child is, in fact, parroting the will of the mother and has been alienated. All of these are matters of record, and says that we want to issue a warrant for production of the mother because she's nowhere to be found. And the respondent's counsel does not have instruction on where she is. On account of one final concession being made, warrants were not issued on the 8th. On the 8th, a direction was issued to the Commissioner of Police to search the whereabouts of the respondent mother and the child, and a direction was issued restraining them from leaving this honorable court's jurisdiction. On the 9th, the matter was taken up once again, on which date the court was informed that the Supreme Court is seized of a matter in an SLP. On the very same day, the Supreme Court heard the matter, and an order came to be passed. That leadership I'll place on record. It is for compliance with the Honorable Supreme Court's order that the matter has been listed today. It is required for your leadership to read this order. It's a brief order passed by consent of parties. May I read, your leadership? The matter was taken up. 9th, it was originally listed on the 9th. It could not be taken up due to the bench not sitting. On the 16th, it was taken up. May I read, your leadership? Paragraph 2, your leadership may see. After arguing for some time, learned senior counsel so-and-so for the petitioner mother and so-and-so appearing for the father have agreed to the following. It is an order by consent. On the 21st of April and 22nd of April, on both days, the
like 1, 2, and 3 are the modification.
Yes, the modification. Instead of what has happened now, at 11 o'clock, the father goes before the registrar. The mother comes after a series of non-compliances, after a series of non-communicated absences. She finally appears before the registrar with the child, and a ruckus is created. The child is unwilling to leave the mother's company and sit with the father, look at the father, even look at the grandmother. So the registrar makes an effort, and I will say a concerted effort, to try and get the child to leave the mother's company and part with the father, at least for the day's duration that the Supreme Court has ordered, from 11 to 6. That fails. Your leadership may have on record already, I'm not sure, the registrar's record of proceedings. But it essentially says that the child was unwilling to meet or not ready to meet. The question is, your leadership, a very plain and simple one. This is a position that we are in. 3 dates have been given to me. 2 dates of day visitation and a weekend of overnight visitation by consent, by an order of the Honorable Supreme Court. If we are going to allow, and I say this with responsibility and with some amount of delicateness, and I'll beg your leadership's pardon if I'm saying something I should not, but can we allow the will of a 10-year-old minor to thwart the order of the Supreme Court that has been passed by parties' consent? If a registrar records the fact that the child is unwilling, do we leave it at that? And the second question is, had I been on the other side? If the father was on the other side, would the mother be facing these sort of difficulties? With this sort of a situation, my respectful submission is there has to be a direction in support and supplement to the Honorable Supreme Court's order to effect handover of custody today, tomorrow, and on the 23rd and 24th by means necessary. That's one. And the second, your leadership, is this is a classic case of a deep-rooted and hard to not identify parental alienation. We don't have law on this in our country that's developed as well as it should have. So I will take your leadership only for a moment to one paragraph of the Honorable High Court of UK, where this similar circumstances arisen. Only one paragraph. This one. Your leadership may go to page 30 of my compilation. The relevant paragraph, this is a decision in 2020 that the UK High Court, the President of the Family Division, passed an order in relation to parental alienation. And the relevant paragraph I would want this honorable court's attention to begins on page 33, the law concerning parental alienation.
Yes.
It is for your leadership to read paragraphs 7 to 12, but the most important is the summary conclusion at page 36. In summary, in a situation of parental alienation, the obligation on the court is to respond with exceptional diligence and take whatever effective measures are available. The situation calls for judicial resolve because the line of least resistance is likely to be less stressful for the child and for the court in the short term. It is very easy for us to say the child is reluctant, we don't want the child to face any short-term stresses, but that is not the right way to do it. It does not represent a solution to the problem. Inaction will probably reinforce the position of the stronger party at the expense of the weaker party, and the bar will be raised for the next attempt at intervention. Above all, the obligation on the court is to keep the child's medium to long-term welfare at the forefront of its mind, and wherever possible to uphold the child and the parent's right to respect for family life before it is breached. In making its overall welfare decision, the court must therefore be alert to early signs of alienation. There is a judicial record now awash, not with one, not with two, but with multiple sources and signs of alienation. And these are not matters of dispute anymore. So for us to raise our hands and say, or for the Honorable Registrar, with all due respect, to say the child is not ready, in my respectful submission, is not an answer at all. Let means be used to ensure that custody is handed over in compliance of the order passed by consent in the Supreme Court. The previous decision, Gaurav Nagpal, doesn't deal as well or articulate as well the problem of parental alienation, but it arose out of a similar situation. If your leadership will have page 28, Supreme Court's order, and the relevant portion your leadership will find being paragraph 52 and 53 at page 28 of my compilation.
What is the report of the counselor, Bangalore mediation?
They didn't go. We came all the way from Gurgaon. The child and the mother didn't turn up.
Yes,
that was your leadership's order.
Lord, I have come on record today in this matter, but based on the instructions that is available, I've come on record today in this matter.
So how many councils you will change every day?
There seems to be a issue with that, but I suppose that I will be there for the rest of it now. Lord, my submission would be that, insofar as the mediation that
no, you don't have to submit anything on anything. Now you
the
have to
child was
submit-
available.
You have to submit about the order of this court, the order of the apex court, and how that is going to be implemented. And if it is now, if the girl is, if this is what she is coming for, we will say we'll shift the custody completely to the father so that she'll get used to it.
Just one submission, Malak. The submission that my learned friend made was no matter what means is necessary, has to be taken, and the child is supposed to be sent to the father according to the order is what is stated. Insofar as the order that was read out between the mother and the father, even if we go by the simple submission that my learned friend made, that the parties have consented that, okay, we'll go forward and have the child's custody, or insofar as today's visitation is concerned, it was agreed between the parties. Today morning, we were present, and my learned friend made a submission saying that we had created a ruckus. There was no ruckus created by us. We were there at 11 o'clock. The child was there. The mother was there. The child was independently, the registrar independently spoke to the child as well. Both the father and the child, the mother and the child, between the families as well as the councils, we were all present there. The child did not intend to go forward. I would say, my lord, if I may, my lord, with all fairness, I would say that the submission that they're making is that no matter what measure is required, it has to be taken to make sure the child is sent. That should not be the approach that needs to be taken, because it is a minor child, it's a small child, and let me finish, my lord. Just one simple point, I'd conclude the entire thing. That should not be the method that is taken, because even if we read the citation that was provided, it says about the welfare of the child. But on one point, if I may, I'm just going to take 30 seconds more.
No. All these submissions quote every day here.
No, I'm only going to take 30 seconds.
I know what is your submission.
I will not, my lord. Just 30 seconds. My only point would be that Insofar
You should
as
make the same submission when you are this side.
I'll make, my lord, if I may.
Will not make.
If I may, let me finish, my lord. Just 30 seconds more.
It's already your client.
My
wasted.
only point
Your
would be
client
that.
has wasted enough of the court's
My
time.
lord, my
No
only
further time
point
can
is
be
that
wasted.
since the parties are present, my only point, in all fairness, is what I'm saying, my lord. Since the parties are present, the child is also present. There is an order saying that since from 21st to 25th, I suppose that for the child and the mother to be present in the court, in the court, let the father build a rapport with the child. We will not come in between that.
It is
My
happening.
only thing is that let him
Happening-
build a rapport.
This statement is happening from how many months?
We are here.
What is
Tomorrow
the
also we'll be here.
contribution of the mother? Every time the custodial parent
Lord,
cannot
I
take
will-
advantage of the situation.
Absolutely
like this.
not, my lord. We will be here
I have
11
seen
o'clock.
the entire record.
My lord, only my point is
Have you
11
read
o'clock.
the prior orders? Have you
I
read
was
the
able
prior
to read the
orders?
last two orders, my
Then
lord.
you cannot submit anything like this.
Last two orders I was able to read, my lord. If I may be permitted,
make
my
one-
only
Can't be
concern is,
permitted.
my lord,
This order of the apex court has to be complied with, or else your client would be, she doing it everything at her own cost.
the child is present today in court. The child will be present tomorrow before the registrar. Let them have a communication.
Why what for presence? Just for the sake of presence?
It is necessary that, my lord, I have no objection. The child chooses not to go. My lord can have an interaction with the child.
I know, I remember this case, the moment I've seen them.
Lord, my only submission would be-
You can't take the course of law for granted.
Absolutely
It's not the
my
way
lord.
your client thinks that
My
she
lord,
can just
absolutely.
get over like this
My lord,
with the orders,
absolutely
with the
not,
weapon
my lord.
of the daughter.
My lord, absolutely
No.
not. my lord. The mother is present, the child is present. All I'm saying is, it would only be right for the
And
father
the
to
court has
have
to,
a.
no, the court has to go to such an extent, asking the commissioner of police to find out the whereabouts of your client. Is it necessary?
Lord, all of that.
No, all of that. That is also relevant.
Relevant. my
The
lord.
conduct also speaks.
Insofar
And in
as.
spite of doing all that, and she has the courage to come before the court and ask for another, giving some other reason, saying that still the daughter is, we will see, we'll completely give the child to the father.
One matter of fact I want to narrate.
All I'm
as to
saying
what I
is
have
the
seen
impact,
with my
my
own
lord.
eyes in the registrar's
All I'm
office.
saying is
Just
the
one
impact.
point.
Yes, please.
Even if, for example, it is contended that the child is unwilling, and I'm saying this on the record so that your ladyship hears it, as a responsible member of the bar, as an officer of the court, not as a person taking a particular side. Today, when the child was leaving the office of the registrar, in front of us, this has all happened. People can attest to it. I'm sure even my learned friend will attest to it. The grandmother, against whom not an allegation has been made from day one, not a single pleaded allegation has been made against the grandmother. She has come down, the paternal grandmother. When the child was leaving, the registrar's office is not very large. The child was leaving. The grandmother went to say hello to the child. It is not the child that said anything. It is the mother that said, please don't. So whatever is happening right now, a 10-year-old child, the vocabulary and the articulation with which she is objecting to the company of the paternal side of the family and the parents, it is not the vocabulary of a 10-year-old child. It is the vocabulary of the mother whose company she has been in exclusively for the last 3 years. It is because of this that the Supreme Court allowed a consent-based order saying, let the visitation and access be gradual. And that graduated access is what is being prevented even now. They don't want any access.
I'm on the same point, my lord. Let it be gradual. Since today we have come forward, my lord. Today we have come forward. The child is there.
The mother is not doing any favor.
No,
Don't tell the
absolutely
court that,
not.
like they have come forward.
Let
She
us
has
not,
to come
my lord,
forward.
let us not look.
There is an order. There is an order staring at her.
My lord,
Which has to comply with
my only pleading before this court would be that let us not look at it from the angle that it is the
whoever
mother or
it
the
is,
father, my lord.
Whoever it is who has no respect for the order of the court.
My lord, let us not have a look at it from the angle of the mother and the
Consider that.
father, my lord. I'm only saying that let us just have a look at the
That's
angle
what is
from
the
the.
conduct of your client right from the beginning. What is this volume of orders are speaking about? What has happened? When is the first order passed by this court?
My lord, my lord, today's is what I'm
Don't
saying.
tell the court without. You have to. Because
I
judicial
agree.
time court have no other word.
I agree.
We need to
I
hear about your
totally agree with
cases,
this court, my lord.
your client's case. No, from when these orders have started?
For your ladyship's convenience, I made a compilation.
Like 2024. How many
Yes.
orders are passed? This is a bunch of orders passed by this
My lord,
court.
I agree with this
As
court.
well as the coordinate bench.
My lord,
of
I
this
agree
court.
with this court on all points, my lord.
My only question to this court, my lord, would be that
Can't question the
let
court.
us not go with respect to the wife or the husband or
Cannot
the
question
mother.
the court,
My only
that's what I'm
submission,
making it
my
clear.
only submission.
You said my question to the
My-
court.
my only
Why would
submission,
the
my
court
lord.
answer your question?
Absolutely not. My only submission would be that should the child be affected in the fight between the mother and father?
That the mother should understand.
Understood.
And
Now, my
don't
lord, my
tell the
only point
court-
is
don't
today
tell
that the
court
mother
that
is.
A girl of that age has her own independent thinking, that she is able to independently think about all the things and she's disliking the grandparents. Is it not the tutoring by the mother?
If
If
she
the
would.
if she is such a plain person as you're submitting, if the grandmother is trying to speak to the child, what is the big, injustice that is caused to the mother?
My lord, that I did not witness to it. In all fairness, I did not witness to it. I was there. I did not witness to it.
Let the grandmother speak to, we will call the matter at 5 o'clock. Let the grandmother speak to the daughter.
Yes, madam.
Yes.
I have no objection to that.
Let the and when the client is there, party is not supposed to speak before the court.
Sure. I
unless the
apologize,
court
Your
wants it.
Yes. My only.
Let the grandmother speak to the child. We'll see. Call this matter at 5 o'clock.
5 p.m.
Call the other matters.
Tell number 15.
My lord, appearing for the petitioner in this
Can I
matter.
request this take place outside the registrar's office?
Yes.
Yes.
My lord, I'm appearing for the petitioner in serial number 15.
What is the
My lord, in this, my lord, I have sought for modification. My lord, on 28, I am appearing for the mother, my lord. On 28/1/25, the learned family court was pleased
Who
to.
appeared for the respondent?
My lord, Srimati Mamata Roy is on record.
What is the urgency now?
My lord, the urgency is that the visitation has been granted to the father. I have produced subsequently on 21/2/25. This honorable court was pleased to modify the visitation also. After the modification, I have sent the child twice. However, my lord, subsequently there have been certain situations where the child has entered into certain trauma for which annexure E, my lord, where the report of the psychologist is also produced along with, where the psychologist suggests that the visitation probably be suspended.
This is matter on Tuesday. Yes, next.
Much obliged.
16.
Next Tuesday, 29. Cell number 16.
I appear for petitioner, please, members. It's the father's petition.
Interim order
please,
is there.
No, please, members.
Who appears to the respondent?
I represent it.
Devanand.
Yes.
My lord,
I have filed an application seeking direction to hand over the custody of the child, please, members. As per the order passed by this honorable court on the compromise petition, please, members. The 75% of the summer vacation, the child has to be with the father, please.
Where is that order?
Page number 24, please, members.
Page number?
24, please, members. Annexure B,
Page number 24.
24, please, members. This is the memorandum of compromise petition under order 23, rule 3. Annexure B, please, members. It starts from 22. Relevant portion is at 24, page number 24.
Yes. Yes, Mr. Counsel.
I have filed execution petition, please, nurse. In the execution petition also, she has been, from the day one, she has been violating the orders of this honorable court.
Then why it is before this court?
Well, I have challenged the annexure N, wherein
Page
the
number,
page number 94, please, Millets, wherein the executing court declined to issue warrant against the respondent, please, Millets.
Let's see that.
Please, Millets. 94, please, Millets.
Who is the petitioner before this court?
Father, please, Millets. I had filed an application.
Court said in New York section 56 of CPC,
Please,
the court shall not order for the arrest or detention of a woman in the civil prison in a hence prayer of the learned advocate for the issuance of warrant so and so. Dated is rejected. Why you are not?
That is with regard to money decree, please, Millets. That can't be, please.
the facts and the situation involved are quite different from what my learned friend puts forth or said through this writ petition. My lord, can I?
No, before the court look into all those. A compromise decree is passed.
Very well.
Whatever, whatever you're projecting, saying to be the different, facts or anything, did you file any other application or did anything has happened or that compromise decree is, remains to be there?
What is included in this writ petition is there is violation of the terms and condition on both the parties. So therefore, put the child in the boarding school. That order has been asserted in the present writ petition. That is the order which is being attacked in this writ petition.
No, my lords, that order beyond the scope of the executing court.
No,
my lords.
that's
It is-
different. That's different.
It is against the order passed by this honorable court.
I am also feel that.
Yes, yes.
I am also.
In the statement of objections also, they have,
Why are you not telling that first?
please, my
By
lords.
saying that order, it is not about the conduct of the wife. It is about this order, saying that the boy should be kept in the child should be in a boarding school.
Yes, please, my lords. My lords, the violation.
Some order is there in this.
No, please, my lords.
The-
I am entitled to have 75% of the custody, please, my lord, now.
That is a different aspect.
For summer vacation.
So already your execution petition is pending on that the court will pass orders.
No, my lords, the executing court declined to pass any order. That is why I have come here, please, my lords. Let's kindly see page number 65, please, my lords. The conduct of the JDR, please. my lords.
Oh, it is like this. One order will be passed in a compromise. For implementing it, another order. For implementing that, another order. This series of things will happen. As far as this order is concerned, on the face of it, this particular direction is not correct. As far as that is concerned, we'll grant stay and hear it later.
No, my lords, now I am entitled.
Not pass another order for
Please,
registration.
Please, my
They
lords,
will not.
my lords, let them hand over the child as per terms of compromise. That is what.
Not direct.
My lords, I am entitled to have 75% of the
But
summer
that you file
vacation.
an execution petition.
I have already filed, please, my lords.
Let it be, let the trial court decide on that. The
My lords, the trial court is declined to issue any warrant and orders, please, my lords. That is what I have challenged here, please, my lords. My lords, I have filed an application for
will
violation
not
of.
pass after vacation.
No, my lords,
Matter after vacation.
my lords, let there be, please, my lords, let there be an order, please, my lords. I have filed an application, please, my lords. I am entitled for 75% of the custody.
How many
please,
times
my
the court will pass order?
lords. There is violation on the part of the JDR, please, my
This is the
lords.
court executing court to execute the order.
No, my lords, the executing court would not have made such an observation to put the child into boarding school.
That's
please,
what
my
I
lords.
said. I will suspend that
They
order.
have
I'm
also-
not happy. What to do?
They
I
have
will
also
only
assigned-
pass an order suspending that order, nothing else.
My lords, in terms of the compromise petition,
But I will not. If you have, you can do. As far as that putting the child into the boarding school, that order will be suspended. Above that, I'll not pass any order. If you want, I'll pass, or else after vacation.
please, my lords, writ petition may be heard, please, my lords, after vacation. Now, please, my lords, as in terms of compromise petition, I am entitled for 75%
Mr.
of the
Counsel,
custody.
I've already said I'll not pass such order. Either I'll pass an order to suspending as far as putting the child in the boarding school and post it after vacation. If you are insisting for the other and you don't want it, let it go after vacation.
My lords, my prayer be, please, my lords, it may be considered. My prayer be, please.
The petition is before this court, assigning the order of the family court, whereby the court had directed to take steps to put the child in the boarding school and both availing visitation rights to the child. This is not a positive order also. And how are you affected if it is not
My
suspended?
lords, she is not complying the orders. That is the reason, please, my
Post
lords.
after vacation. Yes, next. Next.
My lords, let there be an order, please, my lords. My lords, I am entitled for 75% of the summer vacation, please, my lords. They are not giving the child.
Cell number, preliminary hearing, cell number 17.
My lords, I am sorry, I am very sorry, please, my lords. My lords, let there be an observation. At least I will go to executing court, please, my lords. Otherwise, she will.
What observation? Learned counsel is seeking an order from this court directing the father, mother.
Even advance application she will not
directing the
entertain.
mother- Directing the mother to comply with the compromise decree. And he also submits that he's entitled for 70% of the summer vacation. As the execution petition is filed before the court, before the executing court, the petitioner is at liberty to seek all those released from the court, and this court will not, cannot pass any such orders.
Then number 17,
Yes.
how much in the,
Interim application receipt 24 was filed.
Mhm.
Before the interim application receipt 24 was filed. For
How much is the maintenance granted?
maintenance was not granted, the application was
Notice.
rejected.
Notice.
Stay may kill.
Huh?
Otherwise, stay may kill grant, otherwise the matter will be disposed of.
What is required?
Sought to stay of the proceedings before the family court.
What is the stay of?
Proceedings,
You are for the
proceeding.
wife.
No, I am not the husband, my lord.
That's why I said, how much is the amount?
In fact,
granted?
my lord, in fact, in the course of this on mediation center, the parents of the
Give that file.
parents, two female child were aged about 15 years and 12 years. The parents of the respondent, they have agreed to give two sides to the welfare of the children. And that condition, even I was ready to give the divorce. However, certain things have,
Your maintenance petition is dismissed.
yes, ma'am.
In that, how will the court grant stay?
Now, there the proceedings will be.
Not be stayed. Notice to the respondents. Yes,
for
next.
admission, serial number 18, Malati.
I appeal for the appellant, my lord. Insurance company appeal on liability, my lord. It's a case of injury. Pillion rider sustained previous injury is the case of the claimant. And the charge sheet is filed as against the rider as well as the owner of the vehicle under section 181 and read with section 180. And the court has passed on the liability on the insurance company. And the same order is challenged before this honorable court, my lord. The said order is challenged before this honorable court.
According to you, it is pay and recover.
Yes, pay and recovery is also.
So what we do is let the amount be deposited on that, and they may be permitted to withdraw. Ultimately, a claimant will be entitled for the compensation. The land counsel for the appellant.
50% will deposit.
The appellant insurance company is on the ground of liability, and the insurance company is not liable to pay the compensation. Considering the same, in I number 1/25, there shall be stay of all further proceedings on the condition that 50% of the amount shall be deposited by the insurance company within a period of 6 weeks. And on such deposit, the claimant is at liberty to withdraw.
Number 19,
My lord, I am for appellant claimant's appeal only for enhancement, my lord. R2 is the Cholamandalam, my lord. Cholamandalam.
Mr. H.S. Lingaraj is directed to take notice on behalf of the insurance company. Land counsel.
R1, I will file necessary dispensation memo, my lord.
Land counsel for the appellant shall serve the copy of the appeal memo on the counsel, on the insurance counsel. It is submitted that R1 is not a necessary party and he'll come up with an application. The memo seeking dispensation of notice. This is matter after vacation. Next 20.
serial number 20, Chandrasekhar P. Patil for petition.
The petitioners are the mother and daughter, my lord. They are seeking enhancement of the maintenance amount.
Notice.
I pay for the response.
Already appeared.
After vacation. After vacation.
My lords, in one submission, the parties
Tell-
are present, my lords, if they're willing to settle the matter, they're for settlement of matter.
They want to settle by paying some.
We're
After
interested.
vacation, do it. Now it is not possible. All that.
Serial number
After vacation.
Please.
21,
In this
PS
case,
Mahadeva.
in this case appearing for petitioner, my lordship. Petitioner.
What is the urgency in this matter?
Notice issue.
After vacation. Next 23.
Kindly issue notice to respondents has to be issued.
Uh-huh.
Notice has to be issued to the respondent.
In 22.1, then this person, she must be appearing in this after vacation. Yes, 23.
Petitioner, my lord, the first matter, last week, it's about 10 days ago, this honorable court heard both the father, husband and wife, and also the child in the chambers. And a detailed order is passed on the last hearing day. The court also felt that there is some difficulty so far as the child is concerned. It requires medical attention. Thereafter, there was a direction to both the husband, I appear for the husband, and the wife, to give and list out the names of the doctors. And the matter had come up on last Friday. I have given the names of three doctors. One is in Sakara, one is in Manipal Hospital, one is in Astra Hospital. Whichever this honorable court feels. The moot point before this court is, earlier with the consent, I got an order for visitation. Thereafter, there was another order that was passed by the trial court saying that I am entitled for certain days with the child. That was not complied in the spirit of the order. Thereafter, I made an application to hand over the custody of the child to me. It's a girl child of 5 years old now. The court dismissed it on the ground that is not a sufficient ground that I have canvassed. Agreed by that order, I am before the court. Now, on the last hearing, there was a
So it says counsel so and so filed the name of
the
three
previous to that. A detailed order is passed. In chambers, a detailed order was passed.
That is before this. I think I passed some order.
My lords had passed the order about 4 months ago when my lords had their roster.
No, after that there are no orders.
This was, my lord, this was made on
Maybe there are no orders in this.
4/4/2025. Just about.
Two matters,
Huh?
connected matters. It's been filed in
Therefore, when counsel for the parties or directors suggest names of two super specialty doctors, but referring along with her serving a copy of
In compliance to that, I have filed the memo, my lord. And now the vacations are also coming. The child, I require
the
the
age of the child.
5-year-old child.
5 years.
5-year-old child.
Autism child.
Yes,
Autism, that's what they say. I don't agree to that, but the child requires medical help. Because the court also noticed.
What was the earlier arrangement with regard to the visitation?
It was on every Saturday and Sunday. The child would be given to me for about 3 hours.
For how many hours?
3 hours.
Huh.
So that is not being complied in a regular basis. Sometimes she leaves the jurisdiction of the court. She goes to Delhi. There was also an order not to leave the jurisdiction of the court.
Father that she had gone to the.
No, when the vacations are starting for the boy.
No, Lordship, she's an autism child. She's going to a school where she's like, yes.
Vacations have begun.
When the vacations will begin?
It's begun.
Begun already.
Begun.
But Lordship, she's doing under certain therapy sessions. Lordship. Therapist is coming to the house of the child and like giving the sessions for almost 2 hours or something. So the mother has to be over there. Now the issue over here is like the father is interfering in the development sessions. Now whenever these sessions are being going on, the father comes and like disturb the sessions. Hence, Lordship, like we want the father to keep him away like at the point where the sessions are going on. Now there have been multiple applications which have been filed by the father stating that so and so doctor has to.
No,
be
we are
consulted.
not extensively going into all these issues. Number one, this court has asked, a coordinate bench of this court has asked him to give the list of the doctors.
Yes, sir.
He has given name of 3 doctors.
Yes.
What do you say on that?
On this, I have filed certain documents on 4th of this month, wherein the doctor which has been proposed by the father itself, wherein it clearly says that the multiple sessions have to be avoided. Can you look at that? There's a consultation letter which I have attached to this. Wherein multiple assessments of the child is best avoided as it is not beneficial for the child. I do not see any clinical indication to repeat assessment. So hence,
Why the court has asked you to furnish these names?
Because they were not allowing us to interact with the doctor. They are not allowing us to meet the child and the doctor together.
Why father do not have any right to know about the medical
father is
condition
treating
of
the
the
child.
child?
When you look at the on the documents,
So
which are submitted,
with whom the boy or the girl is undergoing the treatment now?
the mother, Lordship. I am the custodial mother.
Father, I mean the
Doctor.
Doctor, currently the name is Dr. Maria. She is from St. John's Hospital.
So why the father has no access?
Father is going to the doctor and seeking documents from the doctor. There are reports which I have filed before this court. He's going and seeking a
So
assessment.
that is
reports
one
directly
aspect.
from the
That is
hospital.
one aspect.
Yes.
Now what about the vegetation till the court reopens?
Investigation is going on. The emails which I have submitted that the father is coming to the house of the wife and like he's taking the child and going meeting it Saturdays 4 hours. Then on all the festivals, Christmas, Ugadi, and all the festivals which have come, the father has met the child. They have produced photos with regard to that.
False. It's false.
They have produced photos.
They are
with
not
regard to
allowing
the
this.
child. The visitation
They have to
has
just
been-
comply with the order passed by the trial court. That is not by them. Therefore, I made an application for complete custody. That is rejected. That's why I am before this court. And we have also made an allegation.
It is submitted that the boy is undergoing therapy sessions and a girl is undergoing the therapy sessions and a therapist is coming home. The doctor is coming home and giving the sessions. The father shall have access to the he can have the medical the therapy session that are going on and all the information regarding that, and father has every right to interact with the doctor to know exactly what is happening with the child. Coming to the visitation, it is ordered on Saturday and Sunday.
Eager holidays, now that the holidays are there, I'm requesting my lord to grant me little more. My parents are living in Bangalore. I live in Bangalore. She lives in Bangalore. Our distance is about 1.5 kilometers from each other.
So the status of the child is like she's 5 years old. But the
What
mental
makes a
capacity of the
woman,
child is 2
what
years
makes
old.
the wife always think that the man
Has
cannot take it?
autism, issue.
As my lords are noticing in each case, the person,
As considering the ensuing holidays, the father on 3 days a week shall have the are you going to their house or you taking her?
I'm going to
your
their house.
Comes to the house and picks the child.
And the father can pick the
Under the
child
supervision of the
from the
mother
mother's
also.
place and take her to his house and spend time for 4 hours in a day.
Lots of the therapy
For-
sessions.
for
Lots.
3
Again,
days.
we disturb lots of.
3 days in a week. It should be basing on the therapy sessions. After the therapy sessions, the father can take the child. If the mother is out of station for any reason, that 3 days shall be compensated in the next week
One more session.
after vacation.
Yes, one submit. Can I take the child to the doctor? Because it's nothing wrong in having a second opinion.
Happening, let's see.
Can I take-
Let
No.
both the parents not doubt each other. Anyway,
Exactly.
anyone like the teacher,
Yes, madam. Yes, madam.
both of you are doing something for the child. Why do you
All
doubt
ego
that the
fight.
mother will do something?
No, I don't suspect that. I don't suspect.
That's why let's see. Let it continue after vacation.
The
Let's
order may
see.
be clarified as well. So 3 days a week, again, there'll be a dispute with regard to the 3 days.
Huh?
Let it be clarified. Also.
Friday, Saturday, Sunday I will take.
Tell
Let the order be specific. Also.
about what?
The 3 days. Also.
That's what I said. Its convenience is given to the wife.
So again, there'll be a dispute with
Okay,
regard to-
Friday, Saturday, Sunday.
Then
No,
there'll be a
Friday, Saturday, Sunday. If on Friday, Saturday, Sunday.
From 10 o'clock till
for any-
4 hours from 10 o'clock.
It is after the therapy.
Yes,
Therapy
madam.
is with
After
what-
therapy.
Therapy is not on
Depends-
Friday.
Depends on the availability
That's
of
what,
doctor.
whenever that is, what did you write?
And let that be communicated by emails also.
For any reason, those 3 days have to be compensated in the coming week. And if there is, with regard to the timing of the therapy sessions, that has to be informed by the wife, by the mother to the father in
Immediately after,
advance.
immediately after vacation.
Oh, this is matter after vacation.
Great.
Yes, next.
Till number 23, VB Sidramaya for petitioner, SB Shrikant, the respondent.
Kindly have it tomorrow, my lord.
What is the matter about
The custody of a child, my lord.
tomorrow? Next 24.
Till number 24,
Respondent.
Present case, my lord.
Engineer.
The impugned order is at page number 23, my lord. 7125, allowing the application order on IA number 4, filing the rejoinder to the counterclaim with a written statement. My lord, here the Honorable Trial Court has allowed the application made by the petitioner
under section 10 of the Family Court Act read with section 151 CPC seeking to file the rejoinder statement in consequence to the statement of objection filed by the respondent. My lord, without counterclaim, the question of filing of rejoinder to the statement of objection is not available as per order 8 rule 6E of CPC, and the procedure allowed by the trial court is not according to law, my lord. Under these circumstances, I have proved before the honorable court.
This is smart after vacation, no urgency.
Interim order may be extended.
Stay order for last 6 months here.
We'll see after vacation.
Oblige,
not
madam.
now. After vacation.
Oblige.
25, Sachin BS for
Yes.
petitioner. Kulkarni,
Yes.
My lord, I am for respond to,
Anything urgent in this?
Lord, there is an interim
my
order
lord,
of
there
stay.
is urgency in the matter, my lord.
What is urgent?
My lord, my party that is respond to filed this expeditious trial petition before this honorable court, and this honorable court it's passed direction to the family court Mangaluru to have the expeditious trial on day-to-day basis, but the other side, that is the petitioner wife, putting hurdle in the trial of the court by filing one or the other applications and dragging on the matter. My party is a doctor, my lord. He is a leading practitioner in Mangaluru, and by one or the other reason, wife is harassing him by taking undue advantage of the.
My lords, the order that is impugned, my lords, I file an application, my lords, for summoning of documents under order 16 rule 1. My lords, summoning the bank account statements and the managers, my lords, of the bank, my lords. That, my lords, the order, my lords, is my application is rejected on the ground that the account, my lords, is with the husband and the mother and father of the husband, my lords. The court.
Second round of litigation.
Second, my lords have already dismissed, my lords, the application for maintenance.
Remember, the moment you said the mother and.
Please, lords have already dismissed the application for maintenance. That is attained finality. No one has challenged. Lords, thereafter I file an application, lords, for after, my lords, we went through the PAN statement, my lords, we found out other document, other bank account, my lords, that were registered with the PAN account of the husband. Thereafter, my lords, we made an application for summoning of those bank accounts.
At what stage?
My lord, after the evidence, my lords, of the parties, my lords. Thereafter, we have filed the application, my lords, for summoning of the documents. My lords may see annexure K, an application was earlier filed that was dismissed on the.
The order passed by this court for the expeditious disposal.
My lords, that order, my lords, was.
My lord, his submission is not correct, my lord.
7th March 2024.
When did you file this application?
Lords, this application, my lords, was filed on.
How much time?
5/2/25.
My lord, such applications are filed only after filing written arguments by me.
There is no time limit that is fixed, especially as possible. Thereafter, my lords, I filed application for maintenance that is rejected. I had filed, my lords, IA number 7 even before maintenance for summoning of the documents. That is, my lords, rejected, saying that it is now the stage has not come. You can file it later with the liberty that was dismissed. Later on, my lords, I filed this application under order 16 rule 1 to summoning the documents of the petitioner.
My lord, he has sought for a production of documents regarding some third parties, my lord, not concerned to me, my lord. And what he has sought for is to produce documents pertaining to some other entities, NGOs pertaining to me and and my parents' income, my lord. It is a matter between the husband and the wife, and it is a confidential matter. And if at all he has to seek any documents, he has to seek documents from me only. And whatever documents I am having, I have already filed assets and liabilities before family court, before trial court. And when he is seeking the order of the trial court to produce documents of third parties, it is not permissible under law, my lord. In that connection, I would like to produce a citation of under the Supreme Court, my lord. It is privacy. It is my privacy. My privacy cannot be leaked before the public society, my lord.
My lord may see.
And lordship, that is filed in the, after we have filed our argument. It's not in the evidence stage. It is.
Who is the counsel for the respondent? How many counsels he has engaged?
Myself and Muhammad Patan advocates are.
One can argue.
Yes, my lord. What my sister is submitting in my lord, the other side submitted that they have filed application at time of evidence stage, but that is not correct, my lord. after reaching the stage of the argument, main arguments on main merits of the case, I have submitted my arguments. Thereafter, he came to know that there are some lacunas in his case. Therefore, in order to fill up those lacunas, he has filed such applications to overcome the.
Two paragraph after considering the contents of the both paragraph at page number 32.
32. Please, ma'am.
Last but one, last para.
Please, ma'am. After considering the contents of both the applications and affidavit in the present petition, this court is not going to decide the alleged financial misappropriation said to have been done committed by the petitioner and his parents. There is no material to show that petitioner after his marriage has diverted the fund from his individual account and business account. The submission of the petitioner is that their marriage ended in 40 days. Therefore, summoning of documents pertaining to third parties in joint account appearing the name of the petitioner and his parents as prayed for in the IA 16 and 17 are not relevant for the purpose of determining the real question in controversy between the parties. The conduct of the respondent shows these applications have been filed only to protract the case and derail the proceeding for the reason best known to the respondent. Hence, Lords may see, I have suffered, my lords, an order under the same circumstances before, my lords, wherein, my lords, an application was filed, my lords, under 16 rule 1 and 2, where, my lords, the joint account of the wife, my lords, was with the mother. My lords are directed as per the Rajneesh versus Neha judgment, all the bank account statement, including with the joint account, has to be furnished. Please.
My lord, the interim order may be vacated, my lord, because taking undue advantage of this interim order, my lord, he is dragging on the matter, my lord. My lord, date may be fixed, my lord. Kindly date may be fixed, my lord.
After vacation, this is matter on 11th of June.
Lords, interim order, my lords.
Yes, I said extended.
Date may be fixed, my lord.
11th June.
11th.
Cell number 26.
11th June.
Khalil Pasha.
What is urgency in this now?
My lord,
Finally, it has to be heard.
My lord.
Finally, it has to be heard.
Yes, my lord. The question is, my lord, is that I sought for vacations for the child, my lord. Second half of the vacation, my lord. Your lordship, please kindly see the page number 32. I have filed an application before the Honorable Trial Court stating, my lord, that I require the child in Christmas vacation, my lord. Your lordship, please kindly see the page number 32.
Why this matter is adjourned on your request so many times?
My lord, the case was not reached, my lord, in spite of.
No, you have asked for 2 times.
No, my lord. Since 5 times it was listed, my case at all, not at all reached, my lord.
At request of the learned counsel, release this
Yes,
matter.
last occasion, 5:45, 6 o'clock, I submitted, my lord.
Yes, where is the impugned order?
Your lordship, please kindly see the page number 32. My application filed before the trial court.
Not application. Please come to the impugned order.
Impugned order, my lord, on page number 52.
What is the order?
This is application. IA number 29 is allowed in part. The petitioner is entitled for the following communication: visitings and temporary custody of his minor son. The petitioner is entitled to have visiting right on first and fourth Saturday of every month from 11 a.m. to 2 p.m. in any public place near to the residence of the respondent. However, he is not permitted to take his son outside Bangalore.
What is that you want now?
No, order, my lord, is that your lordship, please kindly see this order is passed without application. I have not sought for any order in the so modo the trial court is passed the order, my lord. Next, your lordship, please kindly see respondent is directed to the petitioner is directed to pay 3,000 rupees per visit. I have to pay 3,000 rupees per visit to see my own child.
What are these expenses? Why should he pay 3,000?
My lord, we never asked for any expenses.
That's what
has
then
happened
will suspend that order as far as 3,000 is concerned.
That is fine, my lord.
That is one aspect.
Yes, my lord.
Then what about the registration?
Registration, my lord, the second half of the child, my lord.
What is the age of the child?
The child is 11 years old, my lord. The child is 11 years old. The child was interviewed thrice by the lower court. The child did not show any inclination to go to the father. We in fact, it is out of our consent that this order was being passed. We said, let the child gradually start going with the father, spend some time. And then later, maybe if the child is comfortable, let's go for the overnight stay.
No, now.
Yes, ma'am.
Now, in that case, what we do is.
Yes, ma'am.
This is for first and fourth Saturday of every month.
Yes,
Now, anyhow, the boy must be having the vacation.
Yes, ma'am.
So we'll give some 3-4 days in a week.
Uh,
Not the overnight
Yes,
visitation.
madam. I'm okay with that.
And we'll suspend this 3,000 clause.
Yes, madam.
And where shall he meet? He'll pick up and take him.
From the Registrar General here, my lord.
My lord, during vacations,
During
to come here.
vacation, why should all of you come here? Take from her house.
My lord, it's very difficult for me to, it's Devanhalli, they are showing their address in Devanhalli. It's why it is very difficult for me to
So
go
then the
there.
girl, then they will come from Devanhalli to High Court and they will surrender before the registrar and you will take them.
Allah, your lordship, please can you see the page number 162, where at the time of visiting my own child, 6 members kurtar samya kapaka round up.
You, whatever order you want, if you
My
can
lord,
pick up.
4
the
days a
child,
week, okay, no problem. Wherever your lordship appoint your lordship
Go and pick up the child from their house. No, not nowhere else.
with the help of police, my lord, please.
My lord, why with the help
Why
of
with the
police?
help of police?
Lordship, please kindly see. Nalkai sala.
Court, there's paucity of time today also. If
My
you are
lord,
ready
my lord,
with
please
the.
pass any order, my lord, with regard to this.
My lord, let it be with the presence of the respondent, my lord. Let them together because the child is having a lot. Your lordship may kindly see the.
11 years, why? What is, why is
My
the
lord, there
presence
is
of-
this, my lord, this case is not as like the other cases. I would not object. I am okay with 4 days. I'm okay with 4 days, but in the presence of the mother, because the child will just not be willing. If your lordship permits me, I can keep the child present tomorrow.
My lord, I am the biological father. If mother is
My lord, after
restricted me to
three
have,
occasions, this order came to be passed. He is not paying any maintenance except
Where
for
is
the.
the order? Page number.
Your lordship may kindly see page 51, my lord.
Page 50.
51, para 10, my lord.
I have paid 1 lakh rupees.
The trial court, by order impugned, had given a visitation to the father on first and fourth Saturday of every month from 11 a.m. to 2 p.m. in any public place near to the residence of the mother. However, he is not permitted to take his son outside Bangalore. And court has also directed the father to pay 3,000 towards conveyance and other expenses of the child during each visitation. Land counsel appearing for the father submits that for visiting his own son, the court had directed him to pay an amount of rupees 3,000. Land counsel appearing for the mother submits that in fact the child is not reluctant and it is in fact it is stated by the mother or it is submitted on behalf of the mother that if they want the child to get used to the father, once he is comfortable with the father, can the overnight and other aspects can be looked into. This court had put its order and heard the arguments of the counsels on either side. Considering the same, this court is passing the following order. The father on Monday, Tuesday, Wednesday, and Thursday, on all the 4 days, can pick up the child from the can pick up the child from the mother's place at what time?
11 in the morning.
At 11 a.m. and drop him back at 4 p.m. Mother can also accompany both of them. And if any day, if for any reason on some day, if she's not in, if the mother is not able to give the visitation to the father, they shall be informed to him in advance and shall compensate him on the next week. Yes, next post after vacation.
27. Anandappa.
Lordships, submission, my lordships. The order is not to precipitate before the trial court. This is a matter of maintenance, my lordships. Still 2,90,000 maintenance was pending, my lordships. Before the trial court, they say that it.
The respondent, he is the petitioner.
Yes, I had to make submission.
Yes.
Sorry, my lordships.
May please you. See, my lord, this is an interim order has been passed by the trial court for the 6,000 for the first petition being the wife.
You're for the wife.
Oh, fine, wife. And
How much
12
is granted?
It's a 18,000 rupees.
You are seeking enhancement.
No. I'm
He's
not-
for the husband, my lordships.
Because what has happened is whatever the order was passed on 22/6/2024, my lord. From the date of application, that is 3/10/23. Now that comes to all from the application 3,24,000. As of now, as per my calculation, more than that, I have crossed it because I have taken I have made the admission fees and college fees of my child, and I have, in addition to that, I have detailed date wise. I have mentioned in my petition. I have paid whatever the arrears. I have.
Please tell the court, you know your case. I don't know the facts. What is the impugned order?
Impugned
How much
order,
is
your lordship,
awarded?
your lordship, impugned order page number 25.
Yes.
It's the operating portion.
The respondent is directed to pay
Yes,
interim
please.
maintenance
Interim
of
maintenance
6,000
per month to the
12,000 per month to petition number 2. One is who?
Wife, my
One
lordships.
is wife, second is daughter.
For daughter 12,000, wife
But-
6,000,
6,000.
total 18,000.
18,000, my lord.
What is your income?
Income is actually 46,000 as per the net salary. I am getting that. And in addition to, she is also working as a teacher and she is doing the tuition also. And in addition to that, not only that, I have personally, as per her wish, I have taken separate house for her. And here in this case, what has happened is 2023 they filed. We lived together. Only last 1.5 months, 2 months back only, she has been separated. And living together, she is claiming she claimed the maintenance. Though also I have made the maintenance, 3,31,000 I have paid more than the whatever the accumulated of the as per the order also. I have taken enter the expenses, whatever the exam fees and admission fees of the child also. I have full of the receipt. I have mentioned, I have documents also. In addition to that, my respectful submission, I am ready. We are living together and she is claiming in the court as a maintenance. And I'm making the payment also. So whatever as per the impugned order, that comes itself with 3,24,000 accumulated total from the date of petition. But I have, as per my calculation, 3,31,000, more than 3,30,000, I have made it. I have given it in writing.
Yes.
That is all that is there in the petition.
Yes.
Please.
Kindly go to in page number 19, my lordships.
Yes.
Lordships. He has admitted that his net salary, lordships. His
What do
net,
you say about the submission that both of them are living together?
my lordships,
I'm
I'll give
ready,
you
my
the
lord.
order sheet, my
I'm
lordships.
ready.
According to the order sheet itself, my lordships, it says only he has paid only 45,000, my lordships. 2 lakh, there's an, kindly go to order sheet, my lordships.
After vacation.
Date may be fixed, my lordships. Please, my lordships.
Come.
2 lakh, my lordships.
Yes,
We
next.
have paid
My
more than the
lordships,
arrear accumulation
she's
already. we
studying
have paid
PUC,
that.
my lordships. She requires, my lordships. It is at the interim maintenance, my
Oh,
lordships.
we have
For
they are living
for
together very
day-to-day
much.
living, my lordships.
Only one
Please,
and
my
a half month.
lordships.
Cell number 28,
In-
Azhar Ali Faruqi.
Interim order maintenance. Please.
Cell number 28, Azhar Ali
Leadership.
Faruqi for petitioner Fatima
Urgency
SK.
is because the matter is with respect to the vacations.
But even before he argues, I'm concerned at the way they have directly approached the High Court, my lords.
No, no,
Happened?
I have
They
challenged
have
an order.
not, my lords, may I just take your lordships
My case,
through?
may I put forth my case? That is
No, no,
all.
I'm not arguing the case. I just want to point out, my lords, the impugned order, may I just urge your lordships to take page number 43, my lords? 43, the last order under this petitioner is hereby directed to take care of the needs of this is with regards to the vacation, my lords. What happened was there are several IAs that were filed by the husband. Plus the next page 44 for objections to IA number 17, hearing on IA 14 and 15 and objections to the counterclaim.
Where is the prayer? Show the
My lords,
prayer.
14 is what they are approaching here.
The petition herein prays the pending disposal of the main petition.
I have produced the IA.
The
It
court
is
may
at,
be pleased to direct the respondent to hand over the, why should it be?
no,
Because
page
IA
number.
14 is what they are
May I put
agitating
forward-
here.
No, let me look at the main.
May I put
Main-
forth, it
main
is at
prayer.
page number 156, the application which I had filed before the family court.
2012, 2024, where is the order?
Because that is here.
That is,
That is at 43.
Respondent is hereby directed to take the minor children to the house of the petitioner at 10 a.m. and leave the house of the petitioner at 6 p.m. along with the children to her house from 23/12/2024 to 28/12/2024 for exercising visitation rights.
and may I point
Well,
out,
I'll just clarify this.
Let him say.
Yes.
my application at page number 156. It is an application for all the vacations. Now,
Correct.
for all the vacations, it is not for particularly winter vacation. It is for all the vacations. May I read the relevant portion? Page number 156, your lordship, ladyship. Page number 156. It is humbly prayed that this honorable court,
Question this order passed in 20.
reason being it has been limited to only winter vacation. And that is one is the time duration which has been limited. Secondly, I had asked for unsupervised and overnight. It has been converted to supervised and with
So now when is this petition filed?
Plus what happened
this petition.
is,
This petition.
73/2025. What are you doing from 2012 till now? Without
No,
even
it, no,
questioning that order?
it came before court twice or thrice. On that first day when it came up,
No, you filed ultimately so 17/3, I'm saying.
Yes.
After 3 months from the date of order.
yes, because my vacations, when my vacations are approaching, then I filed because
Court has so many other works. All of you realize and come to the court just before vacation seeking some
Yeah.
order or the other. It's not possible for the court to hear all these matters.
indeed,
Orders needs to be
in
have
fact,
in advance.
in fact, as soon as I got instructions, I filed it. And in fact, this is the same case, the Kevin Chandrasekhar. So there are multiple proceedings. Now.
Because your parties think that the courts have no other work but only to hear, rehear, again hear your matters.
Your ladyship, it
filed
is in
my
that light that
objections.
I have filed this petition saying that multiple applications need not be filed.
plus I'll file my objections, they have not yet filed.
My
Also,
only request-
plus IA 14 is something the court was ready to hear, but they have conveniently just, in fact, my lords, they have filed several advancement.
Where is that IA 14?
My lords,
page
I'll
number?
just, my lords, 156.
156,
I'll
that
just
is-
2 minutes, my lords, I'll just clarify.
That is what
this.
I have challenged. That order on IA number 14
page
only I have
one-
challenged.
Page 156 is the IA 14. 49/2024. Which he just said.
Yes.
This is IA 14, my lords.
Hmm.
IA 13 was for school communication. IA 16, I filed for the father to consent admission of the children. Several IAs were filed. Now, my lords, this IA 14 was for vacation. This was filed before winter vacation. The court specifically says, I will consider this application only for winter vacation. I will again take it up for the summer vacation
Nowhere is
later
it.
on.
It is not.
The court said.
No. My lords, I'm just saying that because I'll just point out, my lords. For the winter vacation as of now, since it is at the fag end, they moved the court just before winter vacation. That was 3 days before. I can produce the order sheet. The court said I'll pass the orders for winter vacation right now. And it did pass the orders and that was complied. Now IA 14 was agitated, 16 was agitated, 15, everything. They came to High Court also on IA number 13 being agreed. All that happened, my lords. Now, I may just take your lordships to the impute.
No, anyhow, without going into all that, they are entitled for the visitation during the
No,
vacation.
I'm not denying that, my lords. But how can they just bypass the family court when the court is saying, please address the arguments and they just.
Where do you get that? That's
Plus
what I'm
IA
asking
14.
you.
Plus here, order, impugned order.
Page number.
Page number 44. Ink page, my lords.
Where do you get that? Where did the court say?
Plus for objections to IA,
Objections to
IA 17, hearing on IA 14.
That is a typographical error. IA
Not
number
that-
14.
but
Just
very
madam,
sad
madam,
how
madam,
the
madam,
council can
madam,
even
madam,
lie to the court.
I'll add this, madam. This order is an order passed after due hearing on a particular application. That application is at page number, because there was no application in which I said you give me only for winter vacation. My application was 50% of all the vacations.
Anyhow, this order now anyhow it won't fall for consideration for the reason this now that vacation is already worked out. So we'll ask the trial court to decide on your winter vacation.
No, but I am barred by res judicata because I have already asked for if my IA may be looked at.
What we'll do is we'll say I'll clarify.
Yes.
Res judicata.
And for this vacation at least,
Let you go before the appropriate court. The
for,
presented
for
petition
because
is
your
filed.
ladyship, my concern is now for this vacation at least I may be given something.
The agreed with orders passed in the IA number 14. I number 14 in GNWC number 137 of 2023 dated 21st December 2024. The father is before this court. It is stated that they have sought for all the vacations but the court has decided about the vacation from 23/12/2024 to 28/12/2024, and also the visitation that is given during the vacation is not sufficient. And
Plus
counsel-
sorry, Milas, in winter vacation, it was given entire week.
No, according to you, that is also not
Unsupervised,
sufficient.
it was, yes.
Unsupervised visitation is not sufficient. Land counsel appearing for the respondent submits that, in fact, the court, when they have filed the application just before the winter vacation, court had decided the winter vacation, and for
It is not my submission.
My submission.
respondent, I said, that IA number for objections to IA number 17 and the hearing on IA numbers 14 and 15, objections to the counterclaim by 12/2/2024. And in the very same order, it is observed. It is submitted that when the court has asked them to file objections to IA number 14,
The subjections is filed already. It's already filed.
and the court is about to proceed to hear without even waiting for the order by the court, they have come before this court. Next
Your
paragraph.
Ladyship, it was after after the orders are passed on IA number 14, I came.
The court never said you are not entitled, for that itself shows. When the court has specifically mentioned about one vacation,
Yes.
had it been the case that you ask for intervacation and the court rejects it, it would be fine, it would be there in the order. And that strengthens her argument that court is yet to decide your winter application. That in the teeth of her argument only, I'll pass.
Okay,
this order.
my
In
only
fact,
another
Milords,
request is,
You are, I understood.
no, only thing is, at least it may be decided before the summer vacation starts.
This is exactly this thing, Milas. Every time, even in winter, they did the same thing.
This is what is it, every
I'm not able
every
to understand
litigant-
why they are holding the court.
Yes, every litigant, everybody wants the court like, so that the neck of the moment.
Neck
comes
of
to
the
court
moment.
And take some order or the other. This order is passed on 20/12/2024. That order is assailed before this court on 17/3/2025. This court has perused the application. Application also doesn't contain about which vacation. It only stated about the visitation during vacation, and the court had rightly considered it and granted for the visitation of the winter vacation, which was ensuing as on that time. It is submitted with the land counsel for the respondent also that the orders with regard to the summer vacation are pending. Land counsel insists that the some arrangement may be made by this court. This court is not inclined to pass any order when the court is yet to pass orders on the summer vacation, on the visitation on the summer vacation.
Your Lordship,
Hence,
there is no application where I have filed and where I have asked for.
then
It
there
is
two grounds. Then in that case also, this is not maintainable.
I am coming
If
under.
then I'll record that without even filing an application, they
Please,
will come
Milords.
here.
My contention is that this
Then
is a
the land
this is
council
a
submits that no such application is pending, and this is and
Holistic application.
And this application IA number 14 is the only application. This court has perused the affidavit application and the prayer that is sought in respect of IA number 14. They have only sought for the vacation as it was filed in the month in December. Court had considered
September.
the
I
winter
have
vacation.
filed. I have filed in September.
Huh?
I had filed in September.
September, what vacation will come?
December.
Winter vacation will
Winter
come.
vacation.
September, and the court had considered the winter vacation. As of, it is the contention of the respondent that the court will consider IA number 14 with regard to the summer vacation, and accordingly it is the contention of the petitioner that the summer vacation, the IA number, that there is no application.
IA
at
number
all.
14 is holistic application.
The application is not pending. It is for the applicant to seek an order from the court. Without seeking any order from the trial court, from the family court, he cannot come before this court under 227. If any application is pending, filed by the
Tomorrow only.
by the petitioner, the trial court shall consider the same expeditiously.
Great.
At least before the vacation.
Yes, next. This 29 after vacation?
Yes.
Suppose this matter. Huh? After vacation on 26th of June? Yes, call the other list.
List number 2.
I take complaint in this case, my lord. My
Yes.
lord, there are only two grounds in this case, my lord. There are only two grounds in this case, my lord. The appellant had occurred total percentage of disability is 36%, my lord, and 62% to the left lower limb. But the tribunal only assessed 20%, my lord. There were total 5 major injuries occurred, my lord. That is in the judgment page number.
You're seeking enhancement of the.
Blood in this case,
Yes, my
Milord,
lord.
clear, we have settled the matter for 1 lakh. We have deposited the amount. But I don't know why they have not put their signature
Say
in.
that they have already deposited the amount, 1 lakh rupees.
My lord, it was a proposal, my lord, but the injuries are grievance in nature, my lord. 5 major injuries are there, my lord. So that is the reason we didn't get approval, my lord, from the trial court advocate.
Your Lordship can.
I'm sorry for that, my lord.
It's so difficult to follow this, the virtual hearing with no
Para-
clarity of
Para
speech.
30 of the judgment.
Sorry, my lord. Personal inconvenience.
Also,
Number?
30. Nature of injury is concerned.
May I read out, my lord?
Yeah.
Madam, please you follow the proceedings.
Fracture, left distal end of ulna, trochanteric fracture, femur and patella.
Paragraph number 13 is not. Which para then?
30, 30.
30. Yes.
Left clavicle fracture,
Petition law.
left distal end of ulna, trochanteric fracture, femur and patella.
Left clavicle fracture, left distal and ulnar fracture.
Ulna, trochanteric fracture,
Left inter fracture, left commuted femur, left commuted patella fracture.
please.
How many
Doctor has assessed 33%.
How many fractures? First of all, pain and
1,
1,
2,
2,
3 and
1,
4.
5, my lord.
1, 5 fractures.
5 fractures.
How much amount under the head of pain?
1 lakh is awarded.
Then reasonable.
Correct. Medical expenses
Where
3
is,
lakh.
where is the table?
46 million.
Pain and suffering?
1 lakh.
1 lakh.
Medical expense 3,39,350. Food, conveyance, nourishment, malad.
How many days was in hospital?
20 days, malad.
Then another 10,000.
10 days, sorry. 10 days.
Total 10
Correct.
days. So 10,000. Then transport, it is 50,000
Conveyance,
is granted.
another 5,000 is granted, malad.
Loss of income during the treatment.
14,500 is the income taken.
Into 4 months we will take. Then it will be
Please.
another 29,000.
Please.
Then loss of future income due to permanent disability. What is this 2,900 into 12 into 9?
That is the amount, 33% of the disability which was taken.
No. Income is taken at 14,500.
500.
So 14,500 into 12 into what is the multiplier?
He was aged about 56 years, my lord.
$56 years. 9 into what is the disability?
33%. Here is the case, my lord, 33%.
500 into 12 into 9 into comes to 5 lakhs 16,780. What is granted?
3,12,200.
There is a lot of difference. 2 lakhs here only.
That's what.
2 lakhs here. Then loss of amenities 1 lakh reasonably
1 lakh
granted.
it is granted, my lord.
Future medical expenses 50,000 is granted. Now what
No,
we find
my lord.
is 29,000 and
Yet another
5 lakh, 1 minute, 5 lakh 16,000, 780 minus 3 lakh 13,200 is 2 lakh plus 29,000.
Yet another ground now.
Then it comes to 2 lakh 32,580.
In of the 33% future pass. Future pass.
Then it will be more.
We have
10%,
His age is
10%, 56 years.
56, 10%.
56.
So in that case, 14,500. 1450. 1450 by 15,950 into 12 into 9 into 33. It comes to 5,68,000.
Please.
458. So 5 lakh minus 3 lakh
13,200.
13,200. It comes to 2,55,258 plus 29,000. That is 2,84,258. Yes.
Yes, my lord.
Both the council submits that the insurance company is ready to pay an amount of rupees 2,84,258 about the amount that is granted by the tribunal, and they'll file a joint memo before the Lok Adalat tomorrow.
Less
Much obliged.
less 1 lakh which is already deposited.
Yes.
We have deposited the additional amount of 1 lakh that has to be
That
deducted.
That
will.
can be done. Yes, next.
Much obliged.
method.
What about this?
Appearing for appellant, my lordship. We are seeking for enhancement, my lordship. In tribunal.
3105, my lord, connected matter 8937 of 18. Your lordship has calculated and it is referred to Adalat. Maybe referred.
This also will correct.
Arising out of the same accident, my lord, claimant have prepared one appeal. Insurance company has prepared another appeal. We have lordship in that case, my lord, as per the Aadhaar card 74 years, as per the PM report 52, your lordship has taken 56 and made the calculation day before yesterday. That is a very same connected matter. So it may be posted along with 8937 before the Lok Adalat, we will close the matter. Calculation is already ready, my lord.
Calculation is there in that.
8937 of 18.
Matter before the Lok Adalat on this around 22nd, along with give that number.
8937 of 18.
Yes. Next three.
Cell number 3. Cell number 3, Prakash MH.
I'm for the appellant, your lordship.
What about this? Any calculation is done?
Please.
There's contributory negligence in this matter.
How much is, how it is apportioned
50%, your lordship.
after vacation?
Please, your lordship.
4.
Cell number 4. Cell number 4,
Please.
Latos.
Please. 70 years old, my lord.
Case of death.
It's a case of injury. It's a case of injury, my lord.
Then you will not come forward for this list after vacation. Next.
Cell number
Manjunath.
5. Manjunath Tendi.
Insurance company is on what ground?
Is a disputing the employment status, my lord. Employer and employee relationship.
Relationship.
Yes, ma'am.
Any arguable ground or just like that?
No, my lord, it's a ground, but senior will argue this matter, my lord. Kindly post it
tomorrow. Yes, next.
And serial number 6, my lord.
There's a connected matter, your lordship. I am for the claimant appeal in 8400 of 19.
No, in the, you're there on what ground?
Lordship.
No DL case, my
lord.
No DL case.
That we will hear. What about enhancement?
Enhancement, your lordship.
With the file. 6.
Your lordship, what happened is, it's a death case and he was 19 years and he was an engineering student, your lordship.
How much was the income taken?
The income taken was 8,000 per month, your lordship.
Which year is the accident?
The accident is the year of 2017.
2017. Even as per, how much is taken?
8,000.
8,000. Yes, Mr. Pradeep, even as per the table, it is 11,000.
Yes, my lord.
11,000.
11,000.
So 11,000 plus future prospects at 40%. That is 4,400. 15,400.
Your Lordship, and one more thing, loss of dependency. They've not awarded in a proper manner. The tribunal has stated.
Calculated.
They've taken a ground, Your Lordship, because the tribunal has come to a conclusion stating that mother and father were working. Based on that, the loss of.
No,
Please.
7,700
Please.
into 12 into 18 is the multiplier.
Please, Your Lordship.
12 into 18, it comes to 1,66,000, 16 lakhs, 63,200. 40, 80,000. 80 and 30,000.
17 lakh 72,200.
It comes to 17 lakhs 73,200. What we'll do is, for this file a joint memo, their appeal I'll pass order.
Please.
Then where do you get the DL part? Show it to the phone.
Our appeal. Judgment.
Lordship, para 29 of the judgment.
Para?
29.
Admitted the issuance of insurance policy, so and so. However, respondent number, the driver of Tata Ace was not having valid and as on the date of the accident, there is violation of.
Section 3 and 181.
Where do you get that?
In the para 29, in the middle of the Tata Ace big letter.
Yes, yes.
Section, subsections.
No,
Section
whether
3.
the owner is served.
Blood, yes, place expert. Yes, appeared, my lord.
Appeared?
No.
Sharath.
No, Your
Sharath,
Lordship.
yes, Gowda is appeared.
No separate investigation on behalf of the inside. The order is only in respect of MFA 5099 of 2019. The appeal is filed by the insurance company questioning the liability fastened on the, so ask on them. The present appeal is filed agreed with the orders passed MVC number, which is the MVC number?
3907 of 2017.
Dated 26 March 2019. It is submitted by the land council that the driver of the offending vehicle is not having a valid driving license. In fact, the crime is registered under section 3(1) read with 181 and 182A of the IMV Act, stating that there was no driving license. In spite of the same, the court had fixed a liability on the insurance company. There is no representation on behalf of the owner of the vehicle. Then counsel appearing for the claimant submits that the insurance company is liable to pay the compensation. This court has perused the record, having heard the counsel's peruse the record. The crime is registered as per under section 3(1) read with 181 and 192 of the IMV Act, which shows that the driver of the offending vehicle is not having the valid driving license. When once there is no driving license, the ratio laid down with the honorable apex court insurance case applies, and the insurance company shall pay the amount and record the same from the owner of the vehicle. Accordingly, the appeal of the insurance company is partly allowed, applying the partly allowed, holding that the insurance company shall pay the money and record the same from the owner of the vehicle. Accordingly, appeal is partly allowed. The amount in deposit shall be forthwith transferred. Then, in respect of MFA 8400 2019, both the parties submits that the insurance company is ready to pay an amount of rupees 17,73,200, and they will file a joint memo to this effect accordingly, and list this matter before the Lok Adalat tomorrow's date. It is not given. No, it is not there. No, nothing is there in the previous case. Yes, next.
Oblige, Your Lordship.
Yes, next.
Chair number 7.
And in this case, Pain recovery orders to, but it's case of amputation. Suresh M. Latur is the advocate.
Sir,
Calculation.
only if you are on that point, we can dispose of your appeal. His appeal here, when required, he'll hear.
That's what, if he,
You give that. And what about the owner of the vehicle he served? Please come to that particular finding.
that milk tanker lorry. The driver was charged sheeted on section 3, 181. Owner is also charged sheeted on 180.
It already require his order.
That's the reason, my lord. It has to be disposed of hearing on this. Then my appeal may be dismissed.
That's what I'm saying. Your appeal will.
7% interest is granted, my lord.
Where is that?
Interest portion, last para 9.
Only on that.
That is
Insurance
my.
company has referred this appeal stating that the tribunal had granted the compensation at 7%, which is on the higher side. This court has produced the order impugned. Generally, in all these cases, the court is granting the interest of 6%. Accordingly, the interest is reduced from 7% to 6%. The appeal is partly allowed. Amount and deposit shall be forthwith certain. First para should be there, agreed with the orders passed.
The 7.1.
Yes, then the 7.1 post for hearing in the usual course. Yes, what about 9?
Cell number 9.
It's a case
Cell
of
number
quantum.
8.
Yes, 8.
Quantum.
This is Shivanegowda.
You're questioning the quantum.
Plea.
Yeah.
Blood in this case, this is the 2012 accident, my lord.
It's a case of death or injury.
Death.
Case of death.
2012 accident.
What is the age of the claimant?
Claimant is not 38 years.
30?
38.
38. Occupation?
Coolie, my lord.
According to him, how much is earning?
My lord, 15,000 and they have.
15,000. So to any evidence?
Evidence was regarding income is concerned, they have not adduced any evidence.
So we will take 7,000. Or how much the court had taken?
12,000 taken. That is the reason I came before you.
All are served.
Please. That is the only ground I have to raise.
So we'll just calculate. So
Please.
7,000 and future prospects at 40%.
Please,
So it comes to 32,000,
please.
3,200. That is 10,000.
15 multiplier.
Huh?
15 multiplier.
200 into, no, 10,200. How many are the dependents?
5 members are there. 1/5 as
1 minute, 7,000.
they are the major sons. Our contention, they are the major son, major married daughters and sons are not entitled to get it.
Same contention. $9,800. 1/5 has to be deducted.
Please. They are the major sons. That's the reason our contention, my lord, all except the wife, all other major sons, they are entitled to love and under the consortium made.
Let us see.
Dependency is concerned, my lord, they are not entitled to
All
get.
are 22 years, 21 years, 19
Please.
years.
That's what para 48, my lord, this
Do
is
not consider that.
One-third has
That
to be
will
there.
give a finding with that
Please.
Simon judgment. 9,800 into 1 divided by 5. It comes to 1960. It comes to 7,840 into 12. What's the multiplier?
15.
15. 7,840 into 10.
38.
It comes to 14 lakhs 11,200. Then
For all 40,000.
5 into
4.
44.
2,20,000.
2 lakh 44.
44 into
we are
5,
not,
please.
so it comes to
5 lakh, 5 lakh 20.
5 into 44. It comes to 2,20,000.
20,000. 30,000 under the.
Huh?
30,000 under.
36,000.
Please.
10,000. No, you are.
Please.
36,000. 14 lakhs 11,200 plus 2 lakh 20,000. That's 36,000. It's coming to 16 lakh 67,200. On what basis the court had taken 12,000 as income?
Nothing.
Come to that.
Considering the, I think, considering the major dependent person.
No, let's look at
And
it.
The income can be fixed. 49 para.
Para?
49. Nothing has been given.
Hmm.
Even 46 also it is there, madam. He had a sufficient
PW2
sources of income.
No, PW2 got produced exhibit P17, which is a notarized copy of the list of shareholders.
No, madam. 46 men. Para 46.
Counsel for the respondent number 1 has examined PW2 at length.
He has produced RTC and he was doing an agriculture. Therefore, it can be fixed as to 12,000. That's what the observation by.
This is earning 13 to 50, but 1 from milk vending and 1,000 from the tractor.
Para 45 may kindly be seen, madam. He said that he is an agricultural. He had some receipt to, he has supplied some materials to APMC. He is owing a tractor, therefore 12,000. That is, those documents are not income.
There are documents.
No, those document does not indicate that what was his income, my lord. He says that he was doing, I am not disputing that he is not an agriculturist. But what is the income? They have not placed any document. Merely I am holding a tractor. It will not prove the income.
Exhibits are there, P12 and P13 or what?
P12, your lordship, that's what. P11 is a RTC. It is stand in the name. It is still with them only.
Agreed with the compensation awarded by the tribunal in MBC number 119 of 2014, dated 16th August 2019. This company is before this court. The claim petition is filed seeking compensation of an amount of rupees 30 lakhs, the death of the deceased and lakhs. It is a case of the claimant that the deceased was doing the agriculture work and is also having a tractor and earning an amount of rupees 12,000 to 15,000, and the court had taken 12,000 as income and awarded compensation of an amount of rupees 24 lakhs 89,200. When counsel submits the amount that is granted by the court is on the highest side. Further, the married sons cannot be considered as dependents and they are only entitled for the loss of love and affection. Next para. Though notice is served on the respondents, no wakalat is filed on their behalf. Having got the counsels on for the appellant peruse the material on record. As rightly contended by the learned counsel for the appellant. The court, without any basis, has come to the conclusion that he is earning 12,000 per month. As this is an accident of the year 2013,
please.
This court is taking 7,000 as the 7,000 as income and future prospects at 40% will come to 9,800. And as there are 5 dependents, 1/5 has to be deducted towards the
2012 lakhs.
You said 13.
No, 12.
2012, and for the 1/5 has to be deducted towards the personal expenses. His contribution to the family will be 7,840 into 12 into 50 is 14 lakh 11,200, and the head of loss of dependency. Coming to the loss of Towards consortium for 5 people, 5 into 44, 2,20,000. Funeral expenses 36,000. In all, the claimants are entitled from 16,67,200. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from 24,89,200 to 16,67,200. Any excess amount if deposited, the insurance company is at liberty to withdraw. And any amount to be deposited shall be deposited within 8 weeks. Accordingly, appeal is partly allowed. Call that.
Passed over matter. List number 3. Serial
Yes.
number 14.
We informed your leadership that the child was brought outside the registrar's office, expressed reluctance to meet with the grandmother. On being asked what the reason for that reluctance was, no reason was provided. No reason was provided. All that was said, I don't want to meet, I don't want to meet, I don't want to talk. The mother began recording the conversation.
No, that is wrong. The child was made to sit in the registrar's office chamber, and when the child ran out of the chamber, the family members pursued it and was trying to hold the child or something like that. That's when the mother came. And in fact, I was present there and I stated that we are neither going to use the recording nor are we going to. But what actually happened,
the mother to delete the recording.
this is what has
Leave
happened.
that aside.
What actually happened, my lord, what happens is when narration is made continuously on a point that it is wrong, my lord, it should not be. In fact, when the registrar came, we made the child sit there. In fact, I myself convinced the child to sit there, which I'm sure their counsel was present there. And I in fact got the mother far away from the chambers so that they will not again make a statement saying that the mother is creating a problem. They had half an hour there. They should be able to explain what exactly happened there, because I was not there, not the mother. In fact, the registrar would be the right person.
The
Also,
attempt
but I would not
for
want to make a
the father
statement on that.
and the child to interact, the attempt for the grandmother and the child to interact. All of these are taking place in the premises of this court complex, where the child is already under the strain. In fact, may I make one request? For a counsel to say these things in presence of the very child whose mind has already been influenced may not be the best. If I could request that the mother and child be asked to leave the court while these submissions are being done, at least the child be asked to leave. Because the more I say things, the more the child is turning away. I should have said this when the matter was first taken up. I apologize. I should have noticed this before. We are at the precipice of a 5-day visitation that had been consented to, that had been directed by the Honorable Supreme Court. Day 1 of that 5-day visitation has already been lost. We have tomorrow as a day visitation and the following days as a night unsupervised visitation. My only request, Your Leadership, is there is an order of the Supreme Court that says the registrar has to comply. There is an order of this Honorable Court that the parties and the registrar will comply. Let that compliance be ordered, and let the child be in the company of the father between 11 and 6, outside of the court premises, outside of the earshot and the view of the mother. My view is to be proven later, or
No, what is the order of the Supreme Court?
the order of the Supreme Court is the mother will give the child to the registrar. The reason the registrar was there is because we knew that when the child and the mother and father meet, there will always be a difference of opinion. There will always be some aggressive confrontation or the other. That is why, in fact, the senior counsel appearing for the mother had said,
Comply with it tomorrow.
I'm-
Or else we'll leave it to the Supreme Court and the action, I think you have to face all the consequences. Tomorrow, without any further arguments on this,
No.
tomorrow, let the mother leave the child with the registrar and the father will pick up and again drop as per the orders passed by the Supreme Court.
and let the registrar
Other via media is now possible.
and let the registrar be empowered to take whatever means are necessary, reasonable means necessary, to deliver the child to the father.
That is the problem. In fact, my lord, I have delivered the child.
Tell the problems, tell the court what is that you want.
My
Order has to be complied with. How it has to be complied with, you tell the court.
Yes.
Don't tell about the child psychology.
Yes, my lord.
Yes.
My only submission would be that the child will be present in the morning. The father is anyway here. We will let them have, we will not, neither the mother will be there, nor the counsels will be there, none of them. Let it happen there only. And if in case they are able to successfully, then let them take the child day after tomorrow. Let the registrar send.
You drop the child there, your
I'll
work
drop.
is done.
Yes.
And again come back at 6 o'clock
Exactly.
and take the child back. That's what
That's all.
you're asked to do by the Supreme Court. I think you don't want any other further directions from the Supreme Court.
The problem is here. I mean,
No problem.
I leave it to the court. I leave it to the court, but only one thing I would like to submit.
Now this court is not sitting on an appeal on the order of the
I
Supreme Court.
understand.
Now if this court is only.
I understand that.
This is court only looking at the implementation of it. In fact, this needs no hearing, no time on this. So tomorrow,
Today.
as per the orders passed by the Supreme Court, the mother will be dropping the child at 11 o'clock with the registrar and the registrar from there, and she'll be going.
Yes.
And and he will pick up. What
Actually today happened was we delivered the child there as ordered. The child was not ready to go. And the registrar, please, my lord. No, why I am stating this? No, why I am stating this is for one reason.
Just go there.
That cannot
Go
be,
from
madam.
there.
For the reason this, if I may be permitted, I leave it to the court. But my only submission would be that, as the order was there, today we have delivered the child there. The child was not ready to go. The registrar had a word, tried to convince from, if the order sheet is looked at, my lord, from 11 o'clock till 1:45, genuinely the registrar tried. The child is not ready to go at all. So what would be the outcome?
All of
Should
you
we
are there.
forcefully give the child?
No, where all of you are there? At that
We are
point
outside.
of time. So under your supervision, everything is going on.
Tomorrow let it not be there. But the only problem is, if the child is forcefully, the worries will come, my lord. The only issue is, my lord, if I
We
may,
will see end
if
of the day. Supreme Court
forcefully,
said something you have to
no, let there not be an order.
should have told the Supreme Court all this, that no, this is a problem.
Under the
which would
circumstances, definitely it has to be taken up, my lord. It will be taken up, my lord. I'm sure it will be taken up, because looking into what has happened today, it will be taken up. But my only point would be,
a piece of advice to your client is she cannot, she will be doing it at some cost.
indeed, my lord. But in the
As per the order passed by the Supreme Court, so no further class, this court need not clarify the order. It is submitted that as per the order passed by the Apex Court today, the visitation could not take place, and according to
the visitation has taken place, my lord.
could not take place in the true sense.
Yes.
According to the counsel appearing for the father, there is the child is not cooperating for various reasons, according to them, at the behest of the mother. According to the respondent, the father has to be more patient and more convince the girl, and then he can have the visitation. In the teeth of the order passed by the Honorable Apex Court, this court is not inclined to go into any of the aspects as ordered by the Apex Court. By 11 o'clock, the custody of the child shall be given to the registrar. She shall be left at the registrar's office, and the father will pick her up, and again he will drop the child at 6 o'clock, and the mother can pick up the child at 6 o'clock. The registrar shall make all efforts to see that the order of the Apex Court is implemented in its true sense. And what about the next day?
Next day is the same, your leadership.
Next day also same.
Next day is the same, except the only change will be, instead of dropping her back at 6 p.m., I have 2 days of overnight
Next
custody.
day, that is on 23rd.
Yes.
The order, the father again shall pick up the child from the registrar's office after dropped by the mother, and the father can take the child and have the overnight. Is it the overnight?
Yeah, it is overnight. 25th evening, I have to drop back.
25th evening I have to
overnight,
drop and he'll drop her back as per the order passed by the.
As per the order passed.
As per the order passed by the Apex Court.
25th evening.
As per the order passed by the Apex Court. List this matter when?
Sorry, your leadership. 26th is the day I have to drop her back.
Anil,
26th.
Order of the court.
Yes, 26th is
So,
to be listed.
when to be listed?
When your leadership.
I think it's better to be listed day after tomorrow.
Very well.
You know what has happened
Yes,
yesterday's.
yes.
List this matter day after tomorrow. Any kind of disobedience of the orders of the Apex Court, as well this order of this court, will be viewed very seriously. And as per the order is very clear Mother shall drop the child, shall give the custody to the registrar and leave the court.
I'm obliged.
No, only- Just one clarification,
Yes.
ma'am, just for my understanding and for the parties as well. When my lord says that any means necessary, or it's not been specifically mentioned, my lord, but it indicates to say that any means necessary. Would not that hamper the mind of the child, my
Don't
lord?
worry about it. Everybody has a responsibility.
I'm obliged.
The registrar, the mother, everybody has a responsibility.
Much obliged.
There, so and so, read the name of Mr. Kapil Dixit. Yes, sir.
Good.
Call the next case.
Cell number, case number 2, serial number 9.
Yes.
Cell number 9, N. Krishna Swamy for appellant.
All the 4 matters of insurance company appeals. On the ground,
On the ground of misrepresentation and fraud commission. Because they contended that they were third parties. They were standing in the road. But on the other hand, documents itself would indicate that they were occupants of a lorry. They are not entitled for compensation. They were gratuitous passengers. Baljit Kaur's case squarely covers. Insurer would not be liable.
case to be heard.
It has to be heard.
Yes, after vacation.
After vacation.
Then
Cell
what
number
about 10?
My lord, up to 10 is all.
What about 10? 10 also same?
Is connected matter.
Connected matter.
Huh?
Connected matter.
Yes, 11.
Cell number 11,
Yes.
Sripad V. Shastri.
Anagoda.
Please, it's a case of injury. Right, to a minor by. Minor by. That 1,70,000 was granted.
1 lakh?
70,000.
Hmm.
But the doctors assess the both bones of left leg, Mela.
No, court had granted as per that Mallikarjun's, Master Mallikarjun is applied.
Other,
Will you agree for Master Mallikarjun or you will be asking for the other?
if the Justice Sanjay Gowda judgment, we need to wait, Mela. Otherwise, via media, if he is agree, Mela, I am ready to.
What we'll do is, we'll refer it. Please tell Mr. Shastri.
Please.
It is submitted that the matter may be referred to the Lok Adalat. This is before the Lok Adalat tomorrow. Tell him.
Please, Mela, I will. 12
Next 12.
Cell number 12,
What about this?
PC Shivanya Gowda.
1999.
Huh?
MSc, MFA number 1999. It's a case of death, Mela.
Yes.
The date of accident 17/7/2017.
15/7.
17/7/2017. 44. Disease was 44 years. 14 multipliers applied. Wife.
What's the multiplier?
14 Mela.
14. Income, how much is taken?
6,000 is taken, Mela. No future.
Then what is wrong in it? Their appeal is not there, I think.
Oh, their appeal only.
It is my appeal.
It is not my appeal.
What we have done is 12. 6,000, then we have to take 11,000.
11,000. And
Age is
25%
future prospects. 1 minute.
please.
It comes to 2750.
Please.
That is 13,750. How many are the dependents?
5 dependents. 5 dependents.
5. So 1/5 or 1/4?
1/4.
Huh?
1/5. 1/4.
1/4. 1 divided by. It comes to 3,437.
17,32,500.
13,750 is 10,312 into 12. What is the multiplier?
14 now.
14. It comes to 17 lakhs, 32,500. You said 5 people.
Yes, ma'am.
So 2 lakhs
Please. 1 lakh is granted.
and 30,000
Please.
plus 2,30,000. It comes to how much?
19 lakh 62,500.
19 lakhs, 34,000.
No.
500. 32,500.
19 lakh 62,500.
Sorry, 62,500. Yes. So joint memo tomorrow.
Please.
Is submitted to the insurance company is ready to
As-
pay an amount of rupees 19 lakh 62,000.
As against the award, madam.
As against the award at 6% interest.
Okay.
And it is submitted that they will file a joint memo before the Lok Adalat tomorrow. Take this.
But serial number 12 is concerned.
That's what I was saying.
Serial number 12 is concerned that there is a appeal by the claimant which is pending before the division bench. Therefore,
12
cannot-
adjourned. This is 13.
13, madam.
Yeah, that's what I was asking. That is your
I'm
appeal
sorry,
and yes, next.
Till number,
Tomorrow. Yes, next. 14.
number 14.
14, case of injury.
Appellant, my lordship. I would like to submit 2 points, my lordship. My lordship, without discussing the details of the
Don't worry. We will make the calculation. If what you want to submit is not covered in that, you can submit.
That para 9 of the judgment may kind of this. Nature of injury.
Where is the table?
Para,
my lordship, page
oh, that malad injury. There are 7 injuries in it. Para 9 of the judgment.
So pain and suffering.
50,000 is granted.
How many are the injuries?
7 injuries are there. Please kindly see the para 7.
I saw hemorrhage, light clavicle fracture,
please.
fracture of right neck of
No,
femur.
no, please.
So how much?
No medical evidence was adduced.
Huh?
No medical evidence. No doctor was examined.
Another 50,000.
Please.
Loss of amenities.
30.
Because no disability is assessed, how are you entitled? You have to examine the doctor, is it not?
My lordship, that's why, my lordship, at the time of, without examination of the doctor, they are considered only 50,000.
No, that is your responsibility to examine the doctor. If you don't examine, there can't be any disability, no amenities. Next, how many days he was in hospital?
He was at the hospital for 7 days, I think.
How can it be with these many injuries? Look at it properly.
20 days.
Court itself has granted 15. It must be more than that.
Your lordship can consider in this another.
The 15. Medical already granted. Then loss of income during the later period will consider.
Was not granted where we can grant some amount.
Loss of income during later period.
16 is the accident.
16 into 4, 16 is 9,500.
Please.
Into 4, how much? 38,000.
38,000.
Then
there is no other aid to grant.
so now what is it?
Lordship.
50,000. 50,000. Here another 15,000. 65,000. 65,000 plus 38,000. That would be the enhancement.
1,03,000
Hmm.
plus interest.
1,03,000. It is submitted that the insurance company is ready to settle ready to pay an amount of rupees 1,03,000 above the awarded amount of 3,80,000, and they'll file a joint memo in this regard. Same Lok Adalat tomorrow.
Till number 15. This is Shivanya Yoda.
Please.
Anjula Tejasvi.
Negligence and quantum.
What is this?
Negligence. Negligence is the main point. Is the main point.
And
That
what about
is-
the quantum? Quantum is not in question.
Quantum is not on the higher side. Correct.
So what do you say that you are not responsible? Your vehicle is not in, the driver is not negligent.
No. Charge sheet was filed against them, my lord. And the FIR is also against them. Without considering that, my lord, no eyewitness was examined.
Charge sheet and FIR is against the claimant. We'll see
The
this.
other vehicle.
Huh?
There is another vehicle.
Yes, business matter after vacation. Yes, 16.
Till number
What about
16?
16?
Please. Invalid DL. Liability, negligence and quantum.
Liability?
Till extract, my lord, he was having a driving license, but he was driving a heavy goods vehicle. For that, he is not having a driving license.
What is the driving license is having?
In this case, what has happened, my lord, the evidence was adduced. At that point of time, we have not secured the DL extract. After the judgment, my lord, we received that. We filed a review petition before the court. Without considering that, my lord, court has rejected our review petition. Therefore, it has to remand to the tribunal.
After vacation?
Till
Yes.
number 17 adjourned. Till number 18,
What about this?
Rajaram.
Do you have any? 18 and 18.1?
Oh my.
What is
Quantum.
after vacation? Then 19?
Till number 19,
R. Shashidhara?
R. Shashidhara. 19.
Yes, Mr. Sivanagowda, what about this?
Negligence is the passenger in two ground we have. Passenger in a goods vehicle.
No, 19 is not your case. Shashidhara is appearing.
No. My appeal is also connected.
Oh, 19.1. We are questioning the liability.
Please, passenger in a goods vehicle, risk is not covered under the policy.
This also after vacation 20?
Till number 20,
That is connected to that man.
Okay, then 20, then 21?
till number 21.
Yes,
6
Pradeep.
months for it.
P. Hegde.
One more appeal is there, my lord, which is filed by B. Pradeep, my lord. That number 676 of 2021. They have challenged liability.
On the ground?
On the ground, my lord, there are two vehicles involved in the accident, my lord. One is lorry, one is bus. Deceased was traveling in the bus, my lord.
After vacation?
Please.
Then 23?
Till number 23, 22. 22,
22.
Raghu R.
Ready.
Who appears? Pradeep.
Pradeep and
Enhancement?
yes, madam.
50% negligence against the Sriram General Insurance, 25 against United India and 25 against KSRTC.
Then you all are, he is not bothered. No, you can't file a joint memo.
Judicial order.
Judicial order is.
Yes, what is the enhancement?
Well,
What we do is, we'll do the calculation, we'll post it tomorrow and then I'll dictate all.
Yes.
Come to that.
Date of accident is 13/7/2018.
2000, now pain and suffering, how many are the injuries?
Three fractures, my lord. Right side bimalar fracture, right side medial malleus fracture, and left fibula fracture, my lord.
3 fractures are there.
How much?
And
80,000?
Pain and suffering 20,000.
20,000 kotiara.
80.
That's 60,000.
Yes. Then, how many days he was in hospital?
13 days, my lord.
13 days.
13.
So 13,000 for nourishment and all.
20,000 as of the.
How much is awarded?
20,000 nourishment,
Then
20,000
let it be.
traveling allowance, 40,000 as granted.
Then it's already on the higher side.
Yes.
Let it be.
Attendance charges 3,900.
And then
Loss of income during treatment period 3,900 is given, my lord. 3 months maybe. 12,000.
which year is?
2018, my lord.
How much it should be?
12,500, my lord. 2018.
12,000?
500.
So 12,500 into 3.
38,500.
30?
38,500.
38,500. Then
Disability taken 20%, my lord. Income taken 9%. It may
medical
be
expenses, 1 minute. Medical expenses,
as per the medical expenses.
1,78,946. Then what about, there is no disability?
20% disability taken, my lord. 9,000 income taken.
So the loss of future income,
12,500 into 20%.
12,500 into 12 into
13 multiplier 50 years, my lord.
13 into disability,
3,90,000.
20%, my lord. I'll take it.
20. How much?
3,90,000.
3,19,000. Then
The later period 37,500.
37,000.
37,500.
So how much?
Amenities
then?
not given, my lord.
Huh?
Amenities not given.
Amenities, yes. 30,000.
Next jobless.
Legal expenses, 10,000. How much it comes to? It comes to 6,75,446.
ಜಾಸ್ತಿ
7,12,846.
ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
7,12,846.
Oh, yeah, got to 6,75,446. Pain and suffering 40,000. Traveling and attendance charges 40,000.
Pain and suffering 60 total.
Huh?
60,000 total.
Total I have taken. 60 I have given.
Yes, madam.
Traveling attendant 40,000 court already has granted.
Yes, madam.
43,900 incidental expenses.
Oh, 43,900.
900.
Oh, 900. So another 1,900 will increase.
1,78,946 medical expenses.
Yes. Loss of income during the laid up period 37,500.
30,000 loss of amenities.
30,000. Legal expenses
10,000
10.
legal expenses.
Medical expenses 1,78,000. Loss of future income 3,19,000.
1,78,946.
946, yes. I think that it's not something. 43,900 is the incidental. 47,500 plus 1,78,946.
Correct, my lord. 7,12,946.
Still it is coming for me, it is 6,79,346.
Probably my lord, it was not added there. 40,000 or 43,000. 40,000, 30,000 amenities and 10,000, 40,000. Some of the head is missing, my lordship.
What is that?
Some of the head, my lordship, was not calculated.
No. Let me calculate again. 60,000 plus 43,900 plus 37,500 plus 1,78,946 plus 3,19,000
75,000 ಬರುತ್ತೆ ಕಣೋ.
plus 30,000 plus 10,000, 40,000.
40,000.
Still it is coming 6,79,346.
For my calculation, it comes to 7,75,000 total.
How can it be?
One by one.
No, Mr. Pradeep, I'll just tell you calculate 60,000 pain and suffering.
Yes, my lord.
43,900 incidental expenses. Then 37,500 loss of income.
Yes, my lord.
1,78,946 that is medical expenses. 3,19,000 loss of future income.
3,90,000. 90.
Oh, that's the difference. 90.
90.
So how much it is coming?
And amenities
And
30.
continue. Another 40,000 amenities and legal expenses.
Yes, my lord. It comes to 7,75,000.
7,75,000.
7,75,446, sir. ಇದು ನೋಡಿ ಇಷ್ಟೇ. ತಪ್ಪರ್ದು ಇಲ್ಲ ಇಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ. Plus 60,000.
So it comes to 7,50,346.
7,75,000.
No, 7,50,346.
Correct.
Because it is what Pradeep is also calculating, it is correct. 7,50,346. Tomorrow, heard the counsels in part. This is matter tomorrow. Pin this calculation.
So number 20. 23.
Yes. No name, the branch manager, Royal Sundaram General Insurance.
Ravi Samprati is appealing, liability is under challenge, no employer.
After vacation. Next 24.
Till number 24.
Appellant, my lord. Lord, this is a ECA matter, my lord. Trial court has taken 8,000 income, my lord. Accident in the year 2018.
Should we?
No scope for enhancement. 8,000 was the maximum cap, my lord.
Yes, my.
As for the present petition is filed seeking, give the file. The present petition is filed seeking enhancement of the compensation. Agreed with orders passed in ECA number 5 of 2019 dated 30th August 2019. The tribunal had considered the income at 8,000. And granted the compensation of an amount of rupees 8,90,480 along with interest at 12% per annum from 29/10/2018 till its realization. And counsel appearing for the claimant submits that the accident had happened in the year
18, my lord.
2018 and the court had taken only 8,000. The income should have been taken
15,000 we claim.
15,000 as claimed by the claimant, and it is submitted that the compensation that is awarded is not just and reasonable. Land counsel appearing for the respondent insurance company submits that basing on the notification and as the minimum wages were rightly taken at 8,000 and granted the compensation and no grounds are made out for enhancement. Having heard the counsel's finding the said perusal material non-record, this court do not find any reasons to accept the contention of the land counsel for the appellant that the amount has to be taken at 15,000 and as for the notification it is 8,000 and no other material is placed before the court. Court had rightly taken the income and granted the compensation accordingly. This court finds no reasons to interfere. Dismissed.
Till number 25. Tankaj K.
What about this, Mr.
14 years old boy.
It's also will adjourn then. Adjourn. List this matter for final hearing in the due course. Yes. What about this fruit?
26.
Spurti Hegde. Pradeep.
My lord, on last date of pre-conciliation, my lord, 25/6/2024, we settled 5,75,000, my lord. But till today, they have not replied to that.
Yes, Pradeep. Tomorrow then?
Tomorrow.
It is
Please, I'll
submitted.
cross check
that,
once, my lord, I will submit.
according to the claimant on the last
Reconciliation.
they were ready for an amount of rupees
5,75,000.
75,000, but the insurance company has not come up with a joint has not come up with the said proposal.
Please,
List this matter tomorrow before the Lok Adalat for filing a joint memo.
please.
Yes.
Till number 27.
For appellant, my lord, contributory negligence is in challenge.
After vacation, next
Till number
28.
28.
Yes, Mr. Krishnaswamy.
28.
He left. Oh, he's here.
Driving license to driver of lorry.
No driving license. And the other matters are for enhancement.
Other
No,
matter.
this Harish Bandare Kalyanar, appearing for whom? For enhancement.
Harish Pendari for claimant appeal, I think. Appeal and file.
Ultimately, pay and recovery order may have to be passed in my.
No, about the enhancement, other matters are also there.
They are not possible.
Like, let's list these matters tomorrow, till 30.
Tomorrow. No?
I pay for respondent case, my lord, 30.
Mistake,
Till 28.
one
No,
mistake
it
is
is only 28 and 28.1 are connected. Give that. Please come to that liability aspect. What we do is, we'll dispose of your matter and their matter for the joint memo after calculation.
after cap.
So, where is your liability issue?
My liability issue is at
29.
para 26, page 26.
No,
Very
29. Insurance policy was valid as on the date of the accident. Respondents with the Therefore, the respondent number two has to pay the compensation as incident and it can recover the same. Already pay and recover is ordered.
There is an order of payment.
Against the
Joint
respondent
claims
number one. But now it cannot escape from the liability, hence the respondent liable to with interest. Hence the respondents are liable to.
Proceed against respondent number one for recovery. That is what is there. I have challenged the very order of pay and recovery when there is no driving license.
No, the petition is awarded compensation of with interest.
Like
Severally liable to pay the compensation. No, here pay and recover is not ordered, though it is said so in the, when you look at the penultimate, the operative
para
portion.
28, page 28, last. However, the respondent number two can proceed against respondent number one for recovery of amount so paid, award to the petitioner at the appropriate stage with the due process of law.
What is that?
I don't know. In fact, forensics case would indicate that in the very same proceedings, in filing an execution petition, I can recover it. To that extent, modification.
If you come to the order doesn't even say so. No, it says, however, the respondent number two can proceed against respondent number one for recovery of the amount so paid under award to the petitioner at the appropriate stage with due process of law. Ultimately, the order is pay and recover.
Pay and recover.
That's it. It is there. So we'll dismiss your petition.
My appeal has to go because of pay and recovery order.
Already. So now please come to the compensation. Where is the table?
My lord, the total compensation.
Pain and
My
agony,
lord,
15,000.
appeal memo, in my appeal memo.
So it is there at page
synopsis.
23.
Pain and suffering. He had the swelling and contusion over right eyebrow. My lord,
Pain,
injuries,
swelling and contusion on the right eyebrow.
pain
Pain,
and
swelling on the right hand.
tenderness swelling on posterior aspect of right shoulder.
Tenderness, swelling and deformity of the right
28-year-old
elbow.
person, Mason.
Contusion of the right
4,500
shoulder.
taken for 2011.
Reputed fracture of right ulna. 2 fractures. You see at 6, page number, internal page 10 of the judgment. There are 2 fractures. So, pain and suffering.
Comminuted fracture of ulna at the distal end and
2 fractures are there.
fracture of
60,000.
typhoid process.
Then medical expenses 50,000.
Medical expenses, nourishment, food and conveyance, attendant charges. All
Also-
inclusive 50,000 is granted.
No, then for that we have to see how many are the medical expenses and how many are the other expenses.
My lord, 38,300.
38,000
38,101 was the medical
was the
bills.
medical bills. That means 50,000 is granted is 11,000, 12,000 is granted. How many days he was in hospital? He has specifically said the patient 26/4 to 3/5. 26/4 to 3/5. That means
3/5.
that is
4
right.
plus 3, 7 days.
Granted medical expenses plus incident. Then loss of, what is the evidence of the doctor with regard to disability?
My lord,
Loss of amenities. 40% permanent disability to the right elbow.
14%.
14% to the right elbow.
Right hand and elbow.
Right hand and elbow.
That is so quota taken how much?
My lord would get it at page 11 on these.
Quota taken
He has
9%
assessed
as
the
a
permanent disability of 14%.
Which year is the accident?
My lord, the accident took place
2012.
12, 4,500 is
7,000.
11, I'm sorry, 11.
2000?
11.
11 is 6,500. Loss of future remedy 6,500 into 12. What is the multiplier? 17.
My lord, 28-year-old, 17.
17. Quote had taken 9%. 9 by 100. It comes to 1,19,340. Loss of amenities. How much is granted? 10,000, we'll grant another 10,000, 20,000. Then loss of income during laid-up period,
That would also get enhanced.
6,500 into 3. It comes to 19,500. Future medical expenses,
10,000.
another 10,000.
50,000. In the future.
So all are covered. Plus 1,19,340 less 20,000 plus 50,000 plus 60,000. It comes to 2,88,840 against 1,77,620.
620.
This appeal, it is submitted that the insurance company is ready to pay an amount of rupees 2,88,840 against the awarded amount of 1,77,620. The joint memo shall be filed before the Lok Adalat tomorrow. Then coming to take this, then no, give that. Take that calculation. Then coming to MFA. MFA crop 52 of 2015.
52.
It is submitted and MFA crop, they will file a joint memo. MFA number 5396 of 2014. It is submitted, agreed by the orders passed in so and so, so and so. The insurance company is before this court. And counsel appearing for the insurance company submits that the court had fixed the liability. The court, the insurance company has no liability to pay the compensation as the driver of the offending vehicle is not having a valid driving license. And driving license. Next, this court has perused the order passed by the tribunal, wherein the tribunal has already granted, has applied the theory, the principle of pay and recover, and has held that the insurance company is liable to pay the compensation, as rightly observed by the court. The claimant is a third party to the insurance policy, and the insurance company is liable to pay and can recover the same from the owner of the vehicle. In that view of the matter, this court finds no reasons to interfere. Accordingly, the appeal filed by the claimant is, the appeal filed by the insurance company is dismissed.
One submission, man. Serial number 6
Also
is
shall be forth to transfer.
serial number 6 is disposed of.
Serial number?
Serial number 6 is disposed of. That is connected with serial number 52. Similar order could be passed.
52.
6 is connected with
52. What order is passed in 6?
Pay and recovery order. My colleague was. It is an injury case.
That is the, your 6 52 same order. 52.
52.
Next.
Dismissed.
Then what about 29? 29 after vacation. 29 and 30 after vacation.
My lord, 30 appear for the respondent in this case, my lord. It's only a no DL case. Pay and recovery order should
It will not happen now after vacation. Yes, next. 31.
Till number 31.
Yes, Pradeep.
Guru Prasad wants tomorrow, my lord. Guru Prasad.
Wants it tomorrow. Yes, 32.
Till number 32.
What about this?
32.
Mr. Shantaraj after vacation.
Shantaraj after.
After vacation. Next,
Till number
33.
33.
What about this, Pradeep? MFA 3835.
It's only enhancement.
Yes.
Date of accident is 5/10/2014.
Right. Case of injury.
Case of injury.
Where is the table?
Table.
Fracture of right femur, fracture of right foot, fracture to right knee, grievous injury to right hand, head injury on right side. There are so many MBs. What is this wound certificate? So many things are pain and suffering.
Fracture of right femur, madam, and fracture of right
No,
foot.
there is so, where do you get that?
In the judgment, it is not forthcoming.
No.
In a-
Look at, there are so many.
Pain and suffering, my lord, in page number
PW1 being the injured in this evidence, point number 2.
17, page number 17.
Page number 17.
In pain and suffering, there is a discussion with regard to the fractures.
The injured in this evidence is sustained fracture of right femur, right knee and grievous injury to right hand. That's what I read.
Please,
And head injury, there are about 4 or 5.
but fractures are 3, madam. Knee fracture, femur fracture.
Head injury is.
Head injury is there, my lord, but head injury is not severe. There is no fracture to head injury.
Fracture of femur, right foot, right knee.
The fracture
Right
of
hand.
fracture shaft of right femur is there.
No, you get it exactly at page number 12, internal page 12. Fracture of right femur, fracture right foot, fracture to right knee, grievous injury to right hand, head injury on right side.
Please, my lord, but head
Four
injury.
or still 4. One.
50,000, 80,000.
Then loss of income. How much was considered income?
Income led 17,000 per month as considered. Security guard in the disability assessed at 19% to the whole body, the same has been considered.
How much is the salary according to him?
17,000.
Court had taken the same. So loss of income for rightly.
Future earnings, my lord, 5,81,400.
Medical expenses, nil. Loss of future. Then where he'll be getting only here enhancement.
And attendance charges
No, I
30,000.
think in
32
pain
days.
and suffering will grant 1 lakh.
32 days he was inpatient.
Loss. So that means he's getting 50,000 here. Then loss of amenities. What is the disability?
Disability 19% of the whole body.
50,000 is fine. Then what about conveyance, food and nourishment?
Food nourishment conveyance, my lord.
35 days.
30,000.
35 days.
32 days.
No, it is coupled with amenities. So what we do is that 30,000 we consider for amenities.
Please.
We grant another 35,000. Then future medical expenses also another 10,000. 15,000 is granted. Another 10,000. So 50, 35. 1 lakh. Pradeep will say 1 lakh. Land council appearing with the insurance company submits that they are ready to pay. They are ready to pay compensation of an amount of rupees 1 lakh over and above the amount that was awarded. A joint memo shall be filed tomorrow.
Serial number 34.
Yes, 34.
34.
Yes.
R. Raghu.
Page number 106 of the judgment, my lord.
50-50 negligence. 60-40.
Contributory negligence is there.
Contributory negligence. Reliance General Insurance
Reliance and
Company.
2 companies are there, my lord. One first company is 60% and another company
That
40.
is not that. Then this also order on the judicial side. This is for enhancement.
Yes, my lord. Page number 106 of the judgment, my lord. Para 83.
Or not?
103 of the judgment. 106 of the judgment, my lord.
Pain and suffering, how much is granted?
My lord, she is aged about 10 years, my lord. Minor girl. That is in para page number 130, my lord. Bifurcation is 130.
130. What is this judgment? Is it something?
Connected matter, my lord.
Huh?
Connected matters.
Oh, so many pages.
All the cases are settled apart from the case.
Because of that,
They
my
have
lord, she
settled the
has
case, all 7 cases before the.
Pain and suffering, where is the table?
130, page number 130, my lord.
130.
My lord, she is aged about 10 years, my lord. She has get multiple fractures.
Want that matter, we are different it.
If he is agreement, why am
If you are agreed, then it's fine.
Otherwise,
Then we will.
court has taken matter of Mallikarjun and granted the compensation, my lord, but I asking you.
In addition,
higher
my
That's
lord,
what, if you want the income to be taken as per the table or otherwise, then we are differing it.
35% has taken disability, my lord. 4 lakh is awarded on the disability.
my lord, in addition to what has been granted, 1,50,000 may be granted, my lord.
More, some more, my lord, because she is getting 35% disability and both like
2 lakhs.
2 lakhs.
It is submitted
Lump
to the
sum.
insurance company.
Lump
is,
sum, interest.
Insurance
Interest, my
company
lord.
is ready to pay an
Because of
amount
that,
of 2 lakhs above the, above what has been, over and above the amount that is awarded by the tribunal for filing a joint memo tomorrow.
Interest,
Yes.
with interest,
Huh?
with interest, with interest.